With the podcast you should hear. Andrew Branca's name, the self-defense pioneer. He knows the law, the ins and outs. He'll take away your fears. His expertise is unmatched. It's crystal clear. The law of self-defense. This book that you must read. 5 elements laid out. He's got all you need. From innocence to eminence, he'll break it down for you. Andrew Branca, he's the voice that rings true. Andrew Branca, the self-defense guru. He's got the knowledge, the skills, he'll fight for you. Andrew Branca, the master of the law. When it comes to self-defense, he's the one you should call.
Bam! Good morning, everybody. Good morning. So, welcome back to the Law of Self-Defense. I am, of course, Attorney Andrew Branca for the Law of Self-Defense, and we're back to talk about, to cover the murder trial of Nicolae Miu, the Apple River tubing trial. Testimony is over. Jury instructions were argued out yesterday afternoon. And today we should expect closing arguments, final instructions to the jury, and deliberations to begin. Yesterday was not a good day for the defense. At least the end of the day was not good. Of course, yesterday the defendant, Nicolae Miu, testified, took the witness stand, was subject to cross-examination. I thought he did well under the circumstances. Not perfect, but good enough that it was worth having him take the stand. But the jury instructions are terrible for the defense. First of all, the state kind of ambushed the defense with lesser included offenses, reckless killing charges, which I think are ridiculous on the facts of this case. Miu has been charged throughout the entire trial. They've been arguing about intentional killing, that he killed one person, Isaac Shuman, and attempted to kill 4 others by stabbing them intentionally. And his legal defense to that charge is self-defense. Yes, I did. I stabbed them intentionally, but I did it with the legal justification of self-defense. Self-defense is a defense of confession and avoidance. You're confessing to the underlying conduct. You're not saying it wasn't me. I wasn't there. I had an alibi. You're saying it was me. I did it. I shot that guy. I stabbed that guy. But I did it with the legal justification of self-defense. So even though I'm conceding to the conduct, I'm confessing to the conduct, I should nevertheless not have legal liability because of the justification of self-defense. Recklessness is completely different mens rea, state of mind. With recklessness, you're not intentionally causing harm to someone. The example would be a drunk driving homicide, for example. You go to a bar, you get drunk, you get behind the wheel of your car to drive home. You're not intending to kill anybody. You're just intending to get home. But what you are doing is you're engaged in reckless conduct. Recklessness is when you create an unjustified risk of death to others, and you intentionally ignore that risk, which is what you're doing when you get behind the wheel drunk. And then someone dies as a result. Yeah, I'll get to the court. Don't worry about it. We're going to have a lot of delays today, so I'll be just kind of playing catch up as we go along. Recklessness is completely different. You didn't intend. Who believes that Nicolae Miu did not intend to stab each of these people? There's no evidence of that anywhere in this trial. And recklessness has been allowed by this judge to be defined broadly to apply to the entire scope of conduct. The entire scope, not just the stabbings, but it just refers to acts generally. This opens the door to the state arguing, as they've been arguing all trial, that there was other things that Nicolae Miu that was reckless. Like, why'd he bring a pocket knife to the river? Why didn't he walk away earlier when the boys were yelling at him? Why did he decide to look for the cell phone when his friend said, you don't have to look for the cell phone? None of that is relevant to the stabbings. None of that is part of his decision-making on whether to stab these people. But it opens the door for the state to argue, well, you know, when he got out of bed this morning, why did he bring broken shoes to the river? Wasn't that reckless of him? And so it provides a lot of opportunities to the jurors to come back with a guilty verdict when there ought to be no guilty verdict. The legal question here ought to be very narrowly defined. When he was stabbing those people, because those are the charges, murder by stabbing, attempted murder by stabbing, when he was stabbing them, was that conduct legally justified? Or I guess now, was it reckless? I don't see how it could be reckless, given that it was intentional. But nevertheless, the judge allowed it in. And the danger for the defense is now that if you have a juror that just kind of emotionally feels that something ought to be done, a young man was killed and 4 people were stabbed, we can't just let this person walk out of court with nothing, that you've provided a path to an unjust conviction, not based on law and evidence, but based on emotion. So bad jury instructions for the defense. The defense has had a very good trial, and the state's had a very bad trial. But the state got very favorable jury instructions, and the defense got very bad jury instructions. The jury instructions are 29 pages, and the judge kept saying during the jury instruction argument yesterday afternoon, well, this is a correct statement of the law, and technically, I suppose it is. The difficulty is the judge is a legal technician. The jury's not. The jury needs more guidance. And now that we've added these lesser included charges in, so we already had 6 charges, right? 1 murder, 4 attempted murder, 5 charges, and then the battery on Madison Cohen, the claimed battery. Now for each of the stabbings, we also have 2 degrees of reckless for each of them. So now we have 29 pages of jury instructions that the jury is expected to work through, a lay jury, one of whom's 90. So I've heard that this morning, the first thing that happened is the state investigator, the guy with the frosted hair, Schultz, who sits at the prosecutor's table throughout the trial, that he apparently observed one of the jurors falling asleep yesterday during testimony. And so the state's going to move to exclude that juror. I believe they were unsuccessful, but we'll start with that. But before I dive into that, let's start with the formal launch of today's show. Also, today's show is brought to you by none other than Law of Self-Defense itself in the form of our upcoming Law of Self-Defense Advanced class, Saturday, April 20th. This class is taught live by me, streamed to you at your computer. It teaches you everything you need to know to be hard to convict if you're ever compelled to use force in defense of yourself, your family, your property. Nicolae Miu would have been well served to have taken this class and followed its teachings before he got on that tube the morning of July 30th, 2022. He would not now be in court looking at a life sentence in prison, plus many more years on top of that. We only teach this class twice a year, folks. So if you miss this April class, it'll be at least October before we do it again. Do you know when you'll need this knowledge? Do you know when you'll be attacked? It's not up to you, just like it wasn't up to Nicolae Miu. The bad guy chooses the time, place, and manner of attack. You need this information on board before that happens. Saturday, April 20th, lawofselfdefense.com/advanced for more information and to register. And by the way, if you have a conflict on Saturday the 20th, I would encourage you to sign up anyway, because we'll be making the playback version of the class available to all the registered students for 2 weeks after the live class, so you can watch it at your leisure over that 2-week period. And this week, we're still in the early registration period, so you get 50% off your registration, up to 50% off, again, at lawofselfdefense.com/advanced. All right. So let's go ahead and start with today's trial proceedings. Whoops. Let's try that again.
So single sentence paragraph.
Whoops.
It is removed. Anything else from the state?
Not on jury instructions.
Mr. Nelson?
No, Judge.
Okay. So I'll have the instructions finalized. My intent is to read before you argue. I'll also have the instructions displayed on the monitors so the jury can follow along. The jury will be provided with a few copies of the printed instructions in the deliberation room for their reference. Mr. Anderson, at sidebar, you said you had a motion to make?
Yes, Judge, I have a motion to strike one of the jurors. It was brought to my attention yesterday that during portions of testimony yesterday, one of the jurors was sleeping for an extended period of time and to the point of nodding off and then jerking awake. Both sides have a right to a fair trial, which includes juries that are attentive. I'm looking at Wisconsin Supreme Court case, State v. Novi, 346, Wisconsin 2nd, 289. It could, if there's a conviction, the defense could also try to argue that it violated defendant's right to fair trial.
No jury in the room right now.
So obviously we want jurors who are paying attention to the evidence. So it's a two-step inquiry. One, it's a fact determination whether the juror was actually inattentive to the point of potentially undermining the fairness of the trial. And two, whether there's why this is the appellate review standard, if there's prejudice as a result.
Which juror?
4021.
Yeah, I think I will skip past this. Looks like it's going to be drawn out and boring. Let's see, jury instructions. Keep in mind, folks, with the closing arguments that the state goes first, then the defense, and then the state gets a rebuttal. So the last words the jury hears is from the state. You know, it's really bothersome that they don't stand up. Okay, here we go.
Thank you, Judge.
Arguments of the attorney. Everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. We've now reached the stage where the attorneys will deliver their closing arguments. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. First, we'll hear from Mr. Anderson. When he's done, we'll take a short break. After that, we'll hear from Mr. Shirafisi, and then Mr. Anderson will be permitted to give a short rebuttal. Mr. Anderson.
Thank you, Judge. Absolutely senseless and horrific acts of violence. And all Nicolae Miu had to do was walk away. All he had to do was walk away. That's what you've seen in this case. You saw he told Lieutenant Hart, "They told me I can't run away." Obviously not true. Think about the result of his actions. Everything you've seen in this trial, the horrific injuries, the death of Isaac. Why didn't he just walk away? His only explanation when testifying was, "I stood my ground. I stood my ground." First of all, Wisconsin is not a stand your ground state.
Objection. Overruled.
I'll talk about that specifically from your jury instructions. Second, that's not true, as I'll show you. He didn't just stand his ground. I'm not going to defend the actions of the boys who testified. It was cruel what they were calling Nicolae. They shouldn't have been mocking him, calling him predator, raper. But their conduct did not justify what Nicolae did. You heard from Alina, Isaac's mother, about her son Isaac. He was 17 years old when he was killed. He enjoyed golfing, spending time with friends. He recently started a new business, detailing cars. He was an honor student looking forward to going to college. His death was senseless. One of the things defense said in the beginning of trial in their opening was they're glad there's a video. So are we. Without the video, Nicolae would have slipped away. The only reason he was apprehended was because law enforcement had that screenshot of him. The video doesn't fade with time. It's not biased, not influenced by alcohol. As I told you in the beginning of this case, the violent episode from the video is about 25 seconds, from the point he punches Madison until you see him walking off after stabbing 5 people. He's not seen, Nicolae is not seen in that video for 8 to 9 seconds until the point you see him walking away. You don't see him stab Dante. Some of you may have wondered why we called Marion Davis. Certainly it wasn't for his eyewitness testimony, but he took a video. He took a video that captured a different angle than Juwan's video. It's grainy, it's difficult to see, but you can see enough. And it shows Nicolae seeking Dante out and stabbing him when his group is in the opposite direction. Nicolae walks into a crowd of people, stabs Dante. Before I show you that video again, I need to provide some context from Juwan's video.
Take it off.
Clear the screen, please. So here at 2 minutes and 6 seconds, this is after Nicolae has stabbed the 4 people that you do see parts of on the video. He's standing next to Ariel. Ariel's there. Nicolae's not by himself. Two minutes, 8 seconds. That's the last you'll see of Nicolae until you see him walking off in this video. You see Dante or AJ, the boys running back to their tubes, and you see Larian filming in the background. Larian captured what Nicolae was doing at this point, even though this video didn't. And here, in a moment, you can see the edge of Dante's swim trunks on the right. You can see the light on top, the dark on bottom. At this point in Larian's video, Dante's just been stabbed. The next you see of Nicolae, he's walking off. You can see Dante in the background, holding his stomach, looking down at his wound. Take it down. Well, actually, you can keep it up for a second, sorry. And then for further context, you see Alex Bang running to Isaac. Let's see Larian's video. Okay, I have the screen. Remember, Nicolae admitted he walked up to he walked up to Dante and stabbed him. He admitted Dante was the last person he stabbed. Here you can see Nicolae, dark swim trunks, bigger build. On the right, you can see Dante, swim trunks, lighter on top, darker on bottom. You'll see Nicolae walk up to Dante and stab
I mean, this is the best evidence.
him in the chest. You'll see Dante recoil from the stab. You see the boys on the right running to their tubes. And in the second here, you'll see Alex bang. You'll zoom in on him as he runs to Isaac. I'm going to show that again. So, a few things to note. There's nothing between Nicolae and Larian. He's not surrounded. His friend Ariel is there at this point. There's nothing to the left and behind Nicolae, except his group in the distance that you can't see on video. He walks away from those directions towards a group of people and stabs Dante in the chest, not standing his ground. He's seeking out Dante. That's retribution, not self-defense.
The state will take any guilty verdict. It'll be life in prison for this guy, no matter what they find him guilty of, really.
And recall, too, the DNA results. Isaac's DNA and Dante's DNA was the only DNA on the knife. They're also the last two that are stabbed. It makes sense from how the analyst described DNA and how it can wash off. You probably noticed throughout this trial, not a lot of witnesses come off looking great after they testify. There's some exceptions. Obviously, the Good Samaritans who went to aid Isaac and AJ. Eric Von Williams included in that from Nicolae's group. He's the only one who went to their aid. Sheena Lowell, you heard her testify from the Carlson group. You saw her just standing in the background watching what was going on the whole time. She was completely sober. You heard her testify, Nicolae punched Madison. She has zero connection with the group anymore, zero contact. Her and Quentin broke up. Tony is another one. He only comes in to break up what he thinks is a fist fight. He's directing Nicolae towards Nicolae's group. Nicolae turns and stabs him twice. Another one I submit to is an exception that acted admirably is Isaac. His death was tragic and horrific. This is what you see of Isaac in the video. On the left, he's standing next to his tube, not moving away from his tube. He's pointing at Nicolae to leave. In the middle, when Nicolae turns back to Isaac, Isaac puts his hands up, fingers splayed. The only other thing you see of Isaac is him standing in the background. When the other boys are mocking, calling names to Nicolae, Isaac is just standing in the background. He's not saying anything. He's not doing anything. He's not jeering. He's just standing there holding their tubes. There's been a pretty serious mischaracterization of Isaac's actions with regard to when he gets stabbed. Defense has tried to classify it as a strangulation. Defense accused the state in openings of being selective in the photos we used, the frames, to try to show a certain narrative about Nicolae smiling. As you've seen, he's smiling a lot in the video. But defense is actually doing that when it comes to Isaac. Nicolae never said anything about being choked, never said anything about pain on his neck. Even when specifically asked by the SART nurse, never mentions anything. And the video doesn't lie. So on the left, Nicolae has just stabbed Riley, who you heard from multiple witnesses, were just standing there. Tony comes to try to break it up. Nicolae stabs him twice. Isaac, just off frame, I submit to you, he just saw Nicolae stab those two people completely unprovoked. Although he was in the background the whole time, not doing anything, he came to their aid. And he pushes Nicolae. You can clearly see it's a push. He has one hand on the arm, other hand on the chest. It's Nicolae's own action of thrusting the knife into Isaac's heart that moves Isaac's hands. You can even see from the release, it's a push. He's not sitting there left holding his hands out in a choking motion. Let me take the screen down.
Yes.
I'm going to show you the video so you can see it's obviously a push. While my computer is loading here, even if it was a strangulation, which it clearly isn't, Isaac was justified in using any level of force. He just saw Nicolae stab two people who posed no threat to Nicolae. Tony was breaking up the fight. He had actually ignored Nicolae at first, walked past him, pushed Dante out of the way. Riley was just standing there. I'm at 2 minutes and 3 seconds. Can we have the screen? Clearly a push. Defense has mischaracterized the entire situation as 13-on-1, 13-on-1, implying it's some sort of mob beating up Nicolae. It's not even 13 people yelling at Nicolae. As you saw in the video, Gabby, Janelle, they're just standing in the background. Isaac, he's just standing in the background, not yelling anything. It's 13 people in the proximity, only 2 close to him, 2 tiny females. Nicolae's clearly not afraid of the boys. He ran up on the boys, turns his back on them and others multiple times. Even at worst, this is a 2-on-1 with AJ and Dante. But even then, as you saw in the video, Ariel's right there. So it's more like a 2-on-2. Ariel's right there. Plus, Tony comes in as a neutral party to separate things. It's not 13-on-1. As soon as AJ gets disemboweled, you see people start to move away. So there's not even 13 people immediately around. You saw Owen way in the background because he saw the knife. So why try to mischaracterize the situation? Because there's some things that are hard to explain otherwise for defense. Turn on the screen, please. This is the second time you saw in the video that Nicolae turns his back on the boys and people from the Carlson group. You don't turn your back on somebody. It's common sense. You don't check your common sense at the door when you serve as a jury. You don't turn your back on somebody if you're afraid of them, especially if you're so afraid you got to reach for your knife. You can't be that afraid that he's got to reach for his knife and so unafraid that he turns his back on them. He was angry, not afraid. That image on the right is only less than 30 seconds after he turns his back on them, touching his knife. The defense tried to explain that change from in that 30-second window by saying he was getting pushed by Madison and Riley. He was getting pushed. They're lightly touching his arms, and they're tiny. They're not in his face. You can see in the images, they're standing close. They're not in his face. They're not shaking their fists at him. They're not even sticking their fingers in his face. They're standing close to him, touching his shoulders, pointing, yelling at him to leave. I'm going to back up a little bit and talk about Nicolae looking for the phone. So Eric Von Williams from Nicolae's group, you heard testify, before any of this happened, he was concerned about Nicolae's behavior. He was concerned that people were going to think he was a predator. Ernesto told Nicolae not to go look for the phone. Others in the group told him not to. You heard they didn't care about the phone. Ariel didn't care about the phone. Nicolae went. Sandy said he went twice, was back for 5 to 10 minutes, then went again over by the boys. Defense argued in opening that the boys' goal, their goal was to humiliate Nicolae. Clearly, he wasn't looking for little girls. But the boys are not completely unreasonable in their belief. Eric Von Williams thought the same thing. They reacted wrong, but they just didn't invent this whole thing in order to humiliate Nicolae. What about Nicolae? 52 years old, apparently sober, according to, I think, what defense will argue. He didn't have any signs of intoxication when law enforcement made contact with him, but he certainly made a point of telling Lieutenant Hart multiple times how much he was losing and drinking on the river. He can't let it go that he was insulted. So much so that as the boys are tubing away from him, all Nicolae has to do is stand there. He doesn't even have to take a step back. He just has to stand there, let the boys continue tubing. They're down in their tubes. He starts walking up to them, touches his knife, and then runs up to them. You heard Nicolae's ridiculous description or explanation for why he ran up on the boys. Because one was holding a phone, he thought it was Ariel's phone. You also heard Nicolae had to concede, had to admit that pretty much everyone on the river had those phone cases. Another double standard from defense is physical attributes of those involved. They wanted to elicit evidence that Nicolae is feeble. Sandy, he wasn't feeble according to Sandy. He had a surgery a couple years ago, recovered in a few weeks. Maybe things took him a little longer than they did before. He wasn't feeble according to Ernesto. You heard Ernesto, when he was being asked about the stabbing, said, he's a big guy, he was in the Army, he doesn't need a knife to defend himself. He didn't say, oh, he's this fragile old guy. He's clearly not feeble, as you see in the video. He runs up on these boys in the water. He leaves behind devastating, devastating injuries. Slices clean through 2 of Isaac's ribs. He comes out of the whole event essentially uninjured. While defense tries to argue that Nicolae is this feeble old man, they ignore that the only 2 people actually standing close to Nicolae are these 2 females that are barely over 100 pounds. If the boys are a threat, why does Nicolae run up on them? And clearly he knows they're not a threat to him. When he ran up on them, grabbed their tubes, standing over them, they did nothing. They didn't kick up at him, they didn't punch at him, they jumped out of their tubes and moved away from him. He knows they're not a threat to him. They're mocking, saying cruel things, but not violent.
Note that the state's conflating all different time points in this, as if it was all kind of one moment in time. When Nicolae runs up on the boys, he's not afraid of them. He's also not stabbing them. He's not using any force against them. But the state has to conflate because otherwise they don't have a coherent narrative.
You saw how awkward it was for Nicolae to try to explain this transition from 0 fear to 10 out of 10 fear. He's got to take out his knife. Try to explain it with what I submit to you is obviously rehearsed testimony about his scales of fear. You heard from witnesses recounting what they recall of Nicolae, the demonic look on his face, staring through people, smirking. Defense argued in opening, it's a slide to or here there. You know, after seeing the video so many times, that's not the case. When he's not glaring, he's smirking in the video. Recall, I asked Ernesto, his best friend, when he was trying to describe the shock of Nicolae, I asked, was he smiling? He didn't say, yeah, he smiles when he's scared. He smiles when he's nervous. He said, who's going to smile in a situation where they're in shock or in fear? Nicolae was angry. He wasn't afraid. He's smirking even as he's holding the knife. Why didn't he just walk away? Defense tried to argue there's rocks on the stable, his sandals were bad, didn't stop him from running up to the boys as they're tubing away from him. Why didn't he just hold the knife up? Say, hey, I've got a knife, back up. You saw, Owen is the only person who saw the knife and you saw his reaction. So everyone else is moving forward and respond to Nicolae punching Madison. Owen's trying to pull people back. Next you see him, he's off in the distance. This whole thing would have ended if Nicolae just held up the knife. Instead of opening it down by his waist without looking down, because it's human nature, if he would have looked down, people would have looked down. He holds it down by his waist, opens it up, never displays it, or says he has a knife. Nicolae did not act as any reasonable person would in that situation if they were truly in fear of their life or great bodily harm. So let's talk. Here's Owen reacting, as you see. Again, Isaac just standing in the background in the middle. You see when other people are moving forward, Owen's trying to pull them back. You heard him yell, bro, he's got a knife. So let's talk about the punch to Madison. I submit to you the evidence shows clearly, beyond a reasonable doubt, Nicolae punched her. She fell backwards, but caught herself. Multiple witnesses testified to seeing her falling backwards. Defense is saying, arguing on cross, well, she's not wet. She didn't actually fall down. If witnesses are all standing in that kind of semicircle around Nicolae, she gets punched and falls backwards, and then their attention's back to Nicolae because Dante's hitting him. They're not going to see that she caught herself. They're going to think she fell down. Look at her position next to Riley. They're shoulder to shoulder in front of Nicolae before the camera pans away. When the camera pans back, now Dante's shoulder to shoulder with Riley, and Maddie is back. She clearly got knocked backwards. Her sunglasses aren't on her head anymore. Defense has a double standard about that too. If there's not a photo of it, it didn't happen. If there's not a photo of an injury, it didn't happen. We know Nicolae got punched. He didn't have any injury. Defense can't have it both ways. So turn and talk a little bit about memory, credibility. Obviously, a witness's memory is better closer to the event. That's obvious. Alcohol is going to affect memory. Traumatic events going to affect memory. How fast it happens is going to affect memory. But crucially, and absolutely crucially, there's a huge difference between getting some details wrong, right hand, left hand, sequence of events, and making up an entire story like Nicolae did. Defense has tried to highlight throughout the trial, Nicolae was in this traumatic experience, give him a break. It's understandable, he made up all these lies, told this whole story. Even though he looks calm and collected in the videos, he's convincing in the videos, talking to the sheriff, talking to Lieutenant Hart. But don't give any sort of credence to the theory that trauma affects memory for anyone in the Carlson's group, any of the boys, any who were stabbed, any who had to drag Isaac as he's bleeding to death to the shore, AJ, who's disemboweled don't give any credence that trauma might affect their memory and how accurately they can remember all the details. But Nicolae, who invented an entire story, tried to skip through the crowd. Give him credence for that. You saw what happened to all these witnesses, how fast it happened. It's not surprising. Some of the details are wrong. But the major point is accurate, is consistent. This all started when Nicolae punched Madison, whether it was the right hand or left hand. You heard the turmoil of the boys when they realized Isaac is stabbed. Clearly a traumatic experience. There's a big difference between details and invention. Think about the most basic example. You and, say, your partner go to the grocery store. Park your car, you're leaving the grocery store. You think your car's parked over there. They think it's parked over here. You still know the car's parked in the parking lot, even if you can't remember where it's parked. The same is true for the punch to Madison. You heard from 10 people, both from the Carlson group and the boys group, that Nicolae struck Madison. So let's talk a little bit about witnesses from Nicolae's group. Ariel, what did he say? At trial, he says Nick defended himself. Can't really say how. Never said that when interviewed with law enforcement. He denied even being close to Nicolae. Remember, Ariel was there when he stabbed Dante. He was right there when Nicolae stabbed Riley, Tony, and Isaac. Law enforcement went there with the frame of Ariel standing next to Nicolae when Nicolae has the bloody knife. Ariel denies seeing anything to law enforcement of what Nicolae did. Ernesto, at trial, testified he didn't see Nicolae get hit, just saw him down in the water. Said he couldn't remember Nicolae saying, "They took my knife." You saw on the body cam, he said that repeatedly. He testified that somebody was walking towards him, he pointed at him, "Get back." Never said that to law enforcement, although he did describe to law enforcement, as you saw, him saying, "Nicolae, get out," Nicolae walking out, and then he said, "And that's it." Never said anything about anyone pointing at him and walking towards him. When I asked, he said, "I wasn't asked that question." But he described that event. He also wasn't asked more than 10 times if Nicolae said, "They took my knife." So, about the punch to Madison again. Sergio, he's in Nicolae's group. He had walked out a little ways. You can see him in the photo on the left, in the top right. He had the white shirt, white bucket hat. He testified he saw the blonde girl in the black leotard walk over to Nicolae and say, "Go, go, go." He said it repeatedly to law enforcement. And he said Nicolae pushed her. So this is what it would have looked like from his perspective, although a lot farther back in that photo on the right. How could he have seen Nicolae do anything to Madison unless she got pushed back, punched back, something violent, not some light push? He's not going to see that from where he was. Madison testified, and you saw in the video, after she was hit, she goes back to her group. Why would she walk away back to her group if Nicolae just lightly maybe touched her, maybe didn't? She told Quentin she was punched. She told police at the scene she was punched. She told police in the interview she was punched. She testified about feeling the throbbing pain in her cheek, her heartbeat in her cheek. Maddie testified she was told by law enforcement, sheriff's office, they didn't need the photo. You heard about that misunderstanding. She had anxiety about deleting the photo. In an effort to console her, she was told, "Don't worry about This is an important jury instruction in your jury instructions. Although we're not a stand your ground state, there's also not a duty to retreat. But in determining whether Nicolae's actions, whether his use of force was reasonable to prevent or terminate the interference, you may consider whether he had the opportunity to retreat with safety, whether such retreat was feasible, and whether he knew of the opportunity. He turned his back on them multiple times facing open water. People were yelling at him to leave, to walk away, to go, and he didn't.
Again, the prosecutor's conflating different points in time. When he turns his back on them, he's also not stabbing anybody.
Instead, he took out his knife. That is not reasonable. You heard from Sheena Lowell, Janelle Duxbury, Ghazi Khazri and Nazimpour, Dante Carlson, and AJ about the strike to Madison. You heard from the boys, Ryan Nelson, Juwan Cockfield, Landon Wire, and Alex Bang. Alex Bang originally described it as slap. You heard from Owen that he heard an impact and saw Madison fall back and catch herself. Defense has to argue that they're all either lying or mistaken. All these witnesses, including Sergio. If they're lying, why would Quentin say, I saw some swelling and some slight redness, but didn't see the punch? Why wouldn't he just say, yeah, I saw the punch too? Why wouldn't Tony say he saw the punch? Why wouldn't Tony say he saw Riley get stabbed and she's just standing there? They tried to explain what happened as best they could remember. The punch isn't on video, but you see the reaction. You hear Dante yell, you can't hit a woman before Riley is stabbed. They obviously didn't plan this lie in the chaos of the moment. So the only thing defense can argue is they're mistaken. That all of these people standing around Nicolae in that half circle, proximate shape, they're all looking in that direction, including Sergio, including Sheena, who was by the group, the tubes for the Carlson group. They all were wrong in what they saw. Another defense double standard, it's relatively minor, but I submit to you it shows that they're grasping at straws, is this trying to put Nicolae's group in a different category. There's the drunks on the Apple River, then there's Nicolae's group. About half of you raised your hand that you've been on the Apple River. That's what people do on the Apple River. They go out, they tube, and they drink. Nicolae was in the exact same boat they were in. He wasn't bird watching and this group of drunk teenagers ran up on him. He knew what it's about. He'd been on the river before. Another thing about the punch to Madison, you heard that they didn't get to see the video before giving their statements. Even Juwan, who took the video, said he got far enough to get the screenshot of Nicolae, and then law enforcement took his phone. He didn't get to see the video. You saw what happens in this case if somebody lies about something that happened on video, because Nicolae got burned by that. He made up complete and total lies. Video showed he wasn't telling the truth. The video happens to not show the punch, but it still corroborates what all those witnesses said. So count 6 is battery to Madison Coleman. It has 4 elements. Nicolae caused the battery to Maddie, or caused the injury, the harm, the pain. She testified to that. He intended to cause the harm despite his denial. I submit to you that's clear. You don't punch somebody without intending to cause harm. She didn't consent. She testified to that. He knew she didn't consent. She's a stranger. Obviously, she didn't consent. We knew that. Punching Madison was not self-defense. Again, there's no duty to retreat, but you have to consider the opportunity to retreat, the knowledge of the opportunity to retreat, and whether the use of force was necessary in preventing the unlawful or the interference in Nicolae's person. So what is the interference at the time he punches Madison? The boys are saying cruel things to him. Maddie and Riley are standing in front of him, lightly touching his shoulders. People are pointing and laughing at the boys. They're not, Maddie and Riley aren't in his face. They're standing close, but they're not in his face. What amount of force was necessary to prevent that interference? People yelling at him, Maddie and Riley standing close. What amount of force was necessary? Absolutely zero. Just walk away. That's what people are yelling at him to do, just walk away. Instead, he takes out his knife and punches Madison. Regardless of whether you were convinced beyond a reasonable doubt it was a punch, Nicolae essentially admitted to pushing her. Sergio said it was a push, although when asked, he couldn't remember if it was a push or a punch. There's still provocation. Your jury instructions talk about provocation and how that affects self-defense. A person may not use or threaten force intended or likely to cause death unless he or she reasonably believes he or she has exhausted every other reasonable means to escape or otherwise avoid death or great bodily harm. Remember, Nicolae ran up on these boys who were tubing away. They didn't run up on him. He ran up on them as they're tubing away from him because they insulted him. He was angry. He didn't walk away from the boys to leave the situation. He went over to Maddie, who was yelling at him to leave, and he lies to her and says, "They took my snorkel." I'm going to play that for you so you can hear it.
I'll go over the jury instructions in more detail during the break, folks.
All right, this is at 105 in the video. I'm ready.
Go, kids, go! Go! Go, kids, go! Go! It doesn't, go, kids, go! Go! It doesn't matter.
You didn't, you can take it down. He didn't go over there to extricate himself from the situation. He went over there and accused the boys of taking the snorkel, which was a lie. And he had just ran up on the boys.
Was he stabbing anybody? How deceptive was that to loop loop the video?
After he runs up on the boys as they're tubing away, he goes and tells Maddie they took my snorkel. He's standing there smirking at people, takes out his knife, either punches or pushes Maddie. That's provocation. Defense has zero reasonable argument, especially when it comes to Tony, Riley, Isaac, and Dante. Nicolae gets punched. He gets struck with an open hand twice. He gets ineffectually pushed by AJ. It doesn't do anything. Nicolae pops right up and disembowels AJ. After Nicolae goes down in the water, nobody approaches him. Nobody. Nobody goes to kick him. Nobody goes to punch him. Nobody goes to push him again. Tony, with Nicolae down on the ground, Tony walks by Nicolae with his back to Nicolae, yelling, "Get back to Dante." He turns around to tell Nicolae to get away, and Nicolae turns around and stabs him. Nicolae was facing his group with an open path of escape after provoking a reaction. He just stabbed Riley before stabbing Tony. After stabbing those two, he stabs Isaac. After that, after Ariel's there, he walks over to Dante, stabs Dante in the chest, right below his ribs, right below his heart. So self-defense. I submit to you the state has proven beyond a reasonable doubt this was not justified self-defense, and Nicolae knew it. He knew it from the moment he did it. First of all, Imminent threat of death or great bodily harm. He's not in an alley with no way out, with people blocking his exit. He's on an open river, 150 feet wide, people yelling at him to get away. None of them are armed. Punch, 2 open hand strikes, ineffectual push. Look at the definition of great bodily harm, whether he reasonably believes death or great bodily harm is imminent. For attempted first-degree homicide for Dante, AJ, Tony, and Riley, the state has to prove that he intended to kill each of them. And the acts demonstrate unequivocally, under all circumstances, that he had formed the intent and would have caused the death of each of them, except for the intervention of some other person and an extraneous factor. Third, the defendant not actually believed that the force used was necessary to prevent death, imminent death, or great bodily harm. So for the intent to kill, but for outside circumstances. AJ, it's beyond clear. He would have died but for the blood in the helicopter. He would have died but not for the surgery Dr. Meyer performed. He is lucky, extremely lucky to be alive. What else was Nicolae's intent but to kill when he slices him up like that? He had the knife blade up. That wasn't an accident. He didn't not know. The first thing he does with it is slice up AJ's stomach. Riley, he slashes across the ribs. You saw the horrific nature of those wounds. He cut into her stomach, cut into her diaphragm. Luckily, he didn't hit any major arteries or her heart or lung. Tony blocked one stab, so Nicolae stabbed him again. The one he blocked, you saw the injury, was very close to where AJ's artery was severed. Dante was stabbed again, just below his heart. But for Nicolae missing vital organs, but for medical intervention. Miu claimed he had tunnel vision. Oh, sorry, back up. So Dr. Meyer also testified, you heard about anytime there's a puncture wound in the torso, the stomach, they have to go in because there's so many major veins, arteries, organs. They have to go in to make sure something major isn't done. Nicolae killed Isaac, almost killed AJ. Riley needed emergency surgery. Luckily, but for dumb luck, he missed the vital organs of Dante. But for AJ blocking one strike and missing vital organs, he survived. Nicolae said he had tunnel vision. I thought everyone close to me was attacking me. I thought anyone who touched me was attacking me. He didn't stab Ariel, and Ariel came up. Makes the tunnel vision claim a little bit unconvincing. For first-degree intentional homicide of Isaac Shuman, Nicolae stabbed him so hard and cut clean through 2 ribs. The wound was deeper than it was wide. He sliced Isaac's heart. There's no other intent when you stab somebody directly in the heart than to kill. An intent to kill doesn't need to be planned ahead of time. Your jury instructions talk about that. It doesn't have to be formed a week, a month, a day, even a minute in advance. As long as he had that intent when he does the act, that's intentional homicide. The first element is he caused Isaac's death. That's obvious. Acted with intent to kill. I've addressed that. Did not actually believe the force was necessary to prevent imminent death or great bodily harm. I'm going to get to that in a little bit for all the counts. Third element, he did not reasonably believe the force was necessary. That also goes to, that's part of the third element. So how do we know, what Nicolae believed? What a reasonable person would believe? That there's only one person on the planet who experienced what Nicolae experienced, saw what he saw, was standing in his place. And what did Nicolae believe? He believed it was unjustified. The very first thing he does is walk away. Doesn't run. Doesn't tell Ariel or Nestle anything. doesn't tell them to run. He walks away from his group to the other side of the river. At some point, rinses the knife because it wasn't covered in blood. Throws the knife onto the bank before walking back to his group. Says nothing to his group other than they took my knife. Puts on his hat, sunglasses, and shirt, and sits down on his tee. He's the one, as he said in his interview, says, let's go, let's get out of here. They can't right away because Eric isn't there. You saw, and as they're tubing down the river, you saw the video of him casually paddling along. You saw, so plan one, get away. Slink away with the crowd. That didn't work. Plan two, play down. Can you take the screen down, please? Okay.
Camera recording started.
Still doing all right?
Yeah.
Okay.
What's going
Temperature's okay in here?
Yeah.
Okay.
Somebody, I hear somebody got stabbed, and I fit the description.
Yes, you do.
All right.
Yep. So we're working through that now. Did you see that fight on the river?
I heard about it.
You heard about it?
Yeah, and I seen people gather around it.
Okay. All right.
And I went over to talk to see if somebody saw anything, but that's about it.
Okay.
Our whole group was pretty interested in finding out what happened.
Okay. And that's your whole group over there?
Yeah.
Okay. All right.
So I don't know. Okay, well,
Did you see anybody injured?
no.
You didn't see anybody injured?
No.
Did you see anybody fighting?
I heard people screaming at each other, yes.
Okay.
Yeah.
Screaming in anger or screaming in pain? Do you know?
Everybody's drunk, so I don't know. I can't tell the difference, but I would say, I don't know, just screaming.
Okay.
You know, yeah, calling each other names, but, you know, that's, seen that all day. And we've all been drinking a lot. I'm sure they're drunk. I'm sure they're doing, I don't know,
Okay.
kids
All right.
being kids.
Kids being kids. Where are you? Where's your group from? Where did you drive from today?
Sure, they're drunk, kids being kids. That's what he told Sheriff Knudsen, and he's acting like he has no idea what's going on. Clearly not in shock. You can take it down, sorry. Clearly not in shock. Clearly Nicolae knows that was not justified, and he's looking out for Nicolae. Slinking away didn't work. Playing dumb didn't work. He's told he's under arrest for homicide. Plan 3. Completely lie about what happened as to justify him using lethal force. The boys pulled out the knives. They twisted their arm, poked him. That's what he used, poke, with their own knife. So first degree intentional homicide and second degree intentional homicide are very similar. For first degree, did Nicolae actually believe? Did he actually believe that he was not justified? For second degree, it's the reasonable person standard. I submit to you, it doesn't make a difference in this case. It's crystal clear. He knew he wasn't justified. He knew he wasn't justified. It's crystal clear from his actions after the fact. Can't be explained away by shock. He's clearly not in shock. The use of force on AJ, stabbing Riley just standing there, stabbing Tony trying to break it up, stabbing Isaac directly in the heart. Ariel's there, walking up to Dante and stabbing him. The injuries he left behind, that all shows his intent. Again, you have to consider whether he knew he could retreat, whether there was a safe escape. He could have just walked away. He could have just raised his knife. He didn't do any of that. He just stood there with the knife until he punched Madison. He touched his knife when running up on the before running up on the boys. He takes out the knife, opens the blade up, never says anything, never walks away, never takes a step back, never raises the knife, never yells for help. He's smirking with the knife in his hand. Finally, after stabbing 5 people, then he walks away. Doesn't run, walks. It's shocking to see what Nicolae did in this case, to see the injuries, and then see his calm, cool demeanor after the fact, tubing down the river, sitting in his tube at the scene with chaos, casually talking to Sheriff Knudsen, making up this huge lie to Lieutenant Hart. He even lied to the SART nurse at 9 p.m., so 5 hours after the incident, about the boy pulling a knife, twisting his arm, poking him with his own knife. He even lied to Sandy after the arrest. Nick recognizes that what happened is not justified self-defense. Just standing there with the knife, not walking away when he clearly can. So even to Sandy, after he's charged, he casts blame on her and the group for not hearing him yelling. He never yelled. Normally, it'd be difficult to know what a defendant believed in a self-defense case, not in this case. Nicolae was not in fear, he snapped. He was angry and he snapped, and he knew it. His actions show he knew he did not reasonably believe the amount of force was necessary. He was not actually in fear. If he was actually in fear, he would have left. How else? Do you know what other clues? Think about his testimony. We submit to you that this is first-degree intentional homicide and first-degree attempted homicide. His acts clearly show intent. But if you can't agree unanimously on that, as your jury instructions tell you, you have to consider second degree. Again, the difference in second degree is Nicolae's belief versus reasonable person. Here you know, I submit to you his belief from his own conduct. Afterwards, he knew it was not justified. If you can't agree on second degree, you consider first degree reckless homicide, first degree reckless endanger of safety. Element 1, Nicolae endangered the safety of another human being. That's obvious. Endangered the safety of another by criminally reckless conduct. The jury instructions define criminally reckless conduct, creating a risk of death or great bodily harm. It's unreasonable and substantial. He was aware of the risk. Again, obvious when he's stabbing people. When you talk about reckless conduct, let's say you believe his testimony that he just thought anyone touching him, anyone close to him was attacking him and just stabbing him. That's reckless. That's criminally reckless conduct. That's utter disregard for human life. What other clues are there utter disregard? He just walks away. He just walks away. He doesn't call 911. He just sits on his tube as other people are helping the victims, and he tubes down the river. Your jury instructions talk about the question, the special question, yes or no. Did he commit these crimes while possessing a dangerous weapon, the pocket knife? There's nothing inherently wrong with carrying a pocket knife. A lot of people carry pocket knives. Totally fine to carry it as a tool, totally fine to carry it for self-defense, totally fine to carry any legal weapon, firearm, knife, if it's used legally. Nicolae he was not justified in self-defense when he attacked these people. So we ask that you answer yes on that question. In the end, what is beyond clear, Nicolae knew this was not self-defense. All of his actions, from the minute the stabbings are done, from the second the stabbings are done, he knew it. It's obvious. His actions were horrific. They were senseless. He killed Isaac Shuman, stabbed him directly in the heart, disemboweled AJ, stabbed Tony who's trying to break up a fight, Riley who's just standing there, and then walks up to Dante. That walking up to Dante, stabbing him when he's got clear paths to retreat, that destroys any argument that this was self-defense. He was angry. There's no rational reason Nicolae, his group's over here, would walk this way towards the group of people to stab Dante. Senseless and horrific acts. The state asks that you find Nicolae Miu guilty of all charges. Thank you.
All the charges. Some of them are alternative charges.
Thank you. We will take a 10-minute recess. We'll be reconvening at 11:05.
So, for those of you outraged by the state's misrepresentation of evidence, conflating time points, playing video on loop, so it sounds like it's more than it is, they're allowed to do all of that. The only time the defense objected was when the state says Wisconsin is not a stand your ground state. That's just I would say that's a mischaracterization, but there's really three categories of states when it comes to the element of avoidance in self-defense. There's duty to retreat states, where they say right there in the self-defense statute, you have a legal duty to retreat if safely possible before you can use deadly force in self-defense. And if you don't do that, you lose self-defense. Those are the duty to retreat states. There's only 11 of those. They are Connecticut, Delaware, Hawaii, Maine, Maryland, Massachusetts, Minnesota, Nebraska, New Jersey, New York, and Rhode Island. And the number keeps dropping. So years ago, it was more. In the last 10 or 15 years, a bunch of states have gone from duty to retreat to stand your ground. No state's gone the other way. No state has become a duty to retreat state in my 33-year career. Only states have moved the other way. When you're talking about stand your ground, when I'm talking about stand your ground, I mean there is no legal duty to retreat. And in that context, Wisconsin is a stand your ground state. The jury instruction says, right there is no duty to retreat. It's the first sentence in jury instruction 810 on the matter of retreat. But there are two flavors of stand your ground states. All the stand your ground states have no legal duty to retreat, like Wisconsin. Most of the stand your ground states, however, also include this other language, that the jury can consider the issue of retreat if they believe the defendant had a reasonable opportunity to retreat. I call that soft stand your ground, because although there's no legal duty, it's not an absolute requirement, the prosecution is allowed to argue to the jury that a safe avenue of retreat was available, a reasonable person would have taken advantage of it, and therefore the defendant's use of force was unreasonable. It's kind of a flanking attack on the element of avoidance, even though there's no legal duty to retreat. So there's 39 stand your ground states. There are, let's see, 1, 2, 3, 4, 5, 6, 7. There are 7 of those stand your ground states that are hard stand your ground states. In those hard stand your ground states, the jury is explicitly told you are not allowed to consider the possibility of retreat in evaluating the reasonableness of self-defense. So in the hard stand your ground states, and they are Colorado, Louisiana, Mississippi, Ohio, Texas, Utah, and Washington, the issue of retreat is completely off the table in otherwise lawful cases of self-defense. But that's only 7. Now, interestingly enough, Wisconsin could be characterized as a hard stand your ground state, but only in the context of your home. So if you defend yourself in your home, then Wisconsin jurors are told they're not allowed to consider the possibility of retreat. And this would be an application of what's known as the Castle Doctrine. If you're defending yourself in your home, even if you would have an obligation to retreat outside the home, you're relieved of that duty if you're defending yourself inside your home. But outside of your home, as here on the river, Wisconsin is a soft stand your ground state. So the prosecutor takes this jury instruction and says, well, we're a soft stand your ground state, so I'm going to say we're not a stand your ground state. It's semantics. The point is there's no legal duty to retreat here. On the issue of provocation. So let me see here. I have on the issue of provocation, let me pull this up. So this is Jamon's cell phone video. And so they're trying to say, the state's trying to say this is provocation here. When he runs up, grabs the tubes. He's provoking the confrontation. The trouble for the state is that while it's true, and here's the jury instruction on provocation, a person who engages in unlawful conduct of a type likely to provoke others to attack and who does provoke an attack is not allowed to use or threaten force in self-defense against that attack. But there is no attack provoked here when he runs up on the boys. Further, the same jury instruction says a person who provokes an attack may regain the right to use self-defense if they in good faith withdraw from the conflict. Well, what happens here? He runs up to the tubes. He says he stumbles. But even if you believe that he commits a battery here, that he's intentionally causing offensive conduct to these boys' legs, what does he do after that? He walks away. There's no more aggressive conduct here. There he says he's looking for his goggles. That's credible. But he walks down the river. So he's withdrawn from the conflict. So the whole touching of the tubes is completely irrelevant for the rest of the fight. Then they say he provoked the fight maybe by punching Madison Cone. But who touches who? Here he is talking to Madison Cone, and this is slowed down. He's not touching her. He's not touching her. He's not touching her. He's not touching her. He's still not touching her. He's surrounded now. Are there people all around him? Raised hands. There's Riley. Whoop, there's the punch. I'm going to try to catch it here. There. Who's touching who first before the punch? That's Madison touching him. Riley also touches him. Right there. That's all before the punch. So he doesn't touch them unprovoked. They're committing battery on him. They're not allowed to touch him. Just like the prosecutor said, well, he's not allowed to touch Madison Cone. They're touching him. He's allowed to raise his hands. He's allowed to push their arms away. He's allowed to create space, use force to create space when they're touching. Plus, even if you believe that he punches her, we get to this point. So they say you can't hit a girl, and they punch him into the ground. So let's pretend that he maliciously punched Madison Cone for no good reason. That would privilege this guy to use non-deadly force against the non-deadly force that the defendant used against Madison Cone, if you believe that. They knock him into the water here. There he is, on his ass in the water. How much of a threat is he now to anybody? If they had stopped here, they might have a credible argument that they only punched him into the water the one time to defend Madison Cone. But they don't. They hit him again. They push on his back into the water. They hit him again. And that's when he gets up And then they charge at him, hands going to his neck. That's when the first stabbing occurs. Now, what have they done? The continued beating, the pushing him down in the water, outnumbered. Does that create a reasonable perception that he's facing an imminent threat of death or serious bodily injury? They've escalated what was at best a non-deadly force conflict into a deadly force conflict. And what does Wisconsin law say about that? Even if he punched Madison Cohn and therefore provoked the fight, a person who engages in unlawful conduct, let's pretend the punching of Madison Cohn occurred and was unlawful, of a type likely to provoke others to attack, and who does provoke an attack, let's pretend that's all true, is not allowed to use or threaten force in self-defense against that attack. Fair enough. However, if the attack which follows the provocation causes that person to reasonably believe that he or she is in imminent danger of death or great bodily harm, he may lawfully act in self-defense. You regain that innocence. If the other party whom you provoked in a non-deadly force way, and there's no evidence that his striking of Madison Cohn was deadly force, if you provoke a fight in a non-deadly way and the other party responds with deadly force, they escalate to deadly force, that's a new fight. They're the aggressor in the deadly force fight, and you regain your right to defend yourself. There is a condition here. You can't use deadly force to defend yourself unless you've exhausted every other reasonable means to escape. But of course, he can't escape. They're charging at him. They're coming to him in these fights. All right. So, I mean, this is the situation, right? The state likes to suggest that, well, he was just facing two girls. Was he? Or was he facing all these red dots? We know the truth. All right, let's jump up to the defense closing now. Let's see, 10-minute break, so be about, be about here. Let me make a note to myself. So I think they normally have time limits set by the judge. I didn't hear the judge's time limits. But it seems like let me see, how long did the defense go? Let's see, when did he get up? When did he stand up? From about there. Let me make a note. He talked for about an hour. So normally the state and the defense are given the same amount of time to talk, but the state gets to talk twice. They get to close first, then the defense closes, then the state gets a rebuttal. Given that the state closing, the initial closing was an hour, I expect both parties have an hour and a half to talk. And the state is splitting an hour to start and then 30 minutes for rebuttal. And then the defense would have an hour and a half for their entire closing, would be my expectation. So just for scheduling purposes. All right, let's get up to the defense close now. Whoops. Here we go.
From Nicolae Miu.
All right, we are back in the presence of the jury with the attorneys and Mr. Miu. Mr. Truffesy.
Chirophacy for the close. Nelson did the opening for the defense.
May it please the court, counsel. So, ladies and gentlemen, in his opening statement, Attorney Nelson said to you, one of the things you're going to have to determine is what happened on July 30th, 2022. Well, What happened on July 30th, 2022 is a group of drunk teenagers led by the ringleader, Juwan Cockfield, saw an opportunity to torment a man who was by himself. They taunted him. They called him names like raper and pedophile and predator. They did this for no legitimate purpose. When they did this, they're yelling and carrying on. It attracted the attention of another group, right? Led by Madison Cohen and Dante Carlson. 6 drunk teenagers quickly turned into 13. 13 against 1.
They have this image up
They got it.
on the screen. The one I just shared with all of you. I'll just pop it up to refresh everyone's. Where is it? Here it is. They have this image up showing all the red dots. That's what he's pointing at on the screen behind him. You can see it there on the laptop screen here.
In his face. They screamed at him. They called him names. They swore at him. They put their hands on him. And the group of 6, they became brave. The group of 6 became brave to the point that they circle him and start taunting him. They do this to a man who has done nothing, absolutely nothing to them. Then, when that man, Mr. Miu, tries to create some space between him and Madison Cohen, they pounce. They punch him. They push him. They slap him. They hit him again. They choke him from all directions. And Nick Miu acts in self-defense. That's what happened on July 30th, 2022. I just want to give you guys a little bit of an indication as to kind of where I'm going to go, and more importantly, what I think you need to think about when you are back there thinking about the evidence, okay?
By the way, if I were the defense during this closing, if I were Corey Traffsey, I would tell the jury before I let them go, because this is the last time the jury's ever going to hear from the defense. When you get back there into deliberations, I recommend you're going to have 29 pages of jury instructions. Do self-defense first. Because if you look at the elements of self-defense and you decide it was self-defense, the state has failed to disprove self-defense beyond a reasonable doubt, all those other charges don't matter. Self-defense is a perfect defense against every one of those. You won't need to consider them. You won't need to waste time on them. If you decide this was self-defense, you can just go home.
First is the law. 1, there is no duty to retreat, period. That is the only requirement. In this state, bullies like Madison Cohen don't get to tell us where to go. Bullies like Madison Cohen don't get to get in our face and require that we leave. That's not a requirement here. Keep that in mind. 2, subjective beliefs, okay? When you're listening to or contemplating the evidence and replaying it in your mind, you are to do that and consider the beliefs, not the actions, but the beliefs of Mr. Miu. And when you do that, you are to do that from his perspective at the time that the events were occurring. So while we have a video, that video is from the perspective of Juwan Cockfield. The video perspective that the jury is required to consider it is as Nick Miu is holding the camera.
Could have said that better.
I'm going to address this a little bit later, but the idea of provocation. Whether or not Nick intentionally caused harm to Madison Cohen, that is something that you should consider when you're considering provocation. And the other main one I want to talk about is what it means, because it's different here, beyond a reasonable doubt. So normally, beyond a reasonable doubt is this hurdle, and the state has to jump that hurdle in order to prove a case. It's a little bit different here, okay? Because in this case, self-defense has been alleged. Remember when you're back there, Nick Miu doesn't have to prove he acted in self-defense. They have to prove beyond a reasonable doubt that he didn't act in self-defense. They have to prove that his beliefs were unreasonable. Okay? So,
Say beyond
the
a
way that
reasonable
I
doubt
look
more.
at this video, the main video of Juwan Cockfield, we've all seen the 9-second video where he's screaming at Mr. Miu, calling him a raper. I'm not talking about that one. I'm talking about the video that you've seen probably more than you want to. But I'm breaking that up into really 3 parts, okay? 0 to 149 is the first part, all right? Before anything actually happens in terms of the attack. And what is in dispute in that first minute and 49 seconds? I think 2 things were raised in the case that were in dispute. And that is, first, whether or not these drunk teens were actually afraid of Mr. Miu, right? I think to a person, they testified, yeah, we were really concerned about Mr. Miu. And you get to use your everyday experiences in life when you decide what to believe. Does that look to you like teenagers who are afraid of that person? Is that what that looks like to you? Does this photo of drunk teenagers taunting him, does that make you believe in your experiences in life that they're afraid of him? Or is this what drunk teenagers who are terrified, is that what they look like? Does that make sense to you? Because you heard this. As the numbers rose, as the number of people grew, their fear, it decreased. And you've heard Mr. Anderson say over and over again, all Nick Miu had to do was walk away. Well, you heard from each one of those tubers, those drunk teenagers, we could have passed. When he walked over by Madison Cohen, we could have passed. And you heard Owen Pelican. I didn't want to pass. I wanted to see how this was going to play out. Why? Because Juwan Cockfield was recording this entire incident. They wanted to see what was going to happen. They're not afraid. They want to see how this is going to play out. And Juwan Cockfield said it best of all. It's for the culture. He wanted to put it on the internet so other people could see it. And when you're using your everyday experiences in life, ask yourself this. Do people who are afraid of other people, do they walk up on them? Is that what people do when you're afraid of someone? Or do you try to get away from them? If you're afraid of someone, do you taunt them? Do you call them names? Do you circle around them? Those are questions that you all can answer. Or an alternative hypothesis to them being terrified is, do they do those things because they're drunk teenagers and what they want to do is make a video and put it on the internet? Which one of those two things, based on the evidence that you've seen, which one of those things makes more sense to you? The second thing that I think is in dispute, or was at least raised in the first minute and 49 seconds of that video, is whether or not Nick Miu's looking for little girls. Now, Mr. Anderson gets up here and says, no, he wasn't looking for little girls. But he also says, the boys didn't invent that. No, they pretty much invented that. And why do we, or how do we know that? So that's not on video anywhere, right? They don't mention it. They don't say anything about Nick Miu telling them that, right? Every one of them who speaks to the police provides a statement about what happened. Zero mention to the police that he said he was looking for little girls. This gentleman over here, Investigator Schultz, I think he said that he was a sensitive crimes investigator. He saw some of this stuff come across his desk, and that would have interested him. Investigator did testify. Said he would have mentioned, if any of these kids would have mentioned little girls, I would have taken note of that. So, what's the alternative? Why did they say that? I would submit to you that what kind of person does what these kids did to him, and what would they look like as people if all they did was pick a guy out and start to torment him? What do we think of people who do that? What do we think of people who call grown men rapers and pedophiles and predators for kicks? What do we think of those people? They had to come in and say that. Because if they don't, we know what we think of them. That's the reason they came in, and they said this to you guys under oath. They got on that witness stand and swore to tell the truth, and they told you that he said he was looking for little girls. Well, the cops got up under oath and told you, no, they never mentioned that to me. What are the odds? What are the odds that that actually happened and nobody mentions it to the police? What are the odds? Two other little points on that. In your everyday experiences in life, would you expect a man that you never met to walk up to you and say, if you ask him, how's your day? What are you doing? Oh, I'm looking for little girls. Would you expect someone to actually do that? Does that make any sense to you? He's with his wife. He has lunch with his wife and his friends. In order to believe what these drunk teenagers are saying, you have to believe that he has lunch with his wife, he's with his friends, they're having a fine time. Ariel loses his phone, and Nick goes, this is my chance. My wife's right over there, but this is my chance to go look for little girls. And I'm going to tell a bunch of drunk teenagers I've never met before, that's what I'm doing. Tell me that makes sense to you. Because you get to judge the credibility of what people have said to you. Okay? But I want to talk about what we know in that first minute and 49 seconds of the video. What do we know? We know, based on the evidence, that Nick's looking for a phone. We know that. Ariel said that. Nick said that. They find Ariel's phone in the river. So we know that. We know that Nick comes up to the teenager's tubes, and we know that Cotfield is looking for a phone, and Cotfield's holding the phone. Joanne Cotfield's holding the phone. We know that Nick Miu walks away from them as he passes them. We know that. We know, right, that the drunk teenagers move toward him and start confronting him. We know that. We also know that Nick sees what he believes to be a reasonable, rational adult. So he heads over there to talk to her. And what we know is you can see his thumb. He's motioning back, trying to explain what happened. And we know that Madison Cohen, who knows nothing about what happened, zero, starts screaming at him to leave. We know that Madison Cohen feels comfortable enough to put her hands on him for the first time and move him because, well, she's queen of the river and she decides where people go. So she's moving him. We know that. We know that Nick is uncomfortable. So he waits for his group to come over because the state can say whatever they want. He's by himself. So we know Nick does that. We know that when Nick waves to his group, so does Madison Cohen. But there's one big difference here. Her group shows up. And they show up in numbers. We know that the group of teens are brave. And as this is going on, they start taunting this man who's done nothing to them. We know that. We know that Riley Madison comes over and now she thinks it's necessary because she's been anointed something in the river and she gets to tell him where to go. So we know that she puts her hands on him. We know that Nick's uncomfortable enough that he waves the group over a second time, trying to get someone to come to his aid. We know that. We know that Madison Cohen pushes him, puts her hands on him again. He tells her not to touch him, but she does it anyway. We know at that point it's 13 against 1. The other thing that we know, because we heard it, was someone in the group, the brave group of 6, tells Nick Miu, you got 10 seconds. In your everyday experiences in life, when someone tells you that you have 10 seconds, what normally comes after that? If we have children, I'm going to count to 3. You got 10 seconds to do this. Nothing's good is coming after that. It's reasonable in our experiences as adults to take that as a threat, right? And if you think about it, they all blamed. They didn't know it, but the guy holding the bag is Isaac. We know it's not Joanne Cockfield, and everybody else denied it. So who's left? Their buddy Isaac. They all blame without saying his name. It's like, wasn't me, wasn't me, wasn't me. Well, you're saying it's the one person who isn't here, right? That's what we know. We know everything here I just told you is what we know in the first minute and 49 seconds. And why does that matter? What does...
Judge, I can't see the exhibits we do over models.
And step up and move over to the side.
What does that matter? Why does this matter? Because one of the things you have to consider when you consider self-defense is Nick Miu's reasonable belief that there is going to be an imminent interference with his person. And when you add all of these things together, he has to subjectively believe that. As a jury, as you sit here today, we don't get to look at it and say, what would an objective, reasonable person do? Does Nick feel that way? Does Nick feel, with all of these things listed here, that there is an imminent unlawful interference with his person? And I would submit to you, he does. He told you he did. Right? We're going to see the video one time, promise, broken up into those parts.
Corey's doing good. Very linear.
What is he on? Whoa! 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 Get away! Oh God! We up! We up! What are you talking about? What the hell are you talking about? What? Get away from us! What? What's going on with y'all homie? He's on camera. Tripping. He's on 4K. Yo, the new iPhone got that good quality. What did you say? Yeah, what the hell? Who is this? Yes, yes, yes. Further culture! Further culture! Who is that? Further culture! Who is that? Who the hell is this?
Go! It doesn't matter.
You can't go! He said he was looking for a little girl! He said he was looking for a little girl! You're looking for a little girl? Yeah! That's exactly what he said. Weirding us out. I even have that part on camera. Did I? Some young ass kid. What the hell is this guy's problem, bro? We're trying to have fun. Is he gonna claim you? He's gonna claim you. We don't want this motherfucker. That is on camera. That is on camera. He on camera. Oh God. Oh God. Oh God. He on camera.
The second part of the video that I think is important, and Attorney Anderson's talked a little bit about it, is really the 1 second that we don't get to see, right? The 1 second where the state is insinuating and is claiming that Madison Cohen was punched, and where Nick Miu has testified that he raises his arm to get her out of his space. So those are the two possibilities as to what happened in the video that you don't see. And I am, once again, asking that you use your everyday experiences in life when you make this determination, okay? And I understand that people in stressful situations don't get everything perfect. I get that. I'm not holding anybody to this exact standard. But what have we heard in order to prove beyond a reasonable doubt that this happened? Well, you heard A.J. Martin say that he grabbed her by the back of the hair and was slugging her from behind. Okay, no one else says that. You hear Alex Vang say he slapped her with a right hand in the face. Then I say, Mr. Vang, how can that happen? He's got a knife in his hand. And he says, you're right, that can't happen. He punched her. You hear Joanne Cockfield, who's not looking at it, he's holding his camera in another direction, says he threw a hook at her. I saw that. Right? Madison Cohen says, she said on direct examination, he hit me with a left hand to the left side of my face. And it sat there. Then when I asked her questions and I said, can you explain how that's humanly possible? And her response was, you're right. I get lefts and rights wrong. He hit me on the other side. Okay. But the state says she had a heartbeat in her cheek. She should remember what side of her cheek the heartbeat was in. If she doesn't get that right. But how about the things when you use your everyday experiences in life that the state, they didn't talk about when he was up here talking about her injuries. He talks about her falling back and people seeing things. Okay, people can be wrong. How about things that make sense, though? We know that she's wearing sunglasses, right? We know that. Her sunglasses are not broken. She doesn't have a mark on her face from being cut by sunglasses. None of that. Is that what would happen if a 250-pound man squared up on a woman and threw a hook to her face? She doesn't have redness on her face. She doesn't have swelling on her face. She doesn't have puffiness, a bruise, or a mark. How do we know that? Investigator Schultz told us, I saw her shortly thereafter, and she didn't have a mark on her. He says, if I would have seen a mark, I would have taken a photograph of that mark. Makes sense, right? She doesn't drop her drink. She doesn't drop her vape. Her cell phone doesn't leave her bathing suit. Is that what happens when a 250-pound man squares up on a woman? She doesn't drop a thing, and she doesn't have a mark. Does that make sense to you all? Or does it make more sense that Nick Miu pushes her out of his space? Attorney Anderson said she's not in his face. Well, most of her friends said, no, she was. She was in his face. She was in his face. She was in his space. Right? If he makes this motion, she's not going to have broken sunglasses. She's not going to have a mark on her face. She's not going to have redness, puffiness, swelling, a bruise. She's not going to drop her drink because he doesn't hit her. Which one of those two things in your everyday experiences in life makes more sense? You get to decide that. And I want you to think about this. She knows the seriousness of the case. She tells the police she takes a photograph or photographs. Then she claims to have deleted them in a homicide case. Then the police say, that's okay. That happens. You give us your phone, we can get the pictures. Right? Wrong. They do a Cellbrite downloaded extraction of her phone. Investigator Schultz doesn't do it, but he reviews it and says, there's no deleted photos that I saw in there. He even goes so far as to reach out to Madison Cohen's mother, because maybe she either took the photos or were sent the photos. No, not there either. You get to judge the credibility of people and whether or not that makes any sense. That is not provocation. And just briefly on retreat and provocation. I told you when I started, there is no duty to retreat. And that is true. That's the first sentence in the retreat instruction. If you want to, it says you may consider whether or not when he was retreating, or if he had to retreat, whether the defendant reasonably believed the amount of force used was necessary to terminate the interference. You may consider whether he had the opportunity to retreat. Okay. Now you don't have to, but when it starts, when it matters, is when he's using the force. And when he's doing that, he's surrounded. He told you he was surrounded. I asked.
This is an important point because the states, again, is going to attempt to conflate all the time points of the video into one, as if everything happened simultaneously. They'll say, well, he could have retreated at any time in this 3-minute and 30-second video. But that's not what's relevant. What's relevant is when he's making the decision to defend himself, did he have a safe avenue of retreat? Not could he have retreated 30 seconds earlier or a minute earlier or 2 minutes earlier.
Lieutenant Hart, do you have any information that would be contrary to Nick Miu's belief or statement that he was surrounded? She said, no, I don't. Where's he gonna go? So he doesn't have to go anywhere. We don't let people dictate what we do, and the loudest voice in the room doesn't have to win. Madison Cohen doesn't get to make these decisions for people. He doesn't have to leave. The drunk teenagers don't have to leave either. They told you they could have left, but they wanted to see the show. He doesn't have to go, and there's nowhere to go. That should be the beginning, middle, and end of that evaluation on retreat. Same analysis, same result on provocation. Okay? You have to find that Nick Miu committed an unlawful conduct against Madison Cohen to provoke this attack. He wanted her to get out of his personal space. The bully in the room doesn't get to yell at you and tell you to leave, and then when you don't leave, doesn't get to get in your personal space because you are not leaving. That's not how this works. The last part of the video is the 150 to 205 mark. Okay? Now, you heard yesterday, the state wants to break this video, this last 15 seconds or so, down into stills. 1/24th of a second. No one lives their life in 1/24th of a second. And you're not supposed to in this case, because you're supposed to look at this case through the eyes of Nick Miu. And if you've watched that video, the first time I saw it, I didn't see what happened. I didn't see him pull a knife. I didn't see some of these people getting injured because it's moving like this. When you break it down to 1/24th of a second, it's just not how we live our lives. You have to look at those 14 seconds through Nick Miu's eyes as he was standing there in the river. And remember, he told you yesterday that he believed that he was going to die. But he doesn't have to believe that. He just has to believe that he's going to suffer serious bodily injury. That's what he has to believe, okay? And before I start this video, I'm going to ask you this again. What do we know in those last 15 seconds? We know that Anthony and Dante Carlson were asked by their dad to go over there. Why? To help him. Quentin Carlson testified that he was concerned that Nick Miu was going to get the brakes beat off of him. So Quentin Carlson wanted his boys to go assist. I would submit to you that Quentin Carlson was concerned that Nick Miu was going to suffer serious bodily injury if someone didn't help him. Alex Vang told you Miu's getting his butt kicked when this is going on. And Owen Peliquin said those guys got on his ass. Right? Anthony Carlson is yelling, stop, stop, stop. He's not yelling it to Nick Miu. Nick Miu's tail down in the water. Presumably, he's telling it to the people who are beating him. Right? That's what we know.
He hit a woman? He hit a woman? You hit a woman.
Now, Juwan Cockfield found that to be funny for quite some time. You can hear him cackling on how he thinks it's funny that Miu's getting punched in the face and knocked in the face, slapped, okay? But what we know from that video is a 250-pound man, 250-pound man, has been knocked clean off his feet backwards into the water by getting punched in the jaw. That's what we know. We know that in 1 second, Dante Carlson, who throws that punch, runs around to the other side of Nick Miu while he's still on his back, kind of on his lower, on his butt, kind of on his lower back, and he cracks him across the face. We know that. That's not in dispute. We know that AJ Martin, who says he's the peacekeeper, that's what he said. He runs up from behind and shoves Nick Miu while Dante Carlson comes in for thirds and smacks Nick Miu in the face again. I would submit to you at this point, it's coming from all sides and from multiple people. And this man who had heart surgery is terrified as to what's going on. We know, well, let me just remind you of this. At this point, after he's been punched, slapped, pushed, slapped, he hasn't stabbed anyone. Right? And if you listened closely to what AJ Martin said in his testimony, when he was shown the picture of him making contact with Mr. Miu before Mr. Miu stabbed him, he said, he got me before I got him, I guess. What does that tell you about what AJ Martin's intention is? He's back in the water now for a third time after getting pushed down by AJ Martin. And what do we see next? That's Anthony Carlson. He walks right by me. Miu doesn't do a thing to him. Mr. Miu doesn't do a thing to Anthony Carlson as he walks by. You will then see, and what we know is Anthony Carlson comes up from behind him, appears to be yelling at him and putting his hands on him. So now Miu has been touched at that point, punched, pushed from behind and slapped. And now Anthony Carlson comes up to him. We know that. And then we know 1 second later that Isaac Shuman comes up to him. You guys get to make the decision on whether or not he's choking him around the neck. You get to make that decision. I'm not telling you what that is. You get to decide if that looks like a choke to you or not. So at that point, 4 people have attacked Nick Miu. And why does it matter? Why does any of that matter? Because if you find the following, Nick Miu is not guilty of all the charges, okay? If you find that Nick Miu believed that there was an imminent unlawful interference with his person, if you believe that he believed that was coming, the 19 or 18 reasons that I put up there supports that, and he told you that. And that's his subjective beliefs, okay? If he believed the amount of force that he used was necessary to terminate that interference, okay? So if he believed that he did what he had to do, right? I would submit to you there's only 2 answers to that. Only 2 possible answers. He either did what he had to do to survive, or this man who you watch the video, who's never got a speeding ticket, who decides to go out with his wife that day, who's floating down the river and having lunch, decides, you know what, today's the day I'm going to start stabbing people. I'm going to leave my group, I'm going to go over and I'm going to start stabbing people. Mr. Anderson says he snapped. If he was in fear, he would have left. I think anybody would dispute that he was in fear. So when you're determining whether or not what he did, if he believed that he had to do that to terminate that interference, I would submit to you, why else would he do it? He either believed that or he just lost his mind. Right? This 52-year-old engineer who's married just lost his mind that day. Those are the 2 options I think that you have on that. And the final thing that you need to decide is whether or not his beliefs were reasonable. And the standard is, would a person of ordinary intelligence and prudence would have believed standing in his shoes at that moment. Okay? Quentin Carlson is about his age. And Quentin Carlson is concerned enough for his safety that he sends his boys over. Quentin Carlson tells the police that after his boys have been injured. He tells the police, I get it, they're injured. I sent them over there because I was concerned for the old guy. Brandy Hart. Did you watch that video yesterday? There's a point in that video where Nick Miu puts his hand in his head and says something like, my life is over. And Brandy Hart says, I don't know about that. They're self-defense. She says, I don't know what I would have done. But I can tell you I would have been scared shitless. She's been a police officer for 25 years. And that is her response. State never followed up with her on anything after that. That was her statement to the police. Or that was her statement on the tape. And as I mentioned, Alex Vang and Owen Peliquin say he's getting his butt kicked. They're all over him. Are those reasonable people? You get to decide what a reasonable person would do in that situation. But I would submit to you, you've got something to work with. You've got something to work with. Briefly on the charges, okay? Before you even get to self-defense, you get to intent. You have to find intent on the homicide charges initially for Isaac Shuman, and you have to find them for the others involved, okay? And the question on intent is mental purpose. Can you watch that video and say that Nick Miu's mental purpose is to kill Isaac Shuman? Or is his mental purpose to get another person off of him? You get to decide that. Okay? Under those circumstances, you heard everybody say, anybody who never touched him, he never touched. Right? People were like, I didn't want to get near him. They didn't touch him. He didn't touch them. He didn't say anything. You get to consider all the facts and circumstances. He didn't say anything to Isaac. Right? Isaac grabs him by the throat and he stabs him one time. Is that an intent? Is that his intention to kill Isaac Shuman? And when you started this case, you heard that was the charge. Well, those charges have changed. Now you get to consider all other kinds of charges with all other kinds of mental states too, right? Maybe it was intentional. Well, maybe not. Maybe it was reckless. Pick a theory. Don't let them just throw things against the wall and hope that you guys let something stick. They're telling you they thought it was intentional. Now it might not be. Now it might be reckless. They don't have it. Nick Miu wanted to get Isaac Shuman away from him. He didn't chase Isaac Shuman down. He didn't move toward Isaac Shuman. Isaac Shuman moved toward him. And on the attempted homicides, read the instruction on attempt, you guys. In order to convict someone of an attempted homicide, the state must prove to you beyond a reasonable doubt that demonstrates unequivocally that Nick wanted to kill these people and would have, except for the intervention of another person or some other extraneous factor, okay? And unequivocally means there can be no other inference which can reasonably be drawn. No other inference. And an extraneous factor is something outside the control of Nick. You heard D.A. Anderson say, but for medical intervention, some of these people would have died. Well, A.J. Martin would have. Dante Carlson had a hernia. He repaired a hernia. I'm sorry, medical intervention doesn't prevent him. He's not going to die from that. Anthony Carlson gets 2 stitches. He's certainly not going to die from that. And Riley Madison could have got an infection, they said. I understand that. But if he wanted to kill them, why didn't he? He's, if you believe Attorney Anderson, he's alone with Dante Carlson. Why does he stab him one time? He wants to kill him. Why doesn't he smash him up? He wants what he wanted all along, to get away from these people. He's leaving, and Dante Carlson, who has beaten him up, has hit him in the face repeatedly, confronts him again. What does he think What does Nick Miu believe is about to happen? You don't have to let somebody beat you before you respond. Doesn't that make sense? And because they don't have the attempts here, because there was nothing, no outside extraneous factor, they also say might not be attempts. Take a chance on reckless. How about that? Again, not really a theory, but you get to make that decision. I'm going to comment on the video because I think it's appropriate that was played, the interview with Nick and Brandy Hart. He lies about the knife. He lies about the knife. What he
About 35 minutes in, folks.
Lieutenant Hart said is he's never wavered on is that this was self-defense, that he was fearful, and that he was being attacked. Okay, that he's never wavered on it. He said it over 20 times in the interview, and it's the first words out of his mouth when he's interviewed by Lieutenant Hart. Some people get some facts wrong. Some people lie about stuff. He's not telling you the truth about the knife. But does it change one thing that you saw on that video? That's the reason we want there to be a video. Is so you're not taking the word of 13 people who don't get it right. That video is not subject to change. Attorney Anderson's right. It is what it is, right? What has persevered through this case is Nick Miu's fear, how he felt, the shock. You heard people testify about that. The whiteness, the wide eyes, the ghost-looking color of his skin, that has persevered through this case. He lied about the knife. Doesn't change one thing that's on that video. You should feel sympathy for Isaac Shuman's family. I have a 19-year-old son. He would be in Isaac Shuman's grave right now. Everyone feels sympathy for Isaac Shuman's family. I'm sure he was a wonderful kid. And I know that his parents love him. But you don't get to decide this case based on sympathy. The judge tells you that. You decide this case based on facts and evidence. That's what you are required to do. And put most succinctly in terms of the burden of proof and what the state has to do is they have to prove to you beyond a reasonable doubt it's not self-defense. And what does reasonable doubt mean? Well, the judge read it to you. You'll get to hear about it again. But it's a doubt that would cause a person of ordinary prudence to pause or hesitate when deciding the most important affairs of life. And I would submit to you the most important affairs of your collective lives are your health, your family's health, loved one's health. When you're thinking about that and you have to make hard decisions on those things, if there is a pause or hesitation about what you need to do because you're getting information from various places, and you say, I need a break, I need to figure this out. That's reasonable doubt. Okay? It is a doubt for which a reason can be given. That reason is self-defense. And I just want you guys to know this.
Very good. Very strong.
When you go back there and you have those verdict forms, if you believe it's self-defense, he's not guilty. If you believe it's probably self-defense, he's not guilty. If you believe it's possibly self-defense, he's not guilty. If you're like, it likely is, I don't know, not guilty. If you believe it might not be, not guilty. If you believe it's probably not self-defense, not guilty. All of those considerations that you would have require a verdict of not guilty.
Great,
Because
great
the state
stuff.
has to prove to you beyond a reasonable doubt that it wasn't self-defense. So, as I go to sit down, we, Attorney Nelson, Nick Miu, and I appreciate all of your time. The time that you've taken away from your families and friends to do this. The attentiveness that you've given us. And I think it's time for people to go home when you're done. And what we're asking that you do is that you send Nick Miu home. That you find him not guilty on all of the charges. Thank you.
Very
While we
good,
swap
good
people
stuff.
out, if you'd like to stand and stretch for a moment, you may do so. And then we'll
Good stuff. The only thing I would have added, I think, is urging the jury to start with self-defense. Flip through those 29 pages of jury instructions until you get to the self-defense instruction and start there. Because if you determine the state has failed to disprove self-defense beyond any reasonable doubt, well, that's an acquittal on all the charges. Self-defense is a defense to every one of these criminal charges. Start with self-defense, and you don't have to deal with the remainder of the 29 pages. You can just go home. You could be home by mid-afternoon if you start with self-defense. I'd rather the jury do that than work through first-degree homicide, second-degree homicide, 4 counts of first-degree attempt, 4 counts of second-degree attempt, 1 count of reckless homicide, 4 counts of reckless endangerment, and then the alleged battery on Madison Cohen, and then get to self-defense. That doesn't make any sense. So they'll be exhausted by that by the time they get to self-defense. I want them sharp on self-defense first instruction. And that's not how it's listed in the instructions. All right, let's see. I'll take a quick look at Q&A during this break. Whoops. And take this opportunity to remind everybody about our upcoming Law Self-Defense Advanced class. This is the full-day class taught live by me, streamed to you at your computer on Zoom, that teaches you everything you need to know to be hard to convict if you're ever compelled to use force in defense of yourself, your family, your property. Nicolae Miu would not be in this situation had he taken this course and followed what I teach in this Law Self-Defense Advanced class at lawselfdefense.com/advanced. We only teach this class twice a year. Next one is Saturday, April 20th. After that, it'll be October at best before we do it again. Can you afford to wait? Because taking the class after you've defended yourself doesn't help. It's too late then. You need to have this insight, expertise on board before the fight happens. If you go to lawselfdefense.com/advanced, we have a list of over 100 very specific self-defense law questions we answer in plain English. There's plenty of opportunity for Q&A. And this week, we're still in the pre-registration period. Get 50% off. Check it out now at lawofselfdefense.com/advanced. And now let's take a look at some Q&A. So Law Self-Defense members first. Let's see. Someone's talking about a case in which he had all the facts and evidence on their side and the opponent used almost pure emotion. Yeah, that happens. And emotion works, by the way, folks. Human beings are inherently emotional creatures. We all tell ourselves that we're rational and we apply reason and we're critical thinkers. That's only rarely the case. We create a very artificial environment in a courtroom when we bring a jury together, when we give them these kinds of instructions, we basically ask them to think like legal technicians, and we explicitly tell them not to make an emotional decision. That's not how normally people operate. So the emotional part is very dangerous. Yeah, and adding, I mean, all these crazy 29 pages of instructions, detailed legal language that the jury has to. And how I look at jury instructions, and if any of you who consume my content or are law self-defense members have been exposed to jury instructions maybe for years as I talk about them, we understand them because we've seen them over and over again. But a jury's literally never seen jury instructions before. To them, it's all legalese. And by adding these reckless charges, the state is hoping for an opportunity to get a compromise verdict where maybe you have a juror saying, well, I think it's murder. And then you have the other juror saying, no, it looks like self-defense to me. Well, let's compromise. Even though nobody agrees that the compromise verdict has been proven beyond a reasonable doubt. Let's see. Yeah, it is worth pointing out. Let's see if we can see it here. In this video, after he touches the tubes, right? He touches the tubes here. So he comes up, he touches the tubes. He gets up, he walks around to the other side of the tubes looking for his goggles. Then he walks further down the river, right? There's space there. He's creating space. He doesn't walk backwards towards the boys. A few frames later, the boys are surrounding him again. They came up to him. Look at that distance. Look at that empty space. He's not walking back to them. He's walking away. He's walking away. And then what happens? Then we get here. They closed distance on him. He didn't go to them. I think Corey did a good job on self-defense and burden of proof. Of course, I would have done it a little differently, but I thought he did a fine job, especially when he was talking about, hey, if you think it could have been, it might not have been, it probably wasn't. If you think it probably wasn't self-defense, that's still not guilty. That was all great. I really like that part. Very important, because jurors don't really understand what the burden is. Unless you make it very explicit to the jurors what beyond a reasonable proof means, especially in the context of a self-defense case where the state is basically proving a negative, right? They're disproving self-defense beyond a reasonable doubt. You run a real risk that the jurors are going to decide on a preponderance basis, whether they think it's more likely than not. Frankly, that should still be a not guilty verdict here. But especially when the actual legal standard is, if you have any hesitation about whether it could have been self-defense, that's not guilty. All right, let me jump. Any more questions? What happened? Okay. And just compare kind of the tone and delivery of the DA Anderson's closing to Corey Tarafisi's closing. Corey was so much clearer, linear, easy to follow. Anderson's jumping all around because he has to jump around, because he has to conflate different time points to try to put together a narrative of guilt in this case. Yeah, and Corey pointed out that the suddenly added recklessness charges, different than what the state argued in their opening, right? From the opening, throughout the whole trial, the state's been saying this was an intentional killing. But if you don't buy that, go for reckless. Suggests that the state has no confidence in their own theory of the case. So that was good. Why didn't Anderson says, why didn't he brandish the knife? Why didn't he raise the knife? What do you think they would have done if he'd brandished the knife? They would have charged him with brandishing. Let's see. Yeah, when he walked away, they followed him. Right? That's what I just showed you in the video. Let's see. And Corey Chirafisi did a great job talking about the lying afterwards. Lying's not good. It looks bad, but it doesn't change any material fact in the case. If we didn't have the video and it was 13 witnesses on one side and the defendant on the other, and he's lying afterwards, you can say, well, that goes to the defendant's credibility. I just can't believe him. Fair enough. But it doesn't matter whether you believe him because the evidence is in the video. Cycle Boy says, in Wisconsin, carjacking is also a hard stand your ground. Huh. Okay. I mean, it makes sense if your occupied vehicle is defined as highly defensible property. That makes sense to me. I'll check it out. And if your occupied car is defined as highly defensible property, and it generally is, that would be what I would expect. Then the not considering retreat would be in the context of any highly defensible property. Always your home, but it could include other forms of highly defensible property as well. Jason says defense should walk through the entire jury instruction one question at a time. It's just so, there's 29 pages of jury instructions. It's really hard to do. Maybe another reason why the state threw in all those recklessness charges at the end, just to make it thicker. Let's see. Corey's watching the Law of Self-Defense stream. I have no reason to believe Corey Chirafisi knows that I exist, but I like him as a lawyer for sure. Does a good job. Yeah, the doubt is self-defense was a great moment in this closing. Yes, I've talked about the jury instructions earlier in today's show, and I did it the first day of the trial too. All right, and let me see if there's any super chats. If you want to pose a question on YouTube, it needs to be as a super chat of a minimum of $10. Let's see, anything from today? Oh yeah, there are a couple. Sugary Coyote, $10 super chat, says, is it unusual that all parties involved are being referred to by their first name and not Mr. or Miss? Would there be any strategy behind referring to everyone in this informal way? I mean, I don't know that anyone's doing this deliberately. I would certainly refer to my client on the defense by their first name, right? I want to humanize my client to the jury. The state would want to refer to the 17-year-old high school football players by their first name, because that's how adults refer to children, right? And the state's trying to communicate that these were just children. Duncan, Idaho, $10 super chat, says she was only 115 pounds, though, just a little baby girl. In fact, they were all just helpless little babies, and he chased after and attacked them. Yeah, I did the math yesterday. I mean, if you assume that on average, the 13 people weighed 150 pounds each, and we know the girls probably weighed 150 pounds, at least Madison Cohen, and the males all weighed more than that. That's literally a ton of weight, 2,000 pounds, facing Nick Miu. How's he going to fight off a ton of human beings without a weapon? And SD and Aaron Roll, $5 super chat, just says thanks. Needs to be $10, folks, but he just said thanks, so I appreciate that. All right, caught up on that. Now let's get back to the state's rebuttal. This will be Prosecutor Brian, I don't know how to pronounce his name, Smestad, something like that. Oh, that's something Corey should have touched on more, I think. He mentioned, reminded the jury that the defendant had heart surgery a couple years prior, but he only mentioned it once in passing. And one thing I would have suggested he do is when he's talking about, you have to consider this from the defendant's perspective. I would have listed all those factors. There's 13 people. Collectively, they're 2,000 pounds. There's literally a ton of people surrounding him. He knows he's had heart surgery. He knows he's exceptionally vulnerable to injury. He knows he can't safely run because he's tried to move away before and they've simply chased him. He knows he's twice their age. I would have stepped through every one of those factors. Okay. Back. Where is it?
We'll hear a brief rebuttal from Mr. Smithstone.
It looks like I'm still at the end. I thought I would have moved along a bit more. Oh, I see. Here we go. All right. Oh, there he is. Whoop.
What do we know about Nick Miu? We know he's smart, speaks multiple languages, has a couple of degrees, one's in math. He's a calculating person. He's a cunning person. He's a skilled and prolific liar. We know that because every word that came out of his mouth, practically since he started walking away from this group, was a lie, including to his best friend, who he said they took my knife while the knife is still on him. The things he said to Sheriff Knudsen, where he pretended to not know what was going on. And then everything he said to Investigator Hart, Lieutenant Hart. He is skillful at crafting a story that matches what he needs to say to avoid the consequences for his actions. We all know that. It's undisputed. He told you himself, he's a liar. All right? He did not just not lie about the knife. He lied about all kinds of crazy things, bizarre things. Why would he say that these boys pulled his pants down? What a
But it's so funny. He's not on trial for perjury. He's on trial for use of force. And we have the video. Is the video lying?
bizarre lie to make up, right? Why would he say that two boys pulled knives on him? He's got to say that because he knows what he did wasn't justified. He thinks to himself, if I say one boy pulled a knife, it would be good, but if it's two, that would be better. So he crafts this elaborate story. His entire defense rests on you believing what he said on the stand yesterday. His testimony was a disaster. He got caught in several lies on the stand. He changed his answers a couple of times when he realized that what he said wasn't helpful to his defense, right? He consistently remembered details from July 30th, 2022 that benefits his defense, but doesn't remember anything about what he did, any of the facts, any of the stories that he told Lieutenant Hart. How is that possible that he can only remember the facts, the beliefs he had that assist his defense, and nothing else? How many times did he say on the stand, I don't remember, I don't remember, I don't remember? He repeated it over and over and over again because he doesn't want to answer questions about what he did because he knows dang well it wasn't justified. He's lying. He's lying. One of the many things I'm going to be grateful about when this is done is that I never have to hear again that the actions he took that day was the fault of these boys. That's ridiculous. It's despicable. There's never been any explanation from the defense as to why Nick Miu ran up on these boys, why he grabbed their tubes, why he was groping around where their legs were. They don't even respond to it. They didn't bring it up.
Well, it's irrelevant.
There is no explanation. That behavior is inexplicable. He's a bizarre person. He made bizarre choices that day. It is not their fault. It is not their fault. I'll say it 100 times. It's not their fault. These boys have beat themselves up every day since this happened. You saw the raw emotion on the stand. their best friend was murdered by this guy. And to say that it's their fault is despicable. Nobody's responsible for Nick Miu's choices but himself. He chose violence at every turn. There's been some question about whether he's fragile. Part of him is fragile. His ego is fragile. As his attorney had said early last week, when he's questioning these boys, you were trying to humiliate him. You were trying to insult him. You were taunting him. He was humiliated. He was insulted. He didn't like these boys treating him like that. He certainly didn't like Madison Cohen getting in his face, so to speak. And eventually, he did just snap. He pulled his knife out, getting ready for violence, pulls it out, holds it down where nobody can see it, holds it at his side, and then hits her. That started the violence. He prepared for the violence before he started it. He felt humiliated, and he wasn't going to let it go. I asked him, did you ever take a step back at any time when she was yelling at you? No. With no explanation. We're dealing with what we call false narratives in this case. Things that the defense repeats over and over and over again, hoping that you think it's fact, okay? One of these is this 13-to-1 narrative, okay? We've heard it 100 times in this trial. This is not a 13-to-1 situation. We've got the 6 teenage boys standing on the side by their tubes. He's confronted by the 2 girls. Everybody else is in the background. He hits Madison Cohen when he's only got 2 girls standing in front of him. After the fight, it's 1-on-1 to start. It's Dante hitting him, and then arguably 2-on-1 when AJ comes up and pushes him in the back. Tony breaks it up. The fight's done. He gets off. And AJ, of course, is already tore open, so he's laying in the river. But that's the end of the fight. Mr. Miu continued violence. He chose more violence after that part of the fight was done.
What about Isaac Shuman?
Tony, who did exactly what his dad told him to do, came up to try to break it up. You can hear him tell Dante, his brother, get away, get back. Mr. Miu turns around and stabs him, and Tony blocks it and stabs him again. He chose violence at every turn. There's another false narrative. They circled him. They surrounded him. Baloney. You've seen the video how many times there's open water everywhere. That he was attacked from all directions. False narrative. He said that Owen Peliquin testified that they stuck around because they wanted to see how it played out. That's true, but what he didn't mention is that Owen also said he wanted to make sure he didn't do anything to this woman. And you know what? Those instincts were exactly right. Those instincts were right. He keeps talking about how these boys wanted to make a video. Well, they were making a video. But what does that matter? They didn't start the violence. None of those boys laid a hand on him, despite the fact that he touched both Joanne Cockfield and Landon Wire when he ran up on him in the tubes. Nobody laid a hand on him until after he had already stabbed a number of people. Isaac Shuman tried to stop him. He got killed for his efforts. He seems to be arguing, the defense seems to be arguing that Isaac somehow deserved it. I don't understand that argument. He's trying to protect people. He calls Maddie Cohen the queen of the river, and he calls her a bully, calls her a number of other unkind things. Her testimony was, and it's clear from the video, she was trying to protect these boys. She saw that he was over there doing something, that it was freaking them out. She tried to protect them. You know, maybe if we had more people on the river trying to protect people, the world would be a better place.
No kidding. Defendant could have used some protecting.
They've made over and over, they've argued that Maddie was never punched because she has no marks on her face. Nick Miu, who, as Mr. Trosty said, was lifted off of his feet by the punch from Dante and punched in the jaw and fell in the river, gets up and there's no marks on his face. We have pictures from him. We have the video. We have his interview with Lieutenant Hart later.
It's such a weak argument. I don't know. They've made this before. But if the question is, all right, there's a claim that one person punched another, where's the evidence of the punch? In the case of Matty Cohen, there is no objective evidence. There's no video. There's no injury. In the case of the defendant, there is objective evidence. We have video of him getting punched in the face. But I guess this is all the state has to work with.
Have the pictures that the jail nurse took 5 hours after. There's no bruising. There's no puffiness. There's no swelling. The fact that they're arguing that Matty had no mark doesn't matter because he didn't either. It happens. They're trying to say that he was terrified. His face tells a different story. He has expressions of anger. He has expressions of, I guess, humor. He's smiling. He's smirking. Well, after he has his knife out, he clearly feels comfortable. There's no look of terror in his face at any time.
The smirking
A.J. Martin
argument
was not armed. He pushed Mr. Miu in the back. We know that. He didn't kick him. He didn't punch him. He didn't hold his head underwater. He pushed him in the back. And for that, he got a incision on his body from his belt line all the way up. You saw the pictures. It's horrible. He used no weapon against Mr. Miu. They made a big deal about Lieutenant Hart telling Mr. Miu in the interview that she would have been scared.
Corey should have addressed this too, because the state's made this argument repeatedly about the boys having no weapons. It doesn't matter whether they had weapons or not. The legal question is, could they have been reasonably perceived by this defendant as representing a deadly force threat? No weapon is required when you outnumber somebody by 2,000 pounds.
There too. Well, she made that response after he'd been feeding her a load of BS about all this stuff that supposedly happened, about having 2 kids pulling knives on him and pulling his pants down and all the baloney that he fed her. Based on that, she said, yeah, I would have been scared too. They're arguing that he had no intent to kill Isaac. Isaac weighed 134 pounds at the time. He's 250. He rams his knife up, not down, up, severing 2 of Isaac's ribs right into his heart. All right. If he didn't intend to kill him, why not stab him in the belly? Right into his heart. We've heard no explanation whatsoever as to why he stabbed Riley Madison. We know from the video she's standing off in the background after Tony's trying to break it up. He just walked over and stabbed her. She wasn't attacking him. They don't explain that because there is no explanation. None. He wasn't in fear for his life from Riley Madison. She said she was 110 pounds now, might have been 115 back then. There's no fear for his life. He just was mad because she touched him. They've talked a little bit about the extraneous factors. It's not just medical attention that can be an extraneous factor. As we know, multiple people on the river stopped to help these folks, putting compressions on. One witness said they used a sandwich bag to try to make a chest compression. There was a lot of interventions for these folks. We know with Riley Madison specifically that Larry and Davis and his brother, we saw it on the video, got her to shore on a tube. People went out of their way to help these folks. These are extraneous factors. But another extraneous factor is he just got unlucky. You know, if he, as Mr. Anderson had said, we've got arteries, we've got organs. Dr. Meyer said, you know, whenever you have a an abdomen wound, you have to check all those things. It's kind of a miracle that more people didn't get killed. It's not by anything he did. He just got lucky. Missed major organs and arteries. The bottom line is he had 4 hours from the time that he was arrested to the time that he concocted this ridiculous story about the boys pulling knives on him and pulling his pants down and all this other bizarre baloney. He used his intellect, because we know he's smart, to craft this story. And he was very deliberate and detailed because he wanted to come up with a story that he thought would be sufficient to convince people that he acted in self-defense. We know he lied about all of it. So now today, he's saying, well, sure, I lied about everything I said when I talked to Lieutenant Hart about what happened, but now I'm telling the truth. So now believe me. No, no, no. You have my full confidence. I know you're going to return just verdict of guilty and deliver justice to Isaac Shuman and everybody else who got hurt by this man. Thank you.
Well, that was gratefully brief. I mean, it was largely nonsense. But grateful. It's unfortunate that the defense doesn't get to go again. Last words that the jury hears are from the state. First words the jury hears are from the state, and the state gets to make their opening first. Last words the jury hears also from the state. Powerful advantage for the state. It's done that way in part because the burden is on the state to prove guilt and disprove self-defense beyond a reasonable doubt. Let's see what the judge has to say. The jury's already been read the instructions before these closing arguments. I skipped past that this morning.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding
That was only a 15-minute rebuttal.
the rules of law that should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether Mr. Miu is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide, and they must not affect your deliberations. Multiple forms of verdict will be submitted to you concerning the charges against the defendant, Nicolae Miu. For count 1, 5 forms of verdict will be submitted. They read, as to count 1 of the information, Isaac Shuman, the jury finds Nicolae Miu guilty of first-degree intentional homicide as charged. Another form, as to count 1 of the information, Isaac Shuman, the jury finds Nicolae Miu guilty of second-degree intentional homicide as submitted. Another form, as to count 1 of the information, Isaac Shuman, the jury finds Nicolae Miu guilty of first-degree reckless homicide as submitted. Another form, as to count 1 of the information, Isaac Shuman, the jury finds Nicolae Miu guilty of second-degree reckless homicide as submitted. Lastly, as to count 1 of the information, Isaac Shuman, the jury finds Nicolae Miu not guilty. Return only 1 for your verdict. If you return a guilty verdict, you must also answer this question. Did Mr. Miu commit the crime while using a dangerous weapon? As to count 2, 5 forms of verdict will be submitted. They read, as to count 1 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of attempted first-degree intentional homicide as charged. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of attempted second-degree intentional homicide as submitted. Another form, as to count 2 of the information, Alexander Martin, The jury finds Nicolae Miu guilty of first-degree recklessly endangering safety as submitted. Another form. As to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of second-degree recklessly endangering safety as submitted. Finally, as to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu not guilty. Again, return only 1 for your verdict. If you return a guilty verdict, you must also answer the dangerous weapon question. As to counts 3, Dante Carlson, count 4, Anthony Carlson, and count 5, Riley Madison, the court will give you 5 verdict forms for each count that are worded similar to the ones given to you for count 2. As to count 6, Madison Cohen, 2 forms of verdict will be submitted. One reading. As to count 6 of the information, Madison Cohen, the jury finds Nicolae Miu guilty of battery as charged. Next, as to count 6 of the information, Madison Cohen, the jury finds Nicolae Miu not guilty. Again, if you return the guilty verdict, you must answer the dangerous weapon question. It is for you to determine whether Mr. Miu is guilty or not guilty of each of the 6 counts submitted to you. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer.
I've put up a poll on YouTube, folks. Guilty, not guilty, mistrial. Those of you on YouTube, if you want to participate in that, it just went up.
Any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with the verdict. At this time, please administer the oath to the bailiff.
Do you swear that you will, to your utmost ability, keep all jurors on this trial together in some private and convenient place, subject to the direction of the court, until they have agreed upon your verdict and they are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God?
I will. The bailiff has extra copies of the jury instructions. I imagine you'll probably want to consult with them during the course of your deliberations. I believe he has 4 or 5 sets. If you need more, let him know, and I will print more for you. He also has the verdict forms in each of the manila envelopes, 1 envelope per count. If you reach a verdict, please put that verdict signed by the foreperson back into the envelope. The other forms that you don't use can be discarded, but there only should be 1 verdict form returned back in each envelope. Now, members of the jury, as I mentioned to you at the beginning of the trial, only 12 jurors can deliberate. 2 alternates were seated in the event that we lost jurors due to health, emergency, or some form of misconduct. The alternates have been determined by lot by the clerk of court. The alternate jurors are not released from jury duty. Alternate jurors may be called upon to deliberate if we happen to lose one of the 12 jurors during the course of deliberations. So basically, the alternates are needed to be at the ready and stand by in the event that they are needed. The alternate jurors will be free to leave the building, but You may not talk about this case with anyone. You may not research or investigate the case on your own. You may not read social media posts. You may not read news reports about this case. If we need an alternate juror to participate in deliberations, the clerk of court will contact you. So we'll need a phone number before you leave. You will be expected to return relatively quickly. So please stay close to home or close to your place of work if it's nearby. We will keep your personal notes safe in a secure private location in the event that you're called upon to deliberate. At this time, I'll ask for the envelope.
Yeah, if you're on YouTube, hit that like button and subscribe. Why wouldn't you
The two alternate
subscribe?
jurors are Darren.
Oh, Darren. They didn't cut the mic quick enough. So when a man is off the jury.
You may, if you'd like to have a private place where you can eat it here in the courthouse, we'll provide you with that facility. But the alternate jurors may not eat with the other 12 because the other 12 may begin their deliberations once they are back in the deliberation room. Please take the jury out.
All rise for the jury.
Someone had said that they liked the fact that one of the jurors said they couldn't see the defense easels and moved over to watch it. That's a good sign. That wasn't one of the jurors. That was Brian Smetstat, one of the prosecutors, couldn't see it. He walked over to get a better angle because he has to respond to it in rebuttal. The easels were clearly visible to the jurors. It was the fat DA. They're both fat. It was the non-elected prosecutor.
Please be seated. Mr. Anderson, do you have any objection to the manner in which I read the jury instructions?
No.
Mr. Trofasi, do you?
No, sir.
All right. The alternate juror forms, or the alternate, I don't know what you call this. The jurors selected for 12 the 12 jurors selected for deliberation are listed on the form if either of you need to see it. The clerk has it. You may look at it. Before we adjourn, attorneys, please stay close by in case there are questions. I do want to compliment both of you, actually all of you, on your conduct and demeanor during the course of this trial. It is difficult subject matter. It is difficult law to get your mind around. These were tragic events, traumatic events, and I thought you carried yourselves with dignity during these proceedings. And I think your clients, the victims, and the community should be proud of the way that you have administered justice today. You both have given this jury a lot to think about. We stand in recess.
All right. It looks like there's really nothing else.
Okay. On.
That's it, right? That's it.
Trip, is that right? Yes.
Okay, so the they're just the live stream from the news is just showing footage from the trial, from earlier in the trial. So we're at Verdict Watch. I'll go through questions and comments. I'm not sure what to do about this now. I guess I can go through some of the testimony. We never finished Ernesto or the police interview. I guess I could go stream that. But right now, let me touch on any Q&A we have. First, from the Law of Self-Defense members. Before I do that, don't forget our upcoming Law of Self-Defense Advanced class. Our advanced class is a full-day class taught live by me, streamed to you using Zoom, that teaches you everything you need to know to be hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. If Nicolae Miu had taken this class and acted accordingly, he would not be facing a life sentence in prison. He didn't do that. You should not make the same mistake. We only teach this class twice a year. So if you missed this April 20th class, it'll be October at best before we do it again. Can you afford to wait? Do you know when you'll be attacked? When you'll be compelled to defend yourself, your family, your property? That's not up to you. The bad guy decides that. Check it out at lawofselfdefense.com/advanced. We teach about self-defense, defense of yourself, defense of others, your family, neighbors, colleagues, strangers, like an active shooter event. We talk about defense of property, and there's many forms of property that have different degrees of privilege for the use of force. There's highly defensible property like your home. There's your car, occupied and unoccupied. There's temporary residences like hotel rooms, RVs. There's least defensible property like open, undeveloped land, like your pets. Believe it or not, your pets, members of your family. I know that's how you feel about them, but they are least defensible property. We talk about consciousness of guilt evidence, quite a bit of that in this trial, all the dissembling to the police. We talk about self-defense immunity. We talk about interacting with the police in the aftermath of a use of force event. We spend almost an hour on that alone. It's a much more subtle and complicated dynamic than you might expect. We talk about how you can develop your own customized, legally sound self-defense strategy that fits your circumstances perfectly, and a lot more. If you go to that website, lawofselfdefense.com/advanced, you'll see we have a list of over 100 very specific self-defense law questions we answer over the course of the day. Again, it's taught live. It's live streamed to you. Full day course, plenty of opportunity for Q&A. And this is the last week. We're still in the early registration period, 50% off when you sign up this week. Check it out at lawofselfdefense.com/advanced. Yeah, pretty short rebuttal, only about 15 minutes. Full of nonsense, but he didn't have much to say, really. Let's see. Yeah, one person's pretty easy to kill, but two people are much harder to kill. Two people much harder to defend yourself against as well. 13 people would be overwhelming, obviously. Kyle says, you won't get any letters from me on yellow legal pad and pencil regretting that I didn't know this stuff. Yeah, I get letters just about every month, folks, from people in prison, convicted to felonies, serving sometimes decades in prison. Somehow, after conviction, they manage to get a copy of my book. Somebody sends it to them. They read it, and they write me from prison on yellow legal pad and pencil, typically. Physical letter arrives at our work address with a stamp and an envelope and everything. And usually it's 10 or 15 pages, handwritten out, telling me their tale of woe and concluding that if they had known then what they know now, they wouldn't be in prison right now. And that's generally true. When I read what they have to say about their use of force event, generally they screwed it up. Not out of malice often, but just out of ignorance. They thought they knew where the legal boundaries were, but they were mistaken. That doesn't have to happen. Take our Law of Self-Defense Advanced class. By the way, if you have a conflict for Saturday, April 20th, and I get it, Saturdays are busy, especially in the spring, I would register anyway because we'll make the playback recording of the class available to all the students for 2 weeks afterwards. So you'll be able to watch it at your leisure over the following 2 weeks. Otherwise, you're waiting till October until we teach the class again. So don't do that. Register now at lawofselfdefense.com/advanced. Let's see. Cycle Boy says Wisconsin added the law that made it a hard stand your ground state in your car as well as your home 20 to 25 years ago when carjacking became prevalent. People got out of the car and still killed. Yeah, that makes sense. Elman says, it makes me sad. I'm in a duty to retreat state. I can't get out of here fast enough. I will tell you that if you're in one of the 11 duty to retreat states, they are very aggressive about targeting failure to retreat as a vulnerable point to overcome your claim of self-defense. They love that element of avoidance. Texas is a hard stand your ground state. So the jury is literally told you're not allowed to consider the possibility of retreat in evaluating the reasonableness of this claim of self-defense. Let's see. Bup, 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 bup. He didn't sound very confident, did he? The prosecutor, Brian Smetstat, on rebuttal. He's got that shaking voice. By the way, folks, I think this is should be a clear win for the defense. This is self-defense every day of the week, at least in the context of the burden being on the state to disprove self-defense beyond a reasonable doubt. I don't see how they get there if we're applying reason to the law and evidence. But juries are dangerous and unpredictable creatures, and I never know what they're going to do. So I don't predict. Let's take a look at the poll. What have we got? Just over 800 votes. 15% guilty, 76% not guilty. That's certainly my sentiment. Not guilty on the basis of self-defense, of course. 9% are predicting a mistrial. Let's see. All these face characterizations, the smirking, the anger, he snapped. That was a good line by Corey Giraffacy, saying, to believe the state, you'd have to believe that this guy who's never even gotten a speeding ticket in his life, 15-year-old, heart patient engineer on the river with his wife and his friends, having a grand old time, decided this would be the day he would walk over and stab a bunch of people for no particular reason. Yeah, I thought that was a pretty good close by Giraffacy. What would I have added? I would have told the jury to start with the self-defense instruction. Although, in fairness, I think it might be blended in to the individual charge instruction. So that might be hard to do. I'd have to look at it again. I would be more specific. I would have been more specific about the subjective circumstances the defendant found himself in, that he knows he's a heart quadruple bypass patient. He knows he's exceptionally vulnerable to injury. He knows he's facing 2,000 pounds of opponents in 15 inches of water. He knows he can't outrun them. He knows even if only a subset of the 13 attack him, he's overwhelmed. And I would address the issue of the boys not having any weapons, saying they were armed. They were armed with their fists, and they were armed with the river. Just like Trayvon Martin was armed. You know, Trayvon Martin didn't have an artificial weapon on his person, but he was armed with his fists. He was armed with the sidewalk into which he was beating George Zimmerman's head, and he was armed with the gravity of the planet Earth that allowed him to keep Zimmerman pinned in place so he could inflict that sustained beating. Let's see. Yeah, Philip says, one thing I hadn't thought of, if this was the first high-stress, stare-death-in-the-face event from you, he was probably in shock and denial and very likely froze, which may explain a lot of his initial inactions. Yeah, I concur. Philip points out, Aristotle said, we become brave by doing brave things. I absolutely believe that to be true. That's me talking. If Miu has had no opportunity to practice being brave, it's likely to result in a suboptimal result. Yep. Let's see. I think a mistrial is very likely probable. I don't think it's probable because they have so many charges they've added. I think my expectation would be a compromise verdict if a mistrial is actually threatening. Kyle says, I've lived a life that defies the odds of violent encounters. I know what I'm capable of and how I am after the event. That and the political climate makes law of self-defense platinum and CCW safe and necessary sacrifice. Well, the fire trucks are going by outside my window. By the way, folks, if you like my legal analysis and explanations, and I presume you do, and that's why you're watching this, you might want to be aware that my legal practice is a consulting practice. I don't take clients directly, but I provide legal consult and analysis to other attorneys who are lead counsel on cases where their clients have been charged with a use of force crime, usually a felony. So I provide a legal consult, but we only provide legal consults to people who are members of our Platinum program. We don't take outside consults anymore. We haven't for a few years now. If you're involved in a use of force event and you'd like me to consult on your case, you need to be a Law of Self-Defense Platinum member. That's a higher level of membership. When we took outside consults years ago, they were a minimum of $10,000. We don't do outside consults anymore. I guess that's the bad news. The good news is if you are a Platinum member, you get that legal consult for free. There is no $10,000 minimum retainer. We just provide you with the legal consult. And the least expensive way we've ever offered to become a Platinum member is with this offer, our Platinum program webinar deal, where you get 5 years of Platinum membership coverage, plus every course and book we have to offer. This is just a sampling, $2,000 worth of courses, educational material, 5 years of Platinum coverage, all for 82 cents a day. And then you get my legal consult for free. And that covers you not just for the trial. If there's a retrial for any reason, get the consult again. If there's an appeal, get the consult again. We are there with you until the entire legal process has been exhausted at no charge for you. If you need me to be an expert witness at trial and testify to the jury, it's all included in being a Platinum member. No charge. You can have all that for 82 cents a day, folks. lawofselfdefense.com/82 cents. The number is 82, the word cents. lawofselfdefense.com/82 cents. Check it out. We've never had a better offer than that one. Back to the Q&A. Let's see. Just about any conviction is going to be an effective life sentence, is correct. Kyle points that out. Even the battery's going to be no fun. The purported battery on Madison Cohen, but any of the others are going to be effectively a life sentence. Yeah, if there's an appeal, it's forget it. It's just not gonna happen. I mean, under normal circumstances, appeals result in meaningful relief for the appellant less than 1% of the time. Less than 1% of the time. So appeals, as I often say, appeals are for losers. First of all, they're for losers because that means you lost a trial, right? If you didn't lose a trial, you wouldn't be appealing. Also, the prospects for relief are so minuscule that it's a losing proposition. Yeah, I'm not sure how to do the best notification on when. Unfortunately, we probably won't get a verdict today. Yeah, and meaningful relief generally just means a new trial. The appellate court does not find you innocent, does not find you not guilty. I mean, 1 in a million times. So all you can really expect, a win on appeal just means you go through the trial process again. And I think these prosecutors would certainly prosecute him again. Yeah, it would be nice to get a verdict today. Let's see. So Wisconsin, I guess, is Central Time. So it's 1:30, 1:25 there right now. So they'd have to come back with a verdict in, 3.5 hours. Maybe. The trouble is, Some Karen on the jury might say, well, there's 29 pages of jury instructions. We better read through it all first. See if there's any new super chats. Super chats need to be $10, folks. 5 British pounds. What am I supposed to make of that? Let's see. Andrew Starr. Anthony Starr is a TV actor. Best known for probably The Boys, although I've never seen even a single episode of that. But he was very good in Banshee. The TV show Banshee was really good. But Andrew Starr, $10 super chat, thank you very much, says, this isn't what the justice system is supposed to be. The prosecution is just blatantly dishonest, and it seriously sickens me. I don't want to be a part of this system anymore. The judge should be ashamed. Well, this is how the system works. Elected district attorneys have enormous discretion. By the way, this defendant's been in jail for 21 months. So even if he's found not guilty by the jury today and is released a free man, he still served 21 months in jail. I guess he lost a lot of weight over it. So fairly egregious. All right. So what else do I have here? Can we get back to Ernesto? Do I still have that up? I do. So while we're waiting, I guess I'll pull up Ernesto's testimony. This is from day 5, last Friday of the trial. We can catch up on that for a bit.
Members of the jury, welcome back. We're ready to resume the afternoon with the attorneys, Mr. Miu, all of whom are present. Thank you for your patience. Sometimes during the course of the trial, unexpected things come up. One did, and I had to meet with the attorneys to sort out the solution, which we have reached.
I should mention this is at 1 1/4 speed.
And we're ready to continue. Please be seated. Members of the jury, welcome back. We're ready to resume the afternoon with the attorneys, Mr. Miu, all of whom are present. Thank you for your patience. Sometimes during the course of a trial, unexpected things come up. One did, and I had to meet with the attorneys to sort out the solution, which we have reached, and we're ready to continue. Mr. Chaguez, please retake the witness stand. You're still under oath.
This is the defendant's best friend, Ernesto Chavez.
Mr. Anderson.
Ernesto, you recall you said you don't know if you said to the officer on shore that Nicolae said they took his knife.
Yes.
May I approach?
Yes.
I can't help but laugh every time they translate C. The Spanish translator translates C to yes, and then sometimes translates no to no. Let's see. Someone's asking about jury instructions. I guess I can cover those. Again, let me pull it up. Just the self-defense ones. I'll pull them up on Lexis, so we have the official. So you know I'm not making stuff up. We wouldn't want that. Do that before we get to Ernesto. All right. So, Lexis, of course, is a professional legal database of statutes, case law, jury instructions, and so forth. It's what lawyers use for legal research purposes, and it's expensive. Costs thousands of dollars a year for my Lexis access, but I'm happy to share it with all of you. So, Wisconsin Jury Instruction Criminal 805 is the self-defense privilege, force intended or likely to cause death or great bodily harm. So they'll have a different jury instruction for non-deadly self-defense. This is for deadly force self-defense. Let's see, 805, it reads, self-defense is an issue in this case. The law of self-defense allows the defendant to threaten or intentionally use force against another only if, one, the defendant believed that there was an actual or imminent unlawful interference with the defendant's person. So actually, before I do that, I often talk about the 5 elements of self-defense, right? Innocence, imminence, proportionality, avoidance, and reasonableness. So let's look for them in the statute. Innocence meaning you were not the initial aggressor or provoker. Imminence meaning you're defending yourself against an attack in progress or immediately about to happen, not a past threat or a speculative future threat. Proportionality is built into this jury instruction. It just means you can't use deadly force in self-defense unless you're facing a deadly force threat. Avoidance, whether or not there's a legal duty to retreat, we'll talk about that separately because Wisconsin has a separate jury instruction on the issue of avoidance. Also a separate one on the issue of provocation. We'll cover that as well. And then reasonableness, you need a subjective, genuine good faith belief in the need to act in self-defense, and that belief has to be objectively reasonable. So when we look through these bullet points, notice there's only 3. There's not 5 bullet points. That's in part because it's common for states to do sloppy drafting and combine what should have been distinct elements into one bucket. It's just sloppy. But here, the first one, the defendant believed, so that's subjective reasonableness, right? What the defendant believed, that there was an actual or imminent, that's obviously imminence, unlawful interference, that means it's not a lawful interference. So it's not the defendant being the aggressor and somebody lawfully responding. An unlawful interference with the defendant's person. And the defendant believed, more subjective reasonableness, that the amount of force, proportionality, the defendant used or threatened to use was necessary to prevent or terminate the interference. And the defendant's beliefs were reasonable, meaning objectively reasonable here. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm. That's proportionality, right? Deadly defensive force only when facing a deadly force threat. Determining whether the defendant's beliefs were reasonable. A belief may be reasonable even though mistaken. So we're not required to make perfect decisions in self-defense. We're required to make reasonable decisions in self-defense. Quite a different matter. So you can be factually mistaken about what's happening, and your use of even deadly force in self-defense can still be perfectly lawful. So a belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offense. So when the alleged offense, of course, is the use of force event. The criminal charge, that's the use of force event. Here, the stabbing. So what the jury is being told is you have to judge the objective reasonableness of the defendant's decision-making in stabbing at the time of the stabbing. Not a minute earlier or 2 minutes earlier or a day earlier, but at the moment he's making the decision to use that defensive force. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the viewpoint of the jury now. And then they reference retreat and provocation. I'll talk about those separately. Those are jury instructions 810 and 815, respectively. State's burden of proof. The state must prove by evidence which satisfies you, the jury, beyond a reasonable doubt that the defendant did not act lawfully in self-defense. Now, importantly, that doesn't mean the state has to disprove self-defense in its entirety. It means the state has to disprove any one of the required elements of self-defense, because these are cumulative elements. All the required elements, each and every one of them is obviously required. You could have, imagine all 5 of these elements are required. You could have 4 of them that are 150% in your favor, but if the state can disprove any single one beyond a reasonable doubt, your claim of self-defense collapses. Jury decision, if you are satisfied beyond a reasonable doubt that all elements of the crime have been proved and the defendant did not act lawfully in self-defense, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. So that's the deadly force self-defense jury instruction for Wisconsin. Now let's take a look at the issue of retreat under Wisconsin law. Again, here we go. There it is. Jury instruction 810. You add the following to the self-defense jury instruction when supported by the evidence. That's generally true for all jury instructions. You don't want to be giving jury instructions not supported by the evidence because you just confuse the jury. On the issue of retreat, Wisconsin jury instruction 810 says there is no duty to retreat. However, in determining whether the defendant reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether the defendant had the opportunity to retreat with safety, whether such retreat was feasible, and whether the defendant knew of the opportunity to retreat. So first of all, there's no duty to retreat. Wisconsin is a stand your ground state. Second of all, retreat's only ever relevant if it can be done with complete safety. You're not required to increase your jeopardy in an effort to retreat, and if retreat is feasible, meaning practical. So in this scenario with this defendant, he did back off from these boys. And what did they do? They pursued him. So is practical retreat possible in a river from people half your age who have not had quadruple bypass surgery? Also, whether the defendant knew of the opportunity to retreat. So what was the defendant's perception here? The state talked about, well, you could see open water behind him. Does that mean the defendant knew that, or was he focused on the apparent threats in front of him, the 13 apparent threats in front of him? And that's a very short jury instruction. This one's a little longer. 815 has to do with provocation. Provocation is a way to lose the element of innocence. So if you unlawfully provoke an attack upon yourself, you lose the element of innocence. You can't justify your response of force as self-defense unless you regain your innocence for self-defense. So, jury instruction 815, the privilege of self-defense not available to one who provokes an attack, and also regaining the privilege of self-defense, even if you did provoke the attack. On the issue of provocation, the jury should also consider whether the defendant provoked the attack. A person who engages in unlawful conduct, which, by the way, doesn't necessarily mean criminal. It could also be tortious. So civil level liability is still against the civil law, still unlawful. Unlawful conduct of a type likely to provoke others to attack, and who does provoke an attack is not allowed to use or threaten force in self-defense against that attack. So provoke the attack against yourself. You can't claim self-defense except, however, if the attack which follows, so we're presuming here a non-deadly force attack. If the attack which follows that non-deadly provocation causes you, the defender, to reasonably believe that he is in imminent danger of death or great bodily harm. So you provoked non-deadly, but the response is a deadly force response. It's a disproportional response. That's an unlawful response. A deadly response, deadly force response to a non-deadly force provocation is unlawful. An unlawful escalation starts a second fight in which the other party is the deadly force aggressor in that second fight. So, start again. However, if the attack which follows the non-deadly force provocation causes the provoker to reasonably believe that he is in imminent danger of death or great bodily harm, he may lawfully act in self-defense. but he may not use or threaten force intended or likely to cause death unless he reasonably believes he's exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm. So what is this saying? You're a non-deadly force provoker. The other party responds with deadly force. You're allowed to act in self-defense against that deadly force, but you've reacquired a legal duty to retreat if that's safely possible. Remember, normally in Wisconsin, there is no legal duty to retreat, but you regain that legal duty to retreat. A failure to retreat becomes a point of attack for the prosecutor if you were the initial provoker of the fight. Again, if retreat is safely possible. Another facet of provocation, a person who provokes an attack may regain the right to use or threaten force if the person in good faith withdraws from the fight and gives adequate notice of the withdrawal to his assailant. Now, the adequate notice provision here, it's not like you need to send them a notarized letter. Usually the notice, it can be verbal. Hey, man, I don't want to fight, right? That would do it. But often it's constructive notice. The way you're conducting yourself just makes clear that you don't want to fight anymore. Often it's just walking away from the confrontation, like this defendant did after he falls onto the tubes at the beginning of the video. Another provision of provocation, a person who provokes an attack, whether by lawful or unlawful conduct, with intent to use such an attack as an excuse to cause death or great bodily harm to another person, is not entitled to use or threaten force in self-defense. This is a particular kind of provocation called provocation with intent. This is where someone says, go ahead, throw the first punch, I dare you. But they're doing that with the intent that once you throw that punch, they'll kill you, and then claim to have acted in self-defense. That's kind of an aggravated form of provocation. If you do that, you cannot regain your privilege of self-defense by withdrawing communication. You own that fight forever if you're a provoker with intent. Yeah, that's the take your swing narrative. All right. So those are the self-defense related jury instructions. I'm not going to read the jury instructions for first-degree murder and second-degree murder and first-degree attempted murder and second-degree attempted murder and first-degree reckless manslaughter, basically, and first-degree reckless endangerment and second-degree reckless manslaughter and second-degree reckless endangerment. Would be tiresome, especially since in this case it doesn't really matter. There's no doubt that if it wasn't self-defense, it is those crimes. So we talk about intent. Your intent is inferred from your conduct. If you stab somebody with a knife, it was funny at one point on a rebuttal, Prosecutor Brian Semstad says, well, we know he intended to kill him because he stabbed him in the heart. If he didn't intend to kill him, why didn't he just stab him in the belly? You stab someone in the belly, it's still deadly force, folks. And the jury is instructed that they can infer your intent from the probable outcome of what you're doing. All right, so back to Ernesto from Friday. Okay.
I'm going to show you a transcript. Can you just take your time and look at that? Read through it enough to see if you know what it is.
Want me through everything?
No, does it appear that it's a transcript of your conversation with the officers at the shore?
Yes.
Okay. No, I'm just going to show you. Can you read that? No, just read it yourself.
Yeah.
Okay, down here. I'll just read it.
Yeah, I got it.
He said that somebody took his knife in his pocket, right?
I said I don't remember, but if that's what I say, it's okay.
Are you saying you don't think?
I don't remember.
Okay.
Yes.
I'm going to turn on the volume a little bit. Well, here we go.
But you remember somebody pointing and walking towards you?
I don't remember.
Didn't you testify to that? Somebody pointed and walked towards you and you told them to get back?
Yeah. Sí, eso sí.
Yes, that I did.
But you never told that to police, right?
Well, they don't ask me.
You never said it either, though, right?
So in that moment, you can say or remember everything you said. I answer whatever they ask me.
Can we? You also testified that, remember when I asked you if Nick said anything when he was walking by you on his way back to your group?
I don't remember.
And you said you weren't paying attention because you were looking at the guy who was walking towards you or the person?
Correcto.
Correct.
Okay, I want to go to some frames. I'll let the clerk know when I'm ready. You did, the officer never asked if somebody was pointing at him, anyone but at you, but you did say, I told Nick to come and he came and that's it, right?
Correcto.
Correct.
This is from the video. There's some graphic parts in it. This is 3291. I'm ready. I'm going to scroll and then I'm going to ask you some questions. On 3318, that's Ariel in the American flag shorts and black shirt, right?
Repeat that. Correcto.
Repeat that. Correct.
Correcto.
This is Nick here,
Correcto.
and this is you,
Correcto.
Correct.
and Nick is standing right next to you, and you're touching his arm.
Sí, cuando va pasando. Correcto.
Yes,
Okay.
when he was passing by.
Do you see anyone in this frame walking towards you?
Ahí en ese momento no veo, en la foto no la veo.
Okay.
At that very moment in that picture, I don't see anybody.
How about here on 3322?
There is somewhere and there somebody's coming, it's pointing us. I don't see it there, but I saw that day.
Okay. I've scrolled a little ways onto 3333. See anyone pointing or walking towards you?
No lo veo.
I don't see anybody.
Does it even look like anyone's looking at you?
En ese momento no lo veo.
I don't see anybody at that time.
But depende la parte del video o depende de la perspectiva de cómo se ha tomado el video cuando we was not, I don't see those people there. I was down there.
It depends on the time of the video or the point of view of the person who was taking the video.
Stopped at 3359. You can turn off the screen. I'm going to go to another frame. I'm on 3471. That's you right here, right?
Mhm.
Mm-hmm.
And you're actually You're actually walking towards the camera.
See?
Nobody's approaching you or walking towards you.
And
No.
no,
Nicolae isn't in this, right?
No lo veo.
I don't see him.
Okay, you can turn off.
Guys, I want to speed it up to 1.5 because I don't need to take notes, and we may as well move through it quicker now that the jury's deliberating.
The screen. I'm going to go to another one. Okay. This is 3936. Is that you, Ariel, and Sergio on the top left?
¿Dónde?
Where?
Right here. Sergio, Ariel, you.
Yeah.
Yep.
See?
Yes.
You still haven't walked back to your tubes?
I don't remember.
Well, in the
He's
photo.
standing there, but in the picture, I don't know if it's after or before.
Sure. Okay.
Right?
You can turn it off. I have one more set of frames to ask you about. So this is 3936. I'm going to go to later in the video. I'm ready. Do you think this is what you were thinking of after Nick was long gone? This is you, right?
Yeah, that's me.
And here's a girl standing by a group of other women pointing at you from a ways away or in your direction.
I'm not sure, but this guy is coming this way from there. Probably one of the guys was in the middle. I said to him, stay there, stay there. The guy's behind the yellow picture.
This guy,
probably was that one. It was right here, right in the front. This guy right here.
This guy?
Here.
Right here?
Yeah, no, he's walking here in the picture. You can see he walked. When I say stay there, and he walked the other way. Well, in that time, he probably was right here on the my finger, something like that.
Let's keep going. We'll see. And you said before you didn't know if it was a man or a woman, right? Who was pointing, and then that you and walking towards you and pointing, and then
no, what's a man?
It was a man.
What's a man?
If it was here, it would have been after Miu. Nicolae was long gone, right?
¿Cómo?
It would have been
What did
after
you say?
Nicolae. Sorry.
Wait for the interpretation.
It would have been long after Nicolae was gone, right?
Yeah, but the person, when he started pointing me, empezó a señalar hacia nosotros.
Started pointing towards
It
us.
start when Nico coming this way. So that's what I'm saying. I'm not sure he was in the picture or whatever the video was out there. He has like he turned this way to the other people, but before he was a little more far and he put us.
So before, when I asked what did Nicolae say, if anything, to you when he passed you, you said he didn't know because the guy was coming towards you. Now your testimony is that it was later in the video. So do you know what he said to you or no? If anything, Nicolae?
I don't remember.
And you'd agree you got pretty close to where Nicolae was with the group, right?
¿En qué momento?
At what time? What moment?
I'll go back.
Just not very good lawyers, these prosecutors. Poorly phrased questions. It's confusing. I think Madison Cohen was swollen, just not in the face.
33-21. You got. You said what did you say you saw for injured people?
What question?
What did you see as far as injured people?
I saw some women the other side. That woman was behind, probably this guy. It was like in the middle of the river. And I say, what's going on? Because I don't know what's happening. I saw her and I say, what's going on?
Did you see this man here on 3321?
No.
And you didn't see Nick do anything?
No.
I don't have anything else.
Mr. Nelson?
We're in verdict watch. This is testimony from last Friday that I hadn't previously covered.
You were asked some questions about slide 3321 that's in front of you.
Yes.
Again, this is you.
See?
Yes.
Looks like you're reaching out to Mr. Miu, who's standing next to you.
Correct.
Mr. Miu is walking.
Yes.
He's walking upriver.
See?
Ariel in the flag shorts is walking upriver behind Mr. Miu.
En this moment, en este momento, en el video yo veo a Ariel.
At
Pero
this
before,
moment,
I don't remember what Ariel was.
in the video, I can see him, but before, I don't remember where he was.
I appreciate that. I'm not going to ask you about that. I'm going to ask you about this person here. Do you see the person in the two-tone shorts?
¿Quién es?
Do you see that person
Who
in
he is?
two-tone shorts?
I'm not sure.
I'm not asking if you know who he is. I'm just asking you, do you see the person that I'm pointing to in the two-tone shorts?
No.
Right now
No.
on the screen, do you see them?
Ahora sí, ahora sí.
Oh, now I do. Now I do.
Next to that person is a man in a yellow shirt.
Sí.
Yes.
I want to now ask you questions about slide 3922. Okay?
Sí.
Yes.
You haven't watched the video, have you?
Yes.
You
Yes.
agree that you have not?
No.
No.
Poor question on my part. Have you watched the video or have you not watched the video?
No.
No.
The screens, the slides that we're showing you go in sequential order. So the first one is 0. The last one is 4,819. Does that make sense?
Sí.
Yes.
I previously showed you 3321, and now we're showing you something later, 3922. Does that make sense?
Sí.
Yes.
I'm going to blow this up. In the upper left-hand corner, that appears to be you and Ariel and Sergio standing next to each other. Agreed?
Correcto.
Correct.
Pero,
But
and what I said before, in this moment, I don't see this is, si esto es antes o después del problema, porque I don't see the whole video.
I don't know if this is before
Pero sí
or
está
after the problem because I haven't seen the whole video.
If I were to tell you hypothetically, this is after, because we can see a victim or two victims or two people with injuries down. Agreed? Make sense?
Okay.
Okay.
And then over here, way on the right, you see this blur that may be a person without a shirt on walking from a different direction over to your group. Do you see that?
Yeah.
Okay. I'm now going to scroll through the forward in time, and I want to show you stuff, okay? I'm going to stop at 3953. Going to blow this up. Do you see somebody here on the left-hand side?
Yeah.
Is that a man in two-tone shorts that I had previously shown you?
Sí.
Yes.
Had that man ran up to you and then you,
So,
Wait, please.
I'll-
Objection sustained. Please rephrase.
is this the person that you saw come up to you that you pointed to say, go away?
sí.
Yes.
And as we move forward here in time, the person in the yellow shorts that was in a different spot before is there too, correct?
Sí.
Yes.
And then as we move forward to 4012, excuse me, you now see the woman pointing the finger at you, correct?
Correcto.
Correct.
That's what I'm saying. What's going on?
Understood. When you spoke to the police, was there a Spanish interpreter there?
No.
No.
Sometimes when you've spoken today, you've answered in English. Agreed?
Sí.
Yes.
Fair to say your preferred language is Spanish.
Español.
Spanish.
You know some English.
Sí.
Yes.
if you wanted to communicate something really important and make sure you were accurate, would you say it in Spanish, or would you say it in English, or would you say it in some other language?
Español.
Spanish.
Why?
Porque hay muchas palabras en inglés que tienen diferentes significados.
Because there are many words in English that
Y
have different
a la hora
meanings.
de uno contestar, puede ser que la respuesta no sea correcta.
And when one answers, maybe the answer is not the correct one.
Also, when you hear words, is it easier for you to understand the words spoken to you when the words spoken to you are in Spanish rather than in English?
Sí.
Yes.
You answer some questions about your knowledge about your friend Nick being from Romania. I want to ask you about that, okay?
Correcto.
Correct.
Do you know exactly when Nick Miu immigrated to the United States?
No.
Do you know what age he was?
No recuerdo.
I don't remember.
Do you know whether, in fact, he was or was not in the military at any point?
No.
No.
When you spoke with the police, you told them you thought he might have been in the military for the reasons that you said here, because communist countries sometimes require that, correct?
Mandatorio, sí.
Mandatory, yes.
You also told the police that you didn't actually know. You told them several times, I don't know, I don't know, I don't know.
Correcto.
Correct.
Do you have actual knowledge as to whether Nick Miu was in Romania and served mandatory service for his country?
No.
No.
Last area here, you said you were able to remember some things that you saw, but you couldn't remember everything that you heard. Would that be fair?
Yes.
Do you find it for you easier? Do you find it easier to remember things that you see, or do you find it easier to remember things that you hear?
Cosa que veo.
That I see.
That's all.
Mr. Anderson?
Is your testimony today important?
Súper importante.
Very important.
Sometimes you answer in English,
Oh, sí. Sí.
Oh, yes.
but you're also comfortable speaking in English.
A veces ya lo entiendo, a veces no.
Sometimes I understand it, sometimes I don't.
If you told the officer, he said that somebody took his knife in his pocket, that's something you can easily understand in English, right?
Repita.
Repeat, please.
He said that somebody took his knife in his pocket. You understand that in English, right?
I don't remember.
Do you understand what that means in English?
Sí.
Yes.
And if you told that to the officer 17 times, do you think you said that because you remembered it at the time?
I don't know how many times you say 70 times. I don't remember.
You want to see the transcript?
You can show me.
It's highlighted and there's numbers next to it.
Well, that's what I said, but I don't remember saying many times. I don't know.
Do you agree or not agree that you told the officer that 17 times?
I don't remember.
You don't remember that, but you remember something you didn't tell the police from almost 2 years ago?
What do you mean? ¿Cómo que algo que yo no le dije a la policía hace 2 años?
What do you mean? Something that I didn't tell the police 2 years ago.
This is a 13-page transcript, and there's 17 times on here where it says something about, he said they took my knife.
Objection, asked and answered, cumulative.
Sister, you said you didn't
Nothing else, Judge.
remember. All right. Thank you, Mr. Torres.
Señor.
My apologies. You are excused. You may step down. Whereas Chagwes? Yeah. Yes. That's the part I was missing.
Judge, we have one more witness. I don't know if you want to take a quick 5-minute break before we call the last Spanish-speaking witness.
Are the interpreters prepared to go forward? Good. Let's
Fine,
continue.
Your Honor.
All right.
Please raise your right hand. The clerk will administer the oath.
Do you swear that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth? please help me out?
Yes.
Please have a seat in the witness. Mr. Nelson.
Afternoon, sir.
Buenas tardes.
Good afternoon.
Can you tell us your name, please?
Ariel Chagas.
Ariel Chagas.
Ariel, do you know this man here to my right, wearing the blue shirt and the red tie and the green jacket?
Sí.
Yes.
Who's that?
Nick.
How do you know Nick?
Lo conocí por medio de mi primo,
I met him through my cousin,
Ernesto.
Ernesto.
Have you, how long have you known Nick?
Un poco más de 5 años.
A little over 5 years.
During that time, have you had an opportunity to observe his character, his person?
Sí.
Yes.
I'm just going to repeat the question. Observe his person, his character.
Sí, cómo no.
Yes, of course.
Do you consider him to have a character for peacefulness?
Sí.
Yes.
In fact, when the police talked to you about this, you even mentioned that to them, did you not?
Sí.
Yes.
I think when you spoke with the police, they used terms which you agreed with along the lines of,
Yes.
20 and
The objection is sustained. Next question, please.
you spoke with the police in August of 20 and 22 to a Spanish-speaking police officer. Do you remember that?
Sí.
Yes.
And I want to ask you some questions that that Spanish-speaking police officer asked you about your observations of Nick on that day, okay?
Okay.
Okay.
Just so we're clear, it's in August of 22 that the police officer is asking you questions about Nick in July 30th of 22. Does that make sense?
Sí.
Yes.
And do you remember the officer asking you if Nick was calm or angry on that day, July 30th, 2022?
No recuerdo si me preguntó eso o no.
I don't remember if the officer asked me that or not.
Let me just ask you this. As you sit here today, do you remember on July 30th, was Nick Miu angry or was he calm or did he have some other character or demeanor that you noticed?
No, solo él estaba calmado.
No.
Persona pasiva.
He was calm. He was calm.
Okay.
Hey, folks, I'm just seeing in the chat now, there was a question. I didn't see that pop up on my screen. But I'll address it. Let's see. Jury's back. Why is that not on my screen? How long ago was that? 5 minutes ago? Let me see. All right, let me see. Boy, it's pretty loud.
Second video.
Okay, looks like they're talking about the 9-second video, the initial Jawan Cockfield video. Apparently, the jury sent in a question about this, and now the parties are discussing it with the judge.
It's been played multiple times. It's only 9 seconds. The other video I don't think has been played in entirety only once. So I don't have any objection to the main video being played.
Mr. Trophacy.
Judge, if you may, if that's in the right seats, I apologize, but if it's played, I think it needs to be, they need to be brought into the courtroom and it
Yes.
needs to be played in here. That.
My judgment, the jury is entitled to see the evidence, and this has been a multi-day trial. There's lots of things to consider. There are lots of nuances in the jury instructions. So I think it's reasonable for the jury to re-examine exhibits. They can't have the video in the deliberation room, so they'll have to come out into the courtroom to see it. If the jury thinks that watching both videos will be helpful to their deliberations, they're entitled to see both videos. So we'll have them brought back in, and we will play them both. I'd like to have the videos played in chronological order. So we'll start with the 9-second video, watch it, and then we will move on to the next video. Now, when they come in, this won't be the opportunity for Q&A or
I expect the jury wanted to see the video is good for the defense. I mean, the video is the evidence of self-defense here.
or comment or discussion. The opportunity for persuading the jury is over. I may ask the jury if they want to see it again because it moves fast. So if they want to see it again, we'll play it again. But I'll be the one doing the questioning. Any questions about the process?
Who do you want to play in?
It doesn't matter.
I don't have my computer, so I'm happy to go get it, but.
I can do it.
Okay, so you'll play the video. I'll give you the cues to start.
And I'm sure Your Honor will, but I would imagine when they come in, Your Honor is going to tell the jury as well that this is not the time for questions and answers.
Exactly, right.
Excellent, perfect.
All right. We stand in recess until they come back.
Do I have time to go out or not? Should I wait?
You can, why don't you wait? I think
Okay,
this won't take very long.
Okay, fast forward a little bit. Yeah, I think the jury wanted to see this video is good for the defense. The more they hear the howling hyenas, see the defendant walking away from the boys and the boys following him.
All right, please be seated. All right, we are back in session. The jury is present with the attorneys and Mr. Miu. We did receive your request to see the Juwan Cockfield videos. This is not the opportunity for persuading you or for adding new arguments. So the attorneys are not going to comment. We're essentially stepping into your deliberations, but you are entitled to see these videos, so we're going to show them to you, but you won't hear from anybody else. We're going to start with the 9-second video because that was the first in time sequentially. We will play it from beginning to end. I will check and see if you want to watch it again. We can replay it. Once you're satisfied with that video, then we'll move on to the longer one. And we'll do the same thing. If you want to watch it a second time or a third time, we can. But we're going to run it from beginning to end in real time. Are you ready?
Yes.
All right, let's pull up the video.
Man, trying to have sex with little girls. What the hell?
Hold up. Start over, please.
Grown man trying to have sex with little girls. What the hell?
Come on.
I have to reset the system. You can't just play. Otherwise it's going to pick up everything. Okay. Bear with me a second. You ready?
Yes. All right, action.
Grown man trying to have sex with little girls. What the hell? What the fuck? Out! He's a raper. Whoa, whoa, whoa.
Anybody want to see it again? No hands. Let's move on to the next. One more time? Okay.
Grown man trying to have sex with little girls. What the hell? What the fuck? Out! He's a raper. Whoa, whoa, whoa.
Anybody else? Okay. Let's move on to the next video then. You can keep it up.
That's facts. What is he on? Whoa! 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 Get away! Whoa! Oh God! We up! We up! Homie. What are you talking about? What the hell are you talking about? What? Get away from us! What? What's going on with y'all, homie? He's on camera, tripping. He's on 4K. Yo, them new iPhones got that good quality. What did he say? Yeah, what the hell? Who is this? Yes, yes, yes. For the culture! For the culture! Who is that? For the culture! Who is that? Who the hell is this?
Go! It doesn't matter.
He said he was looking for little girls! He said he was looking for little girls! Yeah! That's exactly what he said. Weirding us out. I even have that part on camera. Did I? Some young ass kid. What the hell is this guy's problem, bro? We trying to have fun. If he's gonna claim you, he's gonna claim you. Weirdo on this motherfucker. That is on camera. That is on camera. He on camera. Oh God. Oh God, he on camera. Oh God, he on camera. He ain't a woman. He ain't a woman. You ain't a woman. He ain't a woman. You killed him.
What the fuck? What the fuck? What the fuck? He's dying. He's dying, bro.
Wait, what?
Oh my God. Oh my God. Oh my God. Oh my God.
Are we serious? Is this real?
Oh my God.
Who is that?
Oh my God.
Oh
my God.
Is this real? Is this real?
Oh my God. Oh my God. What the fuck?
Is this real? Is this real?
Bike. Bro, bike. Bike.
That's not bike. That's not bike. That's not bike. That's not bike. That's not Isaac. Oh my God. Oh my God. This isn't real. This isn't real.
For the culture.
Anybody need to see it again?
Yeah. Yeah, play it again. Yes, please.
The entire, or do you want to stop it at a certain point?
I'd like to stop. I'd like to see the beginning, the middle, but not very end.
Not the very end?
By the way, some people are wondering, I see, why they have to bring the jury back into the courtroom to watch the video. Why don't they just give the jury the video in the deliberations room? The reason they don't do that is there's a concern that the jury might give, I know this is going to sound weird in this case because this video is such decisive evidence, but the jury might give the video undue weight by watching it over and over and over again. It's not like the jury has the opportunity to watch video of the witness testimony over and over and over again. So they, with the digital media, they just want to make sure the jury doesn't do that. So they can ask to see it. They'll come into the courtroom. The judge will play it for them. They're entitled to see the evidence. but they don't want them to just be watching it on a loop for hours and hours. I would suggest that every time the jury sees this video, it's helpful to the defendant.
Let's take the video down. Mr. Anderson, if you can get the video, no, put it. I can see it on my screen. They can't see it up there. Put up the video, and I'd like to get it to a point where I can end it. But I want to see it first so I can tell you where. I can't see it.
Oh.
My mistake. More. That's it. So it's about 2 minutes, 25 seconds, 27 seconds. All right, let's put it up.
That's fact. What is he on? Whoa! Get away! Whoa! Oh God! We up! Homie. What are you talking about? What the hell are you talking about? What? Get away from us! What? What's going on with y'all, homie? He's on camera, tripping. He's on 4K. Yo, them new iPhones got that good quality. What did he say? Yeah, what the hell? Who is this? Yes. For the culture. Who is that? For the culture. Who is that? Who the hell is this?
Go. It doesn't matter.
He said he was looking for little girls. He said he was looking for little girls. Yeah.
That's exactly what he said.
Weirding us out. I even have that part on camera. Did I?
Some young ass kid.
What the hell is this guy's problem, bro? We trying to have fun. Is he gonna claim you? He's gonna claim you. We don't want this motherfucker. That is on camera. He on camera. Oh God, he on camera. He ain't a woman. You ain't a woman. He ain't a woman. You killed him.
That's where we're going to stop it. Yeah, thank you. Anybody else need to see it or a different part? Everyone's good? All right. The jury or the bailiff will take you back. Please continue your deliberations.
All rise for the jury.
For the colon in the water.
Be seated. Mr. Anderson, anything for the record?
No.
Mr. Trofasi?
No.
All right, that's all. We're in recess. You have the jury list.
All right. Take a quick look at the poll. I left it up. It hasn't really changed. 17% guilty, 75% not guilty. and 8 people predicting a mistrial. I would be surprised by a mistrial because they have all these lesser includeds now, all these reckless charges. I would expect a compromise verdict. And we're back to live.
Yes. So you were preparing for your stumble.
All right. I'm not sure how best to set this up so I don't miss stuff in the courtroom like that. Thank you to everyone in the chat for alerting me. I appreciate it. I'll try to do a better job. Let's see. Take a quick look at, see if there's any comments other than people yelling at me to pay attention to the comments. All right. Let's see. Yeah, I think the I much prefer it when the state has to come up with, argue, and defend one theory of the case. What do they think actually happened here? And not be given the option of, hey, we'd like you to find him guilty of murder, but if you don't buy that, here's second degree. And if you don't buy that, here's first degree reckless. And if you don't buy that, here's second degree reckless. And let's just throw in a battery charge too. A misdemeanor battery charge. If the state thinks they know what happened and they can sell it to a jury, that's the argument they should make. Let's see. Bup, 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 bup. I mean, I guess we can just watch Miu's testimony again. Whoops, not that one.
If I had better shoes, I could walk better, but I could still walk.
If you had better shoes, you would have been able to run up on them faster.
No, I mean, I could walk better. I wouldn't stumble. I wouldn't have a hard time walking.
All right, we're going to watch the video again, and I want you to, if you can, point out for everybody where you stumbled.
What is he on? Whoa! 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 Get away!
Did you watch it?
Yes.
So the stumble, is that something you remember or something that you think you see in the video?
Something I remembered.
After you grabbed onto their tubes, stopped them, walked around their tubes, you took a few steps downriver and stood in the path they were floating in, right?
Has to form multiple. Overruled. You understand the question, Mr. Miu?
For a brief moment.
All right, keep going. Stop. At that point, you had the entire river open to move in any direction, right?
Right.
You chose to just walk a few steps directly downstream from where their tubes were, right?
Correct.
The boys were yelling at you at this point, right? You remember that?
Yep.
They were making a commotion. right? They were loud,
Mm-hmm.
and that attracted the attention of the folks in the Carlson group, right?
Mm-hmm.
You've testified that Maddie Cohen walked over, right?
Yep.
You walked towards her.
Yes.
And the water level at the spot that you had contact with Maddie was about ankle deep from the video.
From the video, yes.
And you told Lieutenant Hard you were standing in really shallow water, right?
Yep.
Maddie told you to leave the area, right?
She didn't say it that way, but yes.
She said, go, go, go.
And?
She swore at you too, but she was telling you to go, right?
Yeah.
You didn't go.
I was trying to communicate with her what I was doing in the river.
You didn't leave, right?
No, not down the river.
Hold on. Overruled. It's relevant.
You did not leave, right?
I
At the
didn't
time
go
that
in
she
the
came up
direction.
and,
No,
when she came up and said, go, 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 you chose to stay, right?
I wanted to talk.
You didn't like that she was yelling at you, right?
I only had like 2 or 3 seconds of direct verbal or whatever.
And you clearly didn't like she was swearing at you, right? And what you told her was not that you were looking for a phone, but that these boys took your goggles, right?
I don't remember what I told her.
If it's on the video, did you say it?
If it's on the video, yeah.
You never mentioned you were looking for a phone.
I don't remember my conversation with
And
her.
in fact, after you told her that they took your goggles, you never said another word, right?
After that?
Right.
Of course I did.
Talking about your anger scale, at the point where Maddie Cohen was yelling at you and pointing at you and swearing at you, where was your anger scale?
1.
And even with your anger scale being only 1, you started touching, fidgeting with the knife in your pocket, right?
I don't remember that.
Let's take a look at the video. We're ready. It's timestamp 135. That's you touching your knife in your pocket, right?
Correct.
And at this point, you've got your back to the 2 girls who were yelling at you, right?
It's possible.
So even though you were fearing for your life, you turned.
Not what you said at that time.
Overruled. Let's get the question out.
You turned your back on these folks, right?
Where am I in that location as reference to the other people?
I get to ask the questions at this point.
This is another example of it's always the wrong choice. Whatever you do is the wrong thing. If he had the knife down by his waistband, that was the wrong thing. They want him to have brandished the knife. If he'd brandished the knife, they would have charged him with brandishing. If you use hollow point ammo, the prosecutor Binger says you should have used ball ammo. If you use ball ammo, he says you should have used hollow point ammunition. He turns his back on these aggressors. He'll have to defend himself against, and that's the wrong thing to do. That shows he was not in fear. If he hadn't turned his back, he would have failed to walk away.
Right? Okay.
All right.
You're back at the 135 mark that we just watched. You've turned your back on these folks, right?
Okay.
Is that true?
Yes,
You
I
saw
see
it,
that. Yeah.
Right? You're touching your knife, but you got your back to him, right?
I see that in the picture.
And so at that point, you wouldn't have turned your back on these folks if you had fear of them, right?
Objection mischaracterizes his testimony.
Overruled. You can answer the question. Yes.
Noisy.
We'll play a
Mr.
clip
Smith,
here.
next question, please.
We're going to play a clip here, Judge. Go back. We're starting at 126. Just play it. We can have the screen. Stopping at 135. So in that clip, that's the point where you had waved at your friends, right? You had turned your back on the groups of people that were in the area, and you're touching your knife, right? And at that point, you called out to your friends because I think you had said, and maybe I'm wrong, that your fear scale was going up at that point. Is that not right?
I see lots of people around me, and I wanted somebody to be on my side.
Right. Your fear scale was going up, so you tried to wave your buddies over, right?
Creeping up, yeah.
And as it's creeping up, you're fidgeting with your knife.
It appears that way.
At some point, and even though your fear level is creeping up at that point and you've called for help from your friends or at least waved for help, you turned your back, right?
Yes.
At one point, you turn your head and you stare at the group of 17-year-old boys, right? Do you remember doing that?
I don't remember it, but if I could see a video.
Put it into context, it would have been at the point when Maddie Cohen tried to turn you away from those boys. Do you remember doing that?
Yes.
And 1 second. If we can get the frame up. We're at timestamp 116. That's the look that you gave to those boys, right? At that time, at 116?
Yes.
That's the look on your face.
Yeah.
That's an angry look.
Not to me. I was annoyed, more than frustrated, but not angry.
At the point where you looked at the boys with that expression on your face, whatever it was, you had the entire river in front of you open to walk to, right? That's true.
Correct.
And instead you chose to turn back around where Maddie Cohen was, right?
I stood my ground. I basically stayed in the same location.
Right.
I didn't go towards anybody at that point.
You didn't take a step away either, did you?
No.
And at that point then, that's when Riley Madison joins her. And you've got Madison and Riley standing in front of you, right?
I suppose that's the time, yeah.
Two girls.
Yeah.
And these two girls standing in front of you touched your shoulders somewhat, right?
Mhm.
You never said yes?
Yes,
You never stumbled backwards or anything like that?
it wasn't somewhat, but
Well, let's take a look at the video. We're going to start a little bit earlier than the part I wanted to start at. It's at the 135 mark again, if we can put this screen up. You take the screen down. Starting at 134. So at that point, you're touching your knife before Maddie and Riley are standing in front of you, right?
appears that way.
Stop. You had said that your fear level was rising.
Mhm.
You had waved to your friends, right? That was the look on your face at the time, correct?
Mhm.
You're smiling.
I'm confused.
You're smiling.
I'm confused.
You're not smiling?
That's not a smile.
Yes. Let's move on, please.
Can we get the screen back? All right, so you had been fidgeting with your knife multiple times. You've got Riley Madison in front of you. I believe her testimony was she's a 115-pound woman. You got Maddie Cohen on your other side. This is when you choose to pull out your knife, right?
Overruled. Understand the question?
What does her weight have to do with me?
Sir, you don't get to ask the
Oh, I'm
questions
sorry.
at this point. You pulled out your knife at this point with these two girls standing in front of you, right?
Yes.
And you held it down by your belt line, right?
Yes.
And you opened it up, right?
Yes.
And this is before you had been punched or anything like that. You had that knife ready with these two girls standing in front of you.
Objection as to use of the term girls or women.
Women, pardon me,
Mhm.
right?
Mhm.
And you didn't hold it up and say, hey, I have a knife, right?
To me, that would be a threat.
Well, I'm not asking you that. You did not hold it up.
No.
And you didn't, in fact, you held it down by your side, right?
Objection asked and answered.
Overruled.
Isn't that what you did?
Yes.
You didn't take a step back and brandish it and say, hey, back up, I have a knife, right?
Correct.
You opened it down low and then you held it down low by your side, right?
Correct.
And as you're doing that, you're smiling, right?
That's not a smile.
Well, let's take a look at the video.
I'm overwhelmed and annoyed.
And that's you holding your knife down by your belt line, right?
Yes.
When you pulled it out and opened it up, you held it with the blade facing up, right?
I didn't pay attention, but in the video, yes.
And it becomes important later when you stab AJ, because you didn't try to cut him down, you cut him up, right? Right?
That was not my intent.
Overruled. I believe the witness answered the question.
You had the knife blade up and you're saying you didn't know that?
I didn't pay attention.
As you're holding it there, you've got your thumb on the bottom of the handle, right? Right?
Yeah,
Blade up.
I see that.
Blade's pointing at, looks like at Maddie Cohen, right?
Yes.
Nobody else. I'll strike that. After you opened that knife, would it be fair to say that your fear level went down a little bit because now you had your knife open?
No.
Right. Was your fear level going up at that point? I think you said that earlier.
The whole situation was boiling up.
So when you have your knife open, you take a couple step backwards to get away from the situation?
I stood my ground. I stayed in place.
You never backed up one step, did you?
No,
You had your knife out and you were prepared to use it.
to defend myself.
At that point, there's nothing to defend yourself from, right?
I didn't know that.
If I understand your testimony today, now you're acknowledging that you did do something to Maddie Cohen, which started off this fight, right?
Objection argumentative.
Overruled. You can answer the question.
Objection, police probe.
Yes.
So I can't fast forward it. This is from his Miu's testimony yesterday. We're watching it. The news feed is playing it again. I was going to try to catch up on last Friday's testimony that I haven't covered, but then it's too hard to pay attention to that and to pay attention to the court feed. So here we are. While this is going on, see if there's any questions.
Mr. Smestad, would you please rephrase the question?
I will, Your Honor. You're testifying today that you did actually make physical contact with Maddie Cohen, right? Before you were punched or anything else, right?
I may have.
You don't remember that?
Well, I remember what I said, but I went over to push. She was right in my face, right in my space, yelling, and I could smell the alcohol in her breath.
But you had been drinking too, so it might have been your breath.
I didn't have vodka and all the other garbage.
My point is, today you testified that you did something physical to Madison Cohen before you were punched, right? Correct?
I don't know if I touched her or not. It's possible that I did.
If your friend Sergio testified last week that he saw you push her and she went flying back a couple of steps, that's what happened, right?
Objection as to form.
Sustained.
Were you present when Sergio testified?
Objection as to form and relevance.
Sustained.
After you pushed Maddie Cohen, only one person ever punched you, right?
From the video?
Right.
That's what I see. I don't remember what happened then at that time.
I'm not asking you what you remember. I'm asking what actually happened.
I got punched.
Objection, no foundation.
Sustained. Rephrase the question.
We
Start.
saw in the video that only one person ever punched you, right?
Yes.
Objection.
It's crossed. It's not
Hold
legal.
on. Yes.
Still 75% not guilty in our YouTube chats. For the upcoming April 20th Law Self-Defense Advanced class, I know a bunch of you picked the April 20th date when you became Platinum members some time ago. You'll get an email notification, kind of an e-ticket thing with the necessary link and all that a few days before, probably in about a week, a few days before the class. And if you're, if you want confirmation of that, you can always email support@lawofselfdefense.com, and they can confirm whatever you need confirmed.
Objection sustained. Let's move on.
Whoops.
You testified that you went down and you fell down in the water when you were punched, right?
Yes.
And you indicated, I think, that you were punched in your jaw, I think on your left side of your body.
Yes.
You testified that you fell back in the water and hit your head, right?
Yes.
You did not drop your knife.
No.
Right? You held on to it when you fell down into the water.
Yes.
When Dante Carlson hit you, he was holding a can of beer in one hand, right?
This is such a silly line of questioning.
He was fighting you with one hand.
He was fighting you with one hand.
You never suffered any kind of bruising or cuts to your face from this incident, right?
On the inside of my cheek?
You cut the inside of your cheek.
Yes.
Yeah, you never had any bruising on your jaw, right?
I don't remember. I mean, I had a beard. I couldn't tell.
You weren't bleeding from your face anywhere.
No, not that I know.
Let's play the video of him stabbing you.
Let's play the video.
Once you're knocked down in the water, AJ Madison comes up to you and pushes on your back, right?
Objection, no foundation.
Sustained.
We'll play the video. You were pushed in the back by AJ Madison, right?
Objection, no foundation.
Overruled.
In response, you got up out of the water, right?
Mhm.
You take your knife in your right hand with the blade up, right?
Objection is in narration.
Overruled.
That's what you did, right?
Still in my hand, yes, that way.
You jabbed it into his belly.
About the same time he hit me in the throat.
That's not what I'm asking.
Yes.
You jabbed it into his belly, right?
Yes.
Instead of pulling it out, you pulled up, right?
Because I had so much time to think about it.
You pulled up.
I did not pull up.
Okay,
Look at the angle of my arm.
We're stopped at timestamp 156. You see your knife?
Yes.
How close it is to his jaw, his chin?
Yes.
That's because when you stabbed him, instead of pulling out, you went up, right?
I was falling backwards with the knife in my arm, in my hand, and the angle of my arm was about the same. Just got hit in the throat.
In this frame of the video, the knife's pointing straight up, right?
Yes.
Went in, pulled up, and it's by the time you got done up by his face, your knife's pointing straight up.
Objection answered.
Overruled. You can answer the question.
It's straight up.
At that point, Tony Carlson came in to break up the fight.
Objection, speculation. He doesn't know what Tony Carlson's doing.
Overruled. You can ask the question. He can answer.
I don't know what he was doing.
You know that he told Dante Carlson to back up, right?
Objection, no foundation.
Overruled.
Do I know from video and from testimony? Yes. At the time, I didn't know.
After you stabbed AJ Madison, you were pushed back into the water, right?
Just sorry, it's AJ Carlson.
Pardon me. No, it's not. It's not.
AJ Martin.
It's AJ Madison. He's not part of the Carlson family. AJ Martin.
Thank you.
Pardon me. After you stabbed AJ Martin, you were pushed back into the water, right?
Yes.
Nobody jumped on top of you.
No.
Nobody was kicking at you or punching you.
No.
You're just in the water by yourself, right?
Apparently, yes.
We're going to take a look at the video starting at 1:55. That's you in the water, still holding your knife, right? Pardon me, this is before you got up. At this point, you're standing there. There's nobody hitting you, nobody's punching you, nobody's kicking you, right?
Objection, that's not what the video shows. He's not standing.
Gentlemen, please come up.
Mischaracterizing the evidence because the state just doesn't have anything really to work with. Whether a display of a weapon is unlawful brandishing or not depends on the purpose for displaying the weapon and whether people believe you.
Let's continue. Next question, please.
In any event, you were sitting in the water after AJ Martin pushed you over, right?
I landed on my butt in
Right.
in the river.
But at that point, the fight didn't continue. People weren't punching on you, right?
At that time, I couldn't tell what was going on around me.
That's at the point that Tony Carlson came over, was yelling at people to back up. Do you remember that?
From the video.
You don't have a memory of that in your head? He separated Dante from you, right?
Objection, no foundation.
Overruled.
Right?
If it's from my memory, I don't remember that.
Tony Carlson never punched you, correct?
Correct.
He never kicked you, never pushed you.
Objection.
Overruled.
No.
And you turned around and you stabbed him twice, right?
I couldn't see. I couldn't hear. I didn't know who was punching me, touching me, shoving me, nothing. I was fearing for my life.
You stabbed the guy who tried to break up the fight twice, right?
Objection. One.
Overruled.
That's what happened, right?
That's what happened.
And luckily for him, he was able to block your first stab. So you stabbed him again, right?
I had milliseconds to think.
Riley Madison, after you stabbed Tony Carlson, you turned around, you got up, you turned around, and you sliced Riley Madison through her left side of her body, right?
Yes.
She wasn't punching you or kicking you.
She came at me and she had her hands on me.
At the time you stabbed her, she had her hands on you.
Yes.
This 115-pound woman attacked you while you're standing there holding a knife.
She could have been 500 pounds. I don't know. I'm sorry, sir, but
You've never told anyone ever that Riley Madison attacked you and that's why you stabbed her, right?
No.
You're saying it today for the first time.
I don't remember this whole thing.
After you stabbed Riley Madison, Isaac Shuman tries to push you, right?
And he lands his hands on my throat. Yes.
But his hands originally weren't anywhere near your throat. They were on your shoulder and your chest, right?
I didn't take measurements, but yeah, from the picture, yes.
And as soon as he touches you, you stab up into his heart with your knife, right?
Objection, no foundation.
Overruled.
He went for my throat, and I defended myself. Yes.
Are you saying, we're going to look at the video. We're going to start at 2:02, and for anybody who doesn't want to watch, you might want to avert your eyes. Ready? We're at 2:05, the timestamp on the video. That's Isaac Shuman, right? If you
Right,
don't,
right.
his left hand on your arm, right?
Right,
His right hand on your chest, right?
right.
They're not on your throat.
In that particular frame, correct.
And your right hand is cocked, your elbow's bent, right?
Okay,
And you've got the knife in your hand.
yes.
Let's play it through, please. And as he's pushing you, you jam your knife up into his heart through his ribcage, right?
After he touches my throat and pushes me back, yes, correct.
As your arm is moving up to stab him, you actually moved his arm closer up your, farther up your body with your own movement, right?
I don't know how to answer that. I didn't see that.
At the time that this incident happened, you agree you weighed 248 pounds?
Yes,
Not one of these people that you stabbed so far in the video were armed in any fashion, right?
right.
You told an elaborate story about people pulling knives on you, right?
Objection, argumentative as to form.
Overruled.
Right? You made up that story?
To Brandy Hart?
Lieutenant Hart, yes.
I don't remember that, but I saw the video, yes.
At no point did anybody pull any knife on you, right?
Correct,
You're the only person who had a knife.
correct.
You had said earlier that you had waved for your friends to come over because you were so scared, right? Right?
During we're moving back in time now?
Oh, yeah. Earlier you had waved. We saw
Yes.
the video. You said
Yes.
you waved to your friends because
Yes.
you were scared. Your fear level was at whatever. And in fact, Ariel came over, right?
Yes,
And he's in the group at the point that Riley Madison's standing there bleeding into the river, right? He's
Yes.
standing right behind him.
yep, yep.
And at the time that you stabbed Tony Carlson, Ariel's right there, right in the group, correct?
I see that in the video, yes.
And when you stabbed Isaac Shuman, he's also standing there, right?
I didn't see him there at the time, but yes, in the video, yes.
So this narrative about it being 13-on-1, you had a friend there, right? Your friend was standing right there. He's in the video, right?
In the video. I don't remember him being there.
But you saw him coming, walking downstream.
I don't remember.
You waved for him, right?
I waved at my group.
At no point when you stabbed Tony, Riley, and Isaac, did you call out to your friend and say, hey, help me, they're attacking me, right? Even though he's in the frame and he's close to the action, so to speak. You never said that, right?
I was stunned. Couldn't talk.
The last person you stabbed was Dante Carlson, right?
Yes.
And this is in the sequence of events, everything else had happened, right?
Yes.
Sustained.
All the other stabbings had already occurred, right? At the point that you stabbed Dante Carlson.
Yes.
He wasn't punching you at that point.
I was surrounded. People were coming at me. I just came up a couple of times being punched in the head, punched in the mouth. I fell on river rocks. I was in pain. I was hurting.
Tony Carlson had broken up the fight between you and Dante never hit you again after that, did he?
Objection. That's sustained form. Please rephrase.
At the point that you stabbed Dante Carlson, he was not fighting with you, right?
Correct.
He had not punched you immediately before you decided to stab him.
Correct.
In fact, you took a couple steps toward him to stab him, didn't you?
I thought he was attacking me.
So at that point, you stabbed 5 people and you decided to leave the area. Is that true?
I walked away.
You walked up to Ernesto, right?
Yes.
You didn't say anything about being attacked, right?
I was in shock.
You said they took my knife, right? To Ernesto.
I don't remember that, but that's what I said according to all the video and.
Well, if Ernesto said that, that's what you
Yes.
said.
Yeah.
You still got the knife on your person, right? Even though you just told them they took your knife, you still had it. Right?
No. When I reached the tubes?
No. When Ernesto came walking up and you walked up to him, you told him they took my knife. It's the first thing out of your mouth, right?
I don't remember that.
Okay. Instead of walking to your group, you walked up to the south shore of the lake, of the river, right?
Yes.
And on the way, you washed off the knife in the river.
I don't remember that.
Well, you had blood on your hand and on the knife, right?
Yes.
When you left the area, right?
Yeah.
When you got back to your group, nobody saw any blood on your hands or, right?
Objection, foundation.
Sustained.
At some point, you rinsed your hand and the knife in the water, right?
I don't remember that. But, yeah.
What you do remember is throwing the knife up into the bushes on the south bank.
Right on the bank, yes.
And then you finally walked over to your group, right?
As I was walking, I threw it away, yes.
No, no. You walked out of your way to get to the south bank to get rid of it and then walked back across the river to your group, right?
Overruled.
That's what you did, right?
Yes.
We're going to play the video taken by Larry and Davis, Judge. It's grainy, but it's of some value.
He doesn't sound very confident about that. It's not of
Have
much
any more
value.
questions?
Yes.
Well, maybe this will be a good time to take a break. Let's recess and we'll come back at 2:50.
In that video?
It was not very clear, so I couldn't make
I
out
washed
who
my
was who.
knife in their
There's a
blood.
person wearing dark shorts with the same body type as you in the video. Is it you?
Objection.
Hold on. Sustained.
Well, we're going to watch the video. We're going to watch it through at full speed. Your screen's not out. We're going to play part of it, but slower, but not the end part. We're ready. What's the time? Yeah. This is at the very beginning. And Mr. Miu, do you see yourself in the left-hand side foreground wearing the dark shorts? Where the cursor's pointed?
I can't make out.
You don't know if that's you?
No.
Did anyone else on the river have the same body shape that you had at the time?
Objection, no foundation.
Sustained.
You've been in court since the beginning of the trial, right?
Correct.
You've seen all these people testify,
Yes.
the people that were all involved in the incident, right?
Yes.
At the time that you stabbed these folks, there wasn't anybody else in that area of the river that had the same body shape as you, correct?
Objection, no foundation.
Sustained. It's the same question.
You're aware that Dante Carlson's wearing shorts that are black on the bottom and light gray on top, right?
That's what I learned.
We're going to go through slowly.
Yes.
Bum, 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 bum. Yeah, so law self-defense member Philip in the chat says it's a perverse incentive system for DAs. They get elected or reelected in large part on their win-loss record and then how well they perform on high visibility public outrage trials like Rittenhouse and this one, hence the selectivity of charges and trials to get that high win. So it's two separate issues, right? The high percentage conviction and trial rates, 90%, 95%, 98% in federal court. That reflects that prosecutors can choose the cases they bring to trial. They tend to select the easy wins to go to trial, and they have tons of them. But most criminals are stupid. They're not that hard to convict. The prosecutor's job isn't usually very difficult. But it does mean they don't like to bring hard to win cases to trial. That's one of the things, of course, we teach at Law to Self-Defense is how to make yourself hard to convict. If you look hard to convict, you're much less likely to go to trial, much less likely to be charged in the first place. So that's one factor, which is beneficial to us if we do things right in self-defense. We're well within the legal boundaries. They have to disprove self-defense beyond a reasonable doubt. That's how we make ourselves hard to convict, an unattractive target for prosecution. It's a separate issue on the political nature, or politically energized or racially energized trials, because often those become win-wins. There's no way for the prosecutor to lose. So let's imagine like a George Zimmerman, Trayvon Martin trial. There was no real path to conviction. That was as clear-cut a case of lawful self-defense as I've ever seen go to trial. George Zimmerman literally made zero legal mistakes. He made a tactical mistake. He put himself in an ambush position and he got ambushed, but he didn't make any legal errors. But they prosecuted him anyway. Now, there's always some chance of getting convicted. That's just noise in the system. And the prosecutor knows this. So she knows there's really no legal merit to prosecuting George Zimmerman. But if she brings him to trial and puts him in front of a jury, there's at least a 10% chance. You just get lucky. You get a crazy jury, they convict him anyway, despite the lack of legal merit. But also in that case, that prosecutor, Angela Corey, elected prosecutor in Florida, she was running for re-election and she was going to lose. The polling was against her, in part because the black demographic in her district was against her. She had prosecuted 2 high-profile cases involving black defendants. One was a 13-year-old boy she prosecuted for murder. He did, in fact, commit murder. He murdered somebody, but it was an unpopular trial in the community. And she also prosecuted Marissa Alexander, who was portrayed in the media as a domestic violence victim who just fired a warning shot up into the air when threatened by her husband. In fact, she had an argument with her husband, and while he was standing next to their 2 small children, she left the kitchen where they were arguing, went into the garage, into her car, got a gun, came back, pointed it at his head, and fired it, and missed his head by inches. The bullet hole was in the wall behind where he was standing. Then she ran away. He called the police. And she ended up being charged with 3 counts of aggravated assault with a deadly weapon, which under Florida law at the time was good for 60 years in prison. That was an unpopular prosecution, and she was African-American. So was he. So were their kids. But now it was made to look like Angela Corey was prosecuting this, an African-American woman, domestic violence victim. All she was doing was defending herself. So that was unpopular. And there were protests being led by the usual suspects, large protests and marches against Angela Corey. She was going to lose. And then she had the opportunity to take over the George Zimmerman case and decided to bring it to trial. And of course, that was a very racially energized case. Now the marches in her district were not against her. They were for her. She was at the head of those marches. She was popular with her black community again, and she won re-election. Now, she lost the trial in the sense that Zimmerman was acquitted. But was that the reason she actually brought the case to trial? I would suggest she won the trial in the manner that really meant something to her, in that bringing the case to trial is what won her re-election. And she did get reelected. So the fact that she didn't get the conviction, I think she knew it was very unlikely she'd actually get a conviction on the law and the evidence in the Zimmerman case. But that wasn't her real purpose. Her real purpose was political capital, not justice. And in that sense, she won.
Objection sustained, lack of foundation.
In any event, after you got rid of the knife on the south side of the river, you walked back to the north side of the river where your group was in the at the sandbar, right?
Yes.
Sat in your tube? Did you sit down in your tube?
Yes.
Eric Williams from your group, realizing that people were hurt, left?
Objection, form, lack of foundation, that Eric Williams.
Sustained.
Did you see Eric Williams leave your group?
No,
At some point, did you notice he wasn't with your group anymore?
I didn't do a head count, sir. Sorry.
Okay. Did anyone else from your tubes go to help with the folks on the river that were hurt?
No foundation.
Overruled. You can answer the question.
I don't remember. I wasn't paying attention to anybody in my group.
When you went back to your tube, you put your shirt back on, right?
I was cold, yes,
And you put on your hat, right?
yes,
And your sunglasses.
yes,
Eventually, you saw police officers and emergency medical technicians show up on the river, right?
yes,
Wading up the river, right?
yes.
Trying to help people that had been injured, and
Objection, no foundation.
Overruled.
you saw that happen, right?
Yes,
You didn't approach anybody to say you were attacked, as far as law enforcement or EMTs or anything like that, right?
no, I just pooped myself. I was afraid to go in that area.
Even
I'm
though
sorry.
there's police presence everywhere, you were afraid to walk over there and tell them, hey, this is what happened.
Yes, sir.
So you got in your tube and you floated down the river.
Not immediately. We waited there. We had people, from what I learned, not that I remember, that called 911, and yeah, I don't remember any of that stuff. So I don't remember.
So do you remember waiting for Eric Williams to come back to join your group so you could leave?
I don't remember.
All right, do you remember saying, let's go? You yourself saying that?
Objection asked and answered. City.
Overruled. Overruled.
I don't remember.
Ernesto Torres, he's your best friend.
Yes,
You didn't tell him what happened as you were floating away?
I didn't talk to him. I don't remember talking to anybody. I don't even remember going down the river or up the river. I was just stunned. I don't remember anything.
You didn't tell Ernesto, I was afraid for my life and I did this?
No,
You never told Ernesto that I acted in self-defense?
I didn't. I don't remember talking to anybody.
You didn't say I was afraid they were going to kill me, these folks?
Objection, no foundation. The city doesn't.
Overruled.
I don't remember.
As you were leaving the area, you saw folks giving CPR to Isaac Shuman, right?
I didn't see that.
All right. Eventually, you made it down to Village Park where the exit was, right?
Eventually,
And there's some video of you relaxed in your tube, kind of playing in the water with your hand, right?
objection is to form.
Sustained.
Do you remember seeing the video of you
I remember seeing the video.
relaxing in your tube before you got back to the end?
Objection is to form.
Sustained.
Did you see the video or not?
I said I did.
When you got to Village Park, your group exited the river, right?
Yes,
There was multiple police in the area, right?
yes,
You saw a uniformed officer with his gun drawn, walking towards you, right?
right.
You didn't approach that officer.
I was afraid of everybody at
You were
that
afraid
time.
you were afraid of the officer?
I was afraid of anything and everybody. I was afraid of anything. I couldn't. I was still in shock, so I was afraid of everything. Yes,
You didn't approach the officer and say, they tried to kill me, I defended myself, nothing like that, right?
I don't remember saying anything like that to anybody.
You walked right by him, right?
All that is a blur. I don't remember it.
Once you got further up the path, though, other officers were able to pick you out of your group, right?
Apparently, yes.
They stopped you, right, before you could leave the park.
I don't remember that.
You don't remember the police stopping you and detaining you in the park after this incident?
I remember being stopped, but I don't remember the details.
Sure. You were aware that the police had a picture of you from the river, right?
Okay.
Do you remember that?
I don't remember.
Do You remember the police had to take your hat and glasses off to make sure that it was you in the picture?
Nope, I was focused on one thing only. Somebody with a bat that I've seen in the woods and across that whatever bridge, the little bridge, Rainbow Bridge, whatever. I was focused on him. I was very afraid of that person.
Did you ever say to the officer, hey, there's a guy over there with a bat and that's concerning me. Can you do something about it?
No.
You're put into a squad car, right?
Mm-hmm.
But yes,
Yes,
Sheriff Knudsen came over to make sure you were comfortable, right?
I saw that in the video. Yes.
You don't remember talking to Sheriff Knudsen?
No.
You remember him asking you, well, if you don't remember, you don't remember. We're going to play that video and then I have some questions for you. Your Honor, this is the longer version of the video that's been referenced. It's 1 minute and 59 seconds.
House, when you're ready.
Camera recording started.
Still doing all right?
Yeah.
Okay.
What's going
Temperature? Temperature's okay in here?
Yeah.
Okay.
I hear somebody got stabbed, and I fit the description.
Yes, you do.
All right.
Yep. So we're working through that now. Did you see that fight on the river?
I heard about it.
You heard about it?
Yeah, and I seen people gather around it.
Okay. All right.
And I went over to talk to see if somebody saw anything, but that's about it.
Okay.
Our whole group was pretty interested in finding out what happened.
Okay. And that's your whole group over there?
Yeah.
Okay.
So
All right.
I don't know. Okay, well.
Did you see anybody injured?
No.
You didn't see anybody injured?
No.
Did you see anybody fighting?
I heard people screaming at each other, yes.
Okay.
Yeah.
Screaming in anger or screaming in pain? Do you know?
Everybody's drunk, so I don't know. I can't tell the difference, but I would say, I don't know, just screaming.
Okay.
You know, yeah, calling each other names. But, you know, that's, I've seen that all day. And we've all been drinking a lot. I'm sure they're drunk. I'm sure they're doing, I don't know.
Okay.
Kids being kids.
Kids being kids. Where are you? Where's your group from? Where did you drive from today?
Oh, I drove from Prior Lake.
From Prior Lake.
Yeah.
Okay.
Actually, I didn't drive it. We came here alone.
Your wife and you? And you met the group here?
Yeah, but we know each other.
Okay. All right. As long as the temperature's good, I'll check back with you in a minute, okay? Thank you.
You lied to Sheriff Knudsen, right?
I don't remember that conversation. But yes,
You
I
told him that you heard there was a stabbing, right?
don't remember any of this stuff.
You're fishing for information about what happened, right?
I don't know what you could say I was fishing. I don't know.
You asked him some questions about what had happened, right?
Again, I don't remember this conversation.
But you were pretending that you didn't know what happened. Is that true?
No.
At the point that you were talking to Sheriff Knudsen and saying these things, you didn't know there was a video of what happened on the river, did you?
I didn't know whether I was dead or alive at that point.
But you also didn't know that there was a video, right?
No.
When the sheriff asked you what had happened, one of your responses was it was kids being kids, right?
I don't remember any of that conversation.
You just heard yourself say it on the video, though.
So
Actually, no foundation.
I'll move on. Prior to being taken to jail, you were transferred from that squad car that you were in to a different squad car, right? Remember that? You remember at some point, Deputy Thomason telling you that you were under arrest for homicide and attempted homicide?
I don't remember any
Don't
of
remember
that.
When you spoke with Lieutenant Hart, even though you'd been informed that you were being arrested for homicide, you pretended to know that, to not be aware that someone had died, right? Right? When you were talking to Lieutenant Hart, you,
Over here at the jail?
yeah,
I don't remember any of that conversation.
you don't recall pretending to not be aware that someone had died.
Objection assumes a fact.
Sustained.
When you're talking to Lieutenant Hart, that was about 4 hours after you had been arrested, right?
Yeah, that's what I learned.
And then you had time to put together a story, right?
No.
Overruled.
You had 4 hours to come up with a story about what happened on the river before you were interviewed by Lieutenant Hart, right?
No,
You didn't have that time.
I didn't put a story together.
Okay. So when you told her things like, 2 of these boys pulled knives on me, you're telling the truth?
No.
That was a story, right?
Correct.
And when you said that you somehow managed to grab one of the boys' arms and bend their wrist back and stab them with their own knife, that's a story you made up, right?
I told her what I remembered.
You remember doing that?
No, everything I told her is what I remembered at that time.
At the time you told her these things, you thought that you would grab someone's arm and stab them with their own knife?
As you can see, I was very confused.
Did you not testify earlier that you lied about the knife?
That I did.
And then nobody else had a knife on the river except for you.
That I lied about the knife.
So it's impossible then for you to have twisted someone's arm and stabbed them with their own knife, right?
I saw the video.
No, I'm asking what you said to Lieutenant Hart.
I don't remember the interview, but I saw the video. And
you're aware.
And I know that it's not right. It's not true.
Not just a couple of little lies, but lie on top of lie to Lieutenant Hart, right?
Argumentative.
Sustained.
Well, let's talk about some of the things you told her. You said, these boys took the goggles off my head and threw them down the river, right? You told her that?
If that's what the video recorded, yes.
All right. You told her that these boys tried to pull down your shorts, right?
That's what I saw in the video, but I don't remember the interview.
That's a detail you added for your benefit, right?
No.
You said these boys attacked you, right? You told her that multiple times, right?
I saw the video.
Did you say that or not? Yes or
I
no?
said that in the video. Yes.
And you knew that wasn't true, right?
So in the video script, then that we go by that, but I don't remember that interview.
And I think what you said earlier is that you were afraid you were going to die from being strangled, and that's why you stabbed Isaac Shuman in the heart, right? That was your testimony earlier? Didn't you say that today, this afternoon here in court?
Yes.
That's not anything you mentioned to any police officer, right?
If I didn't mention, I didn't mention it. I don't remember that.
That's not an important detail that you thought you might want to point out.
Objection argument.
Everything is every detail is important. We all know that. But I don't remember saying any of those things to Lieutenant Hart.
Because you didn't say them, right? That's why you don't remember.
Is what?
You didn't say those things to her. That's why you don't remember, correct?
I don't remember what I said or what I didn't say to her. I don't remember even having an interview with her.
So you can't remember anything about what you told her, but when Mr. Nelson's asking you questions, you can remember all these feelings you had at the time. Is that true? You remember answering his questions about how you were feeling that day?
The feelings I had when I was attacked?
And when you were meeting with the Lieutenant Hart.
Yes.
I don't think that judge goes to the gym. I also don't think that prosecutor knows how to push a plate away. Oops.
Testified today a lot about remembering what you were feeling that day, right? When Mr. Nelson was questioning you, right?
Mhm.
Is that a yes?
Yes.
But when you're asked other details that might not be so useful, you don't remember them, right?
Certain feelings and certain, they stick to you forever.
Ones
They
that are
affect you.
helpful to your defense, those stick to you, right?
Sustained.
You were examined by the jail nurse, the SART nurse, several hours after the incident, right?
Yes.
You never mentioned to her that you'd been strangled, right?
Didn't mention to her a lot,
Sure.
not because I intentionally didn't want to do it. I didn't remember. I was still in shock.
You didn't mention anything about your throat hurting.
I don't remember what I mentioned to her.
I understand. You never at any point told anybody other than today that you had a sore throat or your throat was sore from after this incident, right?
I didn't tell anybody.
At any point during the day after you were arrested, when you're interviewed with people, when the jail or the SART nurse is talking to you, you never once said, oh, my throat is sore because Isaac Shuman strangled me, right?
I don't remember what I told those guys either. I was, like I said, I don't remember lots of the interaction I had with anybody here at the jail.
But today,
Yeah.
almost 2 years later, you remember that the next day your throat hurt. That's
Yes,
what you
because
testified earlier.
yeah. And my back.
You can
still have-
remember that detail, but not the other details.
My back still hurts right now.
The SART nurse specifically asked you when she was doing the exam, where are you hurt? And you pointed out some things to her, right?
I may have.
Yeah, but you never once said, I had been strangled, I have an injury to my throat hurts, nothing like that.
I don't remember.
When she asked you what hurt, you said your butt hurt from the rocks. That was your response to the nurse, right?
Don't remember.
You had said that you're in poor health, or you were at least in poor health back on July 30th of 2022. You had your bypass surgery 2 years prior to that, right?
Mm-hmm.
Is that a yes?
Yes.
And typically people that have medical procedures like that are given restrictions on what they can do in their activities, right?
Yeah.
And you apparently weren't restricted from swimming, snorkeling, doing outdoor sports on a river, right?
I was for a while, but 2 years later, lots of the restrictions, I believe, got lifted.
Those restrictions got lifted because you got better, right?
You can say the doctor makes that decision, but he says if you feel a little better, do as much as you can.
Yeah, and you were in fact snorkeling and swimming and doing things that day, physical activities, right?
Snorkeling in 15 inches of water, I was mostly I didn't even snorkel. That was not a lake but I was my whole plan for the day was to just float down the river and relax.
You're able to run, at least you were back on July 30th of 2022, right?
Run.
You were able to run at that time, right? You weren't restricted from running.
I mean,
You didn't have a medical restriction to keep you from running, right?
no.
And in fact, you did run when you ran up on Isaac Shuman's group, correct?
You call that run? Okay. That's not a run, but I wasn't running. I wasn't allowed to run or do any activities like that, so I wasn't running.
At the time that this all happened, July 30th, 2022, you felt sufficiently healthy to go off on your own, away from your wife and your group, to go do snorkeling on your own, right?
It's what I felt.
I just want to check my notes. I think I'm almost done. We can have Exhibit 4, Item 10. I'm going to ask Investigator Schultz to actually handle it since it's evidence, physical evidence.
Can you retrieve the exhibit? Oh, what is that?
If investigator can approach the witness, Your Honor.
Yes.
We're showing you what's been marked as Exhibit 4, I guess Item 10. That's your knife, right?
Yes,
That's the knife you used to stab these people.
that's the knife I used to defend myself with. Yes.
I asked you earlier about when you stabbed Dante Carlson. You agreed that he was not attacking you at the point that you stabbed him. He was the last person stabbed, right?
He attacked me.
Earlier, when you stabbed him, Tony Carlson had already broke up the fight, right? You said you agreed to that earlier.
At that time, everybody that came in contact with me attacked me.
Anybody who looked at you?
No, anybody that came in contact with me, I felt attacked.
You felt attacked whether you're being physically attacked or not, right?
I was in the moment, so I felt attacked by anybody that had either previously attacked me or was approaching to attack me.
So you felt like you could stab folks who are not attacking you at the moment that you stabbed them.
Sustain. Sustain.
You walked up to Dante Carlson and stabbed him in the belly, right?
I did not walk up to Dante Carlson and stab him in the belly.
I don't have any other questions, Your Honor.
Mr. Nelson?
Jimmy, if you ask some questions about your fitness on July 30th, I want to ask you some questions about that, okay? Okay. Just maybe we can get it done in one question. Did you feel fit enough to take on 13 teenagers and adults in a fight by yourself without a weapon?
I didn't, no.
You were asked some questions about what happened with each of these people, right? And you were shown some stills.
Mhm.
Were you in court when, do you know how many frames are in per second of these videos?
I learned they're like 24, 25.
So one frame is a 24th of a second, is that right?
Correct.
When you were in that, let me play the video. I'm going to play Exhibit 2.
you connected?
I think so. Before I am.
Yeah, start over. I don't have anything on my monitor either.
That's not the screen I'm looking at, Judge. I apologize. My screen looks like that.
Screen is this, the library.
That was my, that's my home screen, but. Let me take another chance here, Judge, sorry. See what it looks like for a second. Okay, that's. I don't know, Judge, maybe I need to take a break. I'm looking at my screen and it shows the video, so I apologize. I'm flummoxed.
This is Exhibit 2.
This is Exhibit 2. I want to play it from the 150 mark where you, for 14 seconds. So.
In the spirit of cooperation, are you able to use your exhibit?
Sure. Apologize, sorry. I just started. The video, please. We can start the video at 150, just when he's. All right. Before we press play, Mr. Miu, do you see what's on the screen there at 149?
Yes.
Is that you falling backwards?
Yes.
I want to press play and ask him to stop it at 2:05, okay?
Okay.
Freeze plus play.
He ain't a woman. He ain't a woman. Dude.
Did you observe those 16 seconds or so?
Yes.
Were you, if there's 24 frames a second and we watch for 16 seconds, as you sit here now, are you able to break down exactly what happened in each of those 284 frames? I mean, do you have a memory of
No.
1/24 of a second
No,
for
absolutely not.
how, as far as time goes, if you can, and I apologize, but if you can, just put yourself back in that space for a moment.
Mm-hmm.
Can you do that?
Yes.
When you're back in that space, on that river, in that time, did you seem like you had
284 different chances to do different things and feel different things?
No.
How did time feel in that moment?
It was not real. Everything was not real. Time wasn't following the same rules.
When you
slow, very slow.
When you said you didn't have a memory of some of the details, but you had a memory of the feelings, can you explain, how is that?
So feelings are brought on by what's happening, at least with me. If you get hit in the head, that's a feeling of hurt. If you fall back and you hit your head, you fall back on River Rock and you get hurt, you feel pain. When you know you can't get away and you feel like you're drowning and there are people on top of you pounding you and holding you in the water, that's a timestamp in the filing cabinet that says this is what I suffered.
Do you exactly? Go ahead. Sorry to interrupt you.
Yeah, it's something I would love to erase from my memory, but unfortunately, there are lots of those feelings, very strong feelings I can't erase.
How confident are you in the accuracy of your feelings?
I know my feelings. I lived with my feelings for 54 years.
How about this feeling? How confident are you in the accuracy of this feeling? That
100% confident that is my feeling. 100% confident.
Even if you can't remember the details of everything you saw?
Correct.
Even if you can't remember the details of everything you heard?
Right.
Let me, because there were some questions and I want to just make sure we cover it, right?
Mm-hmm.
AJ Mark, do you remember each of these acts that you're charged with, each of these acts of stabbing?
No.
Do you remember the particulars, that is, I should say, the particulars of like X person did this or Y person did this or Z person did this?
No.
Do you remember, do you have any memory of just randomly stabbing people?
No.
What is your memory as to why you did what you did?
I was afraid for my life, and what I did, I had to do to defend myself.
Do you have a memory of stabbing anybody that didn't come towards you or attack you or touch you or push you or hit you?
No.
Did you ever just randomly go up and hit somebody?
No.
Do you have any memory of Tony Carlson trying to break anything up?
No.
Do you were asked about that, but I know there's some frames on that. Do you remember the frame in which Tony Carlson's coming up from behind and pushing you?
I didn't know who he was, but I remember being held in the water. I mean, it's a feeling that it gives me the nightmares, the trauma that was caused by that. That's the trauma that I remember.
There were asked some questions there at the end about the Larry and Davis video. Could you make anything out in there?
No, I thought I was looking at Sasquatch.
Do you remember anything about Dante? Dante Carlson is the person on the video previously that we saw here that had hit you. You know that, correct?
Yeah.
And he's the person in those two-tone shorts, correct?
Yeah.
Do you have a memory of how it came to be that you defended yourself against him that's not on the Jawan Cockfield video?
No.
You remember him coming up to you?
I remember lots of people coming on to me. I couldn't distinguish who. I don't remember color of shorts or anything like that.
Did you ever swing or hit the knife out of anger?
No.
Why'd you use the knife?
I use because I'm a mechanical engineer. I use it as a tool. But what I used it for that day, I used it to save my life for self-defense.
That's all.
Mr. Smestad?
So, Mr. Miu,
You hear over and over again that there was 13 people there and you're there by yourself, right?
Apparently,
But we
yes.
know that's not true because Ariel was behind you.
Objection.
Sustained.
13 people did not attack you, correct?
Looking at the evidence, correct. In the picture at the time, I didn't know that.
13 people were using words that you didn't like, right?
In action, right?
2 women touched you on your shoulders and arms, right?
They didn't just touch me on my shoulders and arms. You know that.
You were 250 pounds at the time, right?
Yes.
And these women touching your arms caused you to fear for your life?
They're not touching.
Objection.
Say objection.
That's not the evidence. That's not what we said.
Again, members of the jury, disregard what the attorneys say because what they say is not evidence. What the witness says is the evidence that you rely on. Next question.
You said the time slowed down for you on redirect, right? You said the rules didn't apply, time slowed down.
To me, at that time, everything felt different.
If time had slowed down, you would have time to consider your actions, right?
If it did slow down, yes. So I was wrong when I said it slowed down, but yes.
But that's what you said, right?
I understand.
You never told the SART nurse that you had been drowning, right?
Objection beyond the scope.
Overruled.
And good afternoon. We are back live with you from the Fox 9 Streaming Center. You're, of course, watching our gavel coverage of the Apple River stabbing trial right there. We came to a close with the black screen on you. That was Nicolae Miu, the defendant, of course, we now know, on the witness stand just yesterday. 3 hours. He answered questions from his own attorney, Aaron Nelson, cross-examined a very tough cross-examination from Assistant District Attorney, St. Croix County Assistant District Attorney Brian Smeestad. And now I want to just get you caught up as we near 4 o'clock Central Time. As you know, if you've been with us throughout the day, this jury, the Miu jury, got the case at 12:27. They left the courtroom. They were to have lunch and then begin the deliberations. It would not take much longer before they had their first question. They came back into the courtroom just before 2 o'clock, so about 90 minutes after getting the case, and they had asked to watch the cell phone video shot by Juwan Cockfield. Remember, he shot 2 videos, a quick 9 or 10 second clip, the first sort of interaction that's on video between the teenage Stillwater tubers and Nicolae Miu. And then, of course, the subsequent 3 minute, 20 second video that Cockfield continues to shoot that basically captures the entirety of the event. They watched that in the presence of the judge and the 2 parties, and then went back to their jury room to deliberate. The court called recess at 2:14. So what is that, an hour and 45 minutes later, and we have not heard from this jury since. I want to put up on your screen the jury makeup at this point as we now know it. It began with a panel of 14, 8 men, 6 women. The judge has now put 2 alternates basically on notice. They are not deliberating. 1 male, 1 female. We don't know the age demographics. The court has not specified the age demographics on who is not deliberating at the moment. But I do want to point out in Wisconsin, it's a little different than I'm familiar with in Minnesota. Standby. They have not been excused from this trial. So should anything happen during these jury deliberations and the alternates need to come in and then get up to speed and cast a vote and try to reach some form of unanimous consent on all these charges, one or both could then come back. So they're to stay away from social media, news media. They certainly shouldn't be watching us right now, but they are on standby and we're told to sort of stay near the courthouse. But again, Reminder that a jury pool is made up of residents of the county, in this case, St. Croix County, Wisconsin. With that, let's take a look at the charges Nicolae Miu is facing, as these jurors have a whole lot of work. The state in the last 24 hours have added what we now know referred to as lesser included, lesser crimes that are made up by the highest counts. So for the death, the deadly stabbing of Isaac Shuman, they now can choose between first-degree intentional homicide, second-degree intentional homicide, meaning an intentional act that Nicolae Miu meant to kill. Important to remember here, they convict on that top count of first-degree intentional homicide. It is a Class A felony in Wisconsin. With it would come life imprisonment for Nicolae Miu. And then the two lesser counts of murder, first-degree reckless homicide, second-degree reckless homicide, being the bottom count, but more of a reckless, that the combination of behaviors and actions in the river that day subsequently led to Isaac Shuman's death. Then we go to those who survived their stab wounds: A.J. Martin, Riley Madison, Anthony Carlson, Dante Carlson. There are 4 counts for each of these so-called victims. First-degree attempted homicide, that was the top count coming in to this trial. Then second degree was added overnight, as were the 2 recklessly endangering safety counts. And then today, for the first time, we have gotten word and want to make sure the viewers know that there is 1 count. Nicolae Miu is facing 1 count of battery for Madison Cohen. Remember, Madison Cohen is the quote-unquote blonde woman that gets in Nicolae Miu's face. The state is alleging that Miu hit her, struck her, physically hurt her in the river. Remember, that altercation would then lead to an intensifying physical confrontation between the tubers and Nicolae Miu. So Miu is facing 1 count of battery for battering, allegedly, Madison Cohen. The jury must decide if, in fact, that is the case. I will point out as we come back on camera here, Madison Cohen had testified last week at trial. And you may remember the judge shut off our cameras at that time, and he explained at the time that as a potential victim of a crime, she has the ability to opt out of being shown on camera in a Wisconsin courtroom. Remember, Wisconsin camera courtroom rules are looser, are more, they allow for the cameras to be played, to be displayed, to be used during their trials. Minnesota, while we've gotten our cameras into some high-profile case over the last few years during the pandemic era, still difficult for cameras to get into a Minnesota courtroom. But of course, in Wisconsin, you can, but victims do have the right to opt out to any television coverage. With that, we've hit the top of the hour. We have not heard from this jury. Again, they asked to watch the Jawan Cockfield cell phone witness videos. They saw those right around 2 o'clock. They recessed the court at 2:15, and we have not heard from them ever since. My sourcing at the courthouse have said loosely that we anticipate this jury would be allowed to deliberate to 4:30, which would be a typical court day in Wisconsin. But if they were close to reaching any type of verdict, they would be allowed to continue. We have not gotten official word to that effect at this point. But what I will tell you is we are monitoring the courtroom feed. My colleague Rob Olson is in the courthouse this afternoon, has eyes on the courtroom. So if anything happens whatsoever in this court and the parties come back in and do any sort of public proceedings, we will take you live when it happens. For now, though, we're going to go back. It is our promise to you, because we know not all of you are watching this second by second, every moment of this trial. So let's go back to another key portion of the trial, the evidence portion of this case. So this unfolded yesterday. This is going to be the interrogation, the jailhouse interrogation. Lieutenant Brandy Hart sitting down with the defendant, Nicolae Miu. He's under arrest. He asks about getting a lawyer, but does not affirmatively say, bring me a lawyer, I want to remain silent. He opens up to Lieutenant Hart over this 56-minute long video recording. We will take you to that now, but again, with the promise, we'll be right back to this courtroom, Judge Michael Waterman's courtroom, should anything at all develop in Hudson.
Hi there, are you Nick?
Yeah.
Hi Nick, my name is Brandy.
Hi.
I'm a lieutenant with the St. Clair County Sheriff's Office, okay? You got some water, right?
Thank you.
Okay. you had anything to eat?
No.
Okay, let me,
I will wait for now.
Okay.
For food.
are you sure?
I'm not hungry.
Okay, well, if you get hungry,
Yeah.
just let these guys know, okay, or let me know when I can,
I was just very, very thirsty.
yeah, I bet. Hope it was a long,
Out on the river drinking beer all day and not drinking any water.
and it's hot, and, yeah, being in the sun all day, doesn't matter if you're drinking beer. Sometimes just, and then this, yeah. So I would imagine that you have some questions for me.
Well.
I am just gonna go through the rights form and, you know, let you know if you wanna answer any of my questions, we'll talk about that. I'm gonna record our conversation if you're okay with that.
Of course.
Let's see, today is the 30th of July, and it is 7:53 p.m. How do you spell your first name?
Nicolae.
Okay.
Last
And
name, no middle name.
no middle name, okay.
No.
And what's your last name?
Miu.
How do you spell, or how do you pronounce that?
Miu.
Okay. And what's your birthday? Do you like to be called Nicolae or Nick, or
Nick.
what? Nick, okay.
Yeah.
December
11th, 1969.
Okay, so that makes you
52.
52, thank you. What's your address, Nick?
5945 Hidden Oaks Circle, Southeast.
Holy cats, that's a multiple.
It's a long one, yeah.
Hidden Oak Circle. I don't even know if I have enough space in this thing.
You do.
Southeast? Oh, southeast, thank you for correcting
No
me.
problem.
And that's
Prior Lake.
Prior Lake, okay. What's the zip code in Prior Lake?
55372.
Okay, and how about a phone number for you, Nick?
612-735-6317.
6317, and I understand you're married to Sandy,
Yeah.
right? Okay.
Is she okay?
She is, yeah. I did talk to her. I talked to her for quite a while. I brought her to get dry clothes.
Where is she?
She is with Ernesto and Amy.
Okay, good.
They're taking good care of her. And then,
Titi, my puppy.
she's headed home to take care of the dog. And she's also with, Ariel and, who's his girlfriend?
Oh, God, I don't even know.
Is it Tatiana?
No, Tatiana. Tatiana is another girl.
Okay.
But she's not.
Hold on,
with
they gave
Ariel.
me,
Yes,
oh, Sandy didn't know Ariel's girlfriend's name.
neither do I.
Okay. But Ernesto and Amy
They,
came to where I was with Sandy, and they went and got the car, but I had brought Sandy to the car to
she
get
was
changed.
driving, right?
No, she was with me. I brought her from the river to the car so she could get clothes, and we brought the cooler back and put that in the car. So she's got all the stuff.
All right.
Are you working anywhere now?
Mm-hmm.
Okay, where do you work?
I work at Reach Engineering as a mechanical engineer.
And what kind of engineering? What was that?
Mechanical engineer.
Yeah, what's the name of your employer?
Oh, Richie,
R-I,
TCHIE, engineering in Blooming. 55427, I think it is.
okay. What was the last grade that you completed?
I have a bachelor's and I have actually 2 degrees, one
Okay.
in engineering, one in mathematics.
Wow.
And I'm a class away from a master's in both. I'm not a dummy, and I've never had a run with the law except when I got the, we'll go into that.
So where did you get your degrees from, your undergraduate
South
degrees?
Dakota State University.
Okay. The Bison?
No, the Jackrabbit.
Okay.
In Brookings.
And how about your master's degree? Where are you working on that?
I'm not working on it yet.
Okay,
Yeah, I did pass the EIT so that I could work
gotcha.
for the state as a licensed engineer, but I haven't had a chance to do that. For many years, I worked as a contracting engineer. And then for the past 16 years, I've been working with Richie Engineering, where I met Sandy.
Okay. What does Richie Engineering do? Like, what do they manufacture?
What do? We do HVAC service equipment.
Okay.
basically we're the top tier of HVAC. We're like the top brand. And top brand for that is Yellow Jacket.
Okay. And is that for the parts?
The brand of yeah. Everything we make there, we make it under the Yellow Jacket brand.
Got it.
But the company name is Richie Engineering.
Okay.
So what I do everything from hoses, recovery machines, all the electronics. I talk to customers. I get business. I do the documentation, the design. It's a small company, so I like to do everything. Testing, evaluation, you name it. And
wow.
16 years over there, and that's not even scratching the surface.
Really?
I have bigger dreams now,
yeah.
shattered, but anyway, I don't want to talk about them right now.
Okay.
I don't know exactly what happened. I just don't. I can't talk about it. I need to go one step at a time.
Yep. And if you have any questions along the way, Nick, just stop and ask me, okay? Or if you need to take a break, just.
How bad is it?
Well, can we get through this form and ask each other questions?
Yes.
I want to maintain the integrity of this investigation and your rights, and so I want to get through this form and then we can ask questions, okay? So I'm going to turn this around. I'll give you this pen. What I'll have you do is I'm going to read each. You seem to speak excellent English.
Yeah.
You can read.
Yeah, Miranda rights, which have not been read to me when I was put in the car. Is that right?
And that's okay, as long as they weren't asking you any questions, they don't need to.
Oh,
but I'd like to ask these questions, so that's why we're going to go through this right now, okay? So I'll let you have that pen, and so I'm going to read these to you, okay? You have the right to remain silent.
Or just
you can check mark it, or some people put their initials. We'll have you sign it at the bottom, so that's however you want to do that. Anything you say can be used against you in court or other proceedings. You have the right to consult an attorney before making any statement or answering any question, and you may have him or her present with you during questioning. And also, stop me, I talk kind of fast.
Yeah, I was going to ask you about this one.
Okay.
So,
yep.
When do I see one? When do I get one assigned to me?
You would get one assigned to you, the soonest would be on Monday.
Oh.
So that would be the soonest. And
working hours.
Yeah, pretty much. Is how that works.
Okay.
So if you cannot afford to pay for an attorney, you may be eligible to be represented by an attorney from the office of the state public defender. If you desire an attorney from that office, you should contact their local office.
And that information would be provided to me, or?
Yes. So what happens is the jail provides that information every day to the public defender's office. Like, here's who's on the list.
Okay.
So some people come into jail and they either have a lawyer already because of other things, or they know a lawyer, or they're going to find their own. So these guys will let you use the phone if that's
I'll ask Candy to look for me, if that's okay.
Oh, gosh, yeah, absolutely.
Because I'm not going to see you.
Yeah, no, that's fine. If you decide to answer questions now, with or without an attorney, you still have the right to stop the questioning at any time, or stop the questioning for the purpose of consulting an attorney.
Yeah, I'd like to do that at some point.
Okay. You can just check mark that. We went over that. However, you may waive the right to remain silent, and you may answer questions now without an attorney. You can just check mark that I read that to you. You're not agreeing to anything right now. This is just that I stated these things to you. So this says the above rights have been read to me. I have initialed each paragraph, or in your case, check mark, to show that I understand each of my rights. I have received a copy of this form. So you sign it, and then I'm going to sign it, Nick, and then I'm going to give you a copy of it. All right, I'll sign it here. And at 8:01. All right. Okay.
Military time.
Sorry, do you want me to write it regular? Okay.
No.
I get so caught up and used to that.
Yeah.
My friends don't like it because in my vehicle, my own vehicle that I drive, it's military time, and so they're always asking me what
Everything
time.
I have is military because I came from Europe. And
Oh, sure.
everything
Yeah,
is they call it military, but it's not military. It's
Right, it's
the proper time.
exactly. Well, good, at least then you know what it means then when I put the time on there like that. So I would like to ask you questions about your day today, what happened, like how you guys got to be on the Apple River today, and then like what your day was like. It's up to you if you're willing to answer questions. If you decide that, yep, I'll answer questions right now, and in 10 minutes, you don't want to answer anymore, you just need to tell me that, okay? And if you don't want to answer questions right now, then that's fine too, and I will leave. It's up to you.
All I can say, it was self-defense. Self-defense, there were lots of people on it that came on to me. Self-defense, and they produced 2 weapons, one I took from them.
Okay.
That's the only thing I can tell. And they hit me, and they were on top of me, and I don't remember anything after that. I just remember I ran away. I ran away to my group. There were actually people coming over from my group to see what was going on. I said, nothing, just get back on. And they kept asking, and I said, nothing. I didn't explain to them anything because I was so fearful. I didn't know what these people were doing to us. I've never been in a situation like this where people produce weapons on, and they were saying they were calling. I don't remember, but they said, don't run away, don't run from us, don't do this, you're a child molester, you're this. Again, I said, are you people drunk? Or you're a child molester. I said, the only thing I remember is, in my mind is, if I'm a child molester, should you be drinking? Should you be drinking alcohol and doing what you're doing to people that you don't even know, attacking them? And I said, if I'm a child molester, you should be having alcohol, And they took I was snorkeling, so they took my snorkel away. They threw it in the water. They grabbed my pants. One wanted to pull my pants down, and I grabbed onto him. And I don't know who that kid was, but he had a knife on him. And then there was another knife, a longer knife, looked like a kitchen knife. Kitchen or something, I don't know. And I don't know what happened to either one of them. I just know that when the kid attacked me, I took that from him.
The kitchen knife or the other
No,
knife?
the smaller knife.
Okay, what did that knife look like? Do you remember?
I don't even remember.
But it was smaller?
Smaller, yes.
Okay.
So, that's all.
How did you get to be by them? Or who are these people?
So, Ariel lost his phone.
Okay.
The phone was in the floor.
One of those bags? that
Yeah.
they gave you? Okay.
And everyone had one, but his phone was in the floater, so he says, well, let's go look for it. So I put my snorkel on, and I looked, and these guys found something, and they were talking about it, and I said, okay.
This group of people?
This group of people,
gotcha.
yeah. I went over and I said, did you guys find the phone? And if you did, can I see it? Can I identify it? And they started calling me names. They got off of their tubes. They came at me. I said, all I need. And they were calling me all kinds of names, insulting me for being in the water with a snorkel. And I said, all I want, guys, did you find the phone? And I saw they had found something, all right? And I don't know if there was a phone or something else they found, but they wouldn't talk to me about what they found. And we were looking desperately to find this phone. And I know somebody found it, but I thought it was that group.
Okay.
And then they went over, they came to me and they grabbed my snorkel and they threw it in the water. Well, the water was so fast, it went under. So I went out after it and they started, another group of mostly girls came over from the other side, yelling at me or calling me child molester and something with, something like that. And I went back. I actually, after this incident, I don't even know what happened. I just know that they attacked me and I was in self-defense. I went into self-defense mode and then I went over to my group of people. That was it. And they asked me what happened and I wouldn't tell them. I said, I can't tell you. Let me calm down.
Okay.
I was shocked. So nobody on that knew exactly what happened. The only thing they said was, look, somebody got in an argument over there. Like, yep, let's just leave that alone. Don't go there.
Are you able to draw for me, like, where you were looking for the phone, like, and where was Ernesto and Sandy, and where was this group? Maybe it helped me kind of understand. Yep.
These guys were here. I don't know how many. There were quite a few.
Okay.
We were upriver about 100 feet. Our group was here.
So you guys were in the water? Okay.
So we were in the water. And then there was another group of people over here that came to attack me. So there was this group of people here, this group of people that attacked me. They attacked me here.
So your group was floating down the river like this?
Actually, we're stopped. But yes, this is the
That's the direction you were going. Okay. So your group is stopped.
Yeah.
And who's looking for the phone besides you? Like, how do you know the phone is missing?
Oh, yeah, we talked about it.
Oh, okay.
I lost my phone. And so, well, you didn't lose it. It's floating down the
Because it's
river.
in that bag.
Yeah, so let's go find it, you know. And he was over here pouting that he lost his phone, and I said, that's okay, I have my snorkeling gear. And then I heard this guy said that he found something. And when I was snorkeling down, I passed him. I kept looking, and then I came up, I kept looking, and then they started yelling and screaming, and I said, did you guys find something? And I thought they did. And I know they did, because they were hiding something from me. And then I went over there and they grabbed my snorkel, they threw it down. They got off their tubes. They came after me, they pushed me. One of them hit me, and then there was a girl that came from here and hit me in the back of my head. And I was about right there.
You said right here?
When she hit me, yeah.
And that's when the female hit you?
Hey guys, so take a break from this for a moment. I made the effort to look up the sentencing for Wisconsin on these various counts. So pretty much everything will be an effective life sentence if he's convicted of any of the felonies. So count one, that's the fatality, Isaac Shuman. This defendant's charged with first-degree homicide, which is a Class A felony. That's a minimum of life imprisonment. So just life in prison. He's also charged as a lesser included with second-degree intentional homicide. Second degree, that's a Class B felony. That's still good for up to 60 years. By the way, don't expect the judge to cut this defendant any slack. If he's convicted, that means it wasn't self-defense. If it wasn't self-defense, it was just heinous, violent acts against young people. So I would expect this judge to sentence him to the max if he's not acquitted on self-defense. Then the counts for the other four people that he stabbed but did not kill, counts 2, 3, 4, 5. That's the stabbing of Dante Carlson, Tony Carlson, A.J. Martin, Riley Madison. For each of those, he's charged with a count of first-degree reckless homicide. That's a Class B felony. Again, good for up to 60 years. And as a lesser included second-degree reckless homicide, Class D felony, good for up to 20 years. And again, I would expect him to get the max. Now, if self-defense does not apply, if he's not acquitted in self-defense, he's effectively guilty of all of these crimes. Normally, he'd be sentenced concurrently. Not that it matters. I mean, you get a life sentence. Who cares? Of course, it's possible that he's convicted of some and acquitted of others, depending slightly different circumstances for each stabbing. It's possible under Wisconsin law, the judge has the discretion to sentence him consecutively. So stacking the sentences and aggravating factors that would apply that could justify in the judge's mind consecutive sentencing as opposed to concurrent or parallel sentencing is use of a weapon and multiple victims. Both of them might be compelling arguments for consecutive sentencing. Then we have count 6, which is Madison Cohen, the Apple River Queen. There's a charge of battery based on the claim that the defendant punched her in an unlawful manner. That's a Class A misdemeanor. It's good for 9 months in jail, where he's already been sitting for 21 months. So presumably he'd get time served for that and wouldn't do any further time. And finally, there's the weapons enhancement, which is part of the jury instructions. That's another statute. Because he used a weapon, if he's convicted of any of the felonies, he should expect to get an additional 5 years. So there were life, there was 60 years and 25 years. Life, again, it hardly matters. 60 years would become 65 years. 25 years for the Class D felony would become 30 years. Again, it hardly matters. It's effectively a life sentence. For the misdemeanor, well, he didn't use a weapon for the misdemeanor, so I guess it doesn't matter. That was just a punch. But had it applied to the misdemeanor, it would have added 6 months to that sentence. So there we go. Just a little change of pace. With that out of the way, let me take a quick look and see if there's comments that need to be addressed. Let's see. Where's my little... Here it is. Look through the comments. By the way, did you notice during this interrogation where he's telling all these lies to Brandy Hart, the 25-year police officer, detective, he asks about a lawyer, right? When can I get a lawyer? But he doesn't assert his right to counsel unequivocally. So she just gets to chat with him. If you want to assert your rights, folks, they have to be unequivocal. Assert your right to silence, assert your right to counsel unequivocally. I'm asserting my right to silence. I'm asserting my right to counsel. Period. Otherwise, it doesn't count. Also, there's never any good reason for you to be speaking with an investigator, especially once you've been Mirandized. Either of those, much less the combination, is a big red flag that you should interpret as meaning, I assert my right to silence, I assert my right to counsel, period. Did the jury go home? I don't know. I've got the feed here. How do you know the jury's going home? Can't get anything from the Fox 9 comments. They're crazy. Let's see. No, reckless homicide doesn't make sense to me. He obviously stabbed everybody intentionally, not recklessly. It's almost a weird angle on imperfect self-defense. So imperfect self-defense would be when you have all the elements of self-defense except your perception of the need to act in self-defense was objectively unreasonable. It was irrational. Maybe it was reckless. And that would mitigate murder down to manslaughter. So basically when they're saying reckless, they're making a very similar argument that he stabbed them intentionally, but his perception of the need to stab them was, I'm not sure exactly what they're getting to. It doesn't really make sense to me as a criminal charge here, except as a potential for a compromise verdict and a 60-year plus 5-year weapons enhancement sentence instead of a life sentence. Yeah, again, people are misunderstanding the relevance of all the lying. I mean, the lying to the police is not good, but it really would only matter if it went to a material fact in the case. If there were no video and we had to rely on his credibility for self-defense, yeah, this would be completely destructive because you'd feel like you couldn't believe a word the guy said. But we don't need to rely on his credibility because we have the video, and his lies to the police don't change anything about the video. We need lawyer alert bracelets. Like a medical alert bracelet. Says, I invoke all my rights. Demand an attorney. By the way, when people say don't talk to the police without your lawyer present, I would encourage you not to talk to the police even with your lawyer present. Let your lawyer do the talking. Let's see. Yeah, self-defense is a legal defense, is a defense of confession and avoidance. You're confessing not to a crime, but to the underlying conduct that forms the elements of the crime. You're not saying I didn't stab that person. You're saying I did stab him. But I did it with the legal justification of self-defense. So confessing to the underlying conduct, and avoiding legal liability through the legal defense of self-defense. But if you lose the self-defense part of that, all that's left is a confession, effectively. Oh, all right, let me see. Here we go. Got it.
Again, the exact wording is, can we see the Cockfield video tomorrow morning from 10 seconds before the confrontation with Maddie Cohen to 2:27 seconds, signed by the foreperson. Comments, Mr. Anderson?
No objection. No objection.
All right, since there's no objection, we will plan for that. As soon as the jury arrives, we'll assemble in the courtroom. I'd like to have the video connected and ready to go, and then we'll follow the same procedure as we did earlier today. No comments, no commentary, no opportunities to persuade or influence the jury. They're simply coming in to view the video, and then they will return to the deliberation room.
Do we agree that it would start then at 1:40?
I don't know what the time would be. They're just asking for 10 seconds before the confrontation with Maddie Cohen. So I'll let the attorneys identify what point in the video that is, and then we'll display that to the jury. Beg your pardon?
Maybe you don't want us to talk about it right now, so I was
Yeah.
going to talk, but.
Yeah, you guys can figure that out, where in the sequence it should start from. Anything else from the defense?
No, Judge.
All right. Have a good night, everyone.
Can I approach?
Yes, we'll see you tomorrow.
So I don't really know what that means.
And good afternoon again, Paul Bloom here in our Fox 9 streaming.
All right, I don't need to hear him. Where's my... I don't really know what that means. This 10 seconds before the Madison Cohen interaction, they described it. Because does that mean before the purported punch or the first contact with Madison Cohen? I don't mean physical contact, but communication contact. Because, and then from there to 227, because I'm going to turn the sound then just so I can find it. So this is the video, the Juwan Cockfield video. And if I scroll forward, we have, there's Madison Cohen coming up now. That's at 1 minute. She's pointing, she's communicating at, well, 1 minute, 1 second. Well, I don't have it shared with you guys. Okay, let me try this again. So at 1 minute, we have our first, I think it's the first sighting of the River Queen. Right there. She's walking up. And she immediately starts pointing downriver. So she's communicating. So I don't mean, no, they mean 10 seconds before this, which would be here.
Yes! Yes! Burn the culture! Burn the culture! Who is that?
So that portion, or they mean from the punch, which is here. So that's that's the punch. There's a River Queen. So that would be from here, 10 seconds before that.
He hit a woman! He hit a woman! You don't hit a woman! He hit a woman! You got him! What the fuck? What the fuck? What the fuck is that?
To 227. Sounds like that's what the jurors want to see in the morning. All right. Good enough, I suppose. Everyone's going home today. I'll take a last look at the Q&A, and then we'll start to wrap things up. But of course, I'm obliged to mention the sponsor of today's Law of Self-Defense show is none other than Law of Self-Defense itself, in the form of our upcoming full-day live class. Our Law of Self-Defense advanced class teaches you everything you need to know to be hard to convict. If you're ever compelled to use force in defense of yourself, your family, your property, taught live by me, streamed to you at your computer Saturday, April 20th. We only teach this class twice a year, folks. So if you miss this one, it'll be at least October before you have an opportunity to take it again. Can you afford to wait? How can you know? You don't choose the time, place, and manner that you're attacked. The bad guy does that. You need this insight information on board before the fight happens. Doesn't help you much to learn it afterwards. If Nicolae Miu had taken this class and done what I suggest, he would not be looking at life in prison right now. If you have a conflict on Saturday, April 20th, can't make the live stream, then I would tell you to sign up anyway, because we're going to make the recorded playback of the class available to all the students for 2 weeks afterwards. So you can watch it at your leisure over that 2-week period, but that only goes out to registered students. Right now, we're still in the early registration period, so you can get 50% off your registration at lawofselfdefense.com/advanced. We cover defense of yourself. We cover defense of others, family, neighbors, colleagues, strangers, like an active shooter type situation. We cover defense of property, all the different levels of property, because different property is privileged for different intensities of defensive force. Highly defensible property like your home, your vehicles, temporary castles like hotel rooms or RVs, personal property, open, unimproved land, pets. Your pets are, I know you're not going to like to hear this, least defensible property. We talk about consciousness of guilt evidence, quite a bit of that in this trial. We talk about self-defense immunity. We spend almost an hour talking about interacting with the police in the aftermath of a use of force event. It's a much more subtle dynamic than I think most people recognize. Just say nothing has drawbacks. So we talk about all of that. We explain how you can develop a customized, legally sound self-defense strategy that allows you to decisively defend yourself, your family, your property, while staying well within the legal boundaries, making yourself hard to convict. Again, all of that and much more at lawofselfdefense.com/advanced. Don't pass it up, folks. You miss this one in a couple weeks, it'll be 6 months at least before we do it again. All right, let me take a look at Q&A. Let's see. They said the jury asked to see the Jawan Cockfield video from 10 seconds before Maddie Cohen to 2:27, 2 minutes and 27 seconds. I don't know what that means in terms of the start, because there's an ongoing interaction with Madison Cohen. But I've showed you the from 10 seconds before the purported, contact, physical contact of the supposed punch, the battery of the defendant against Cohen to 227. It's all the stabbing stuff, really. It's the punching and stabbing stuff. Let's see. Yeah, I think the more times they look at the video, the better it probably is for the defendant. It would be my expectation, especially with the audio on. If they understand the provocation language, that's all favorable for the defendant, if they understand it properly. Because he wins. You can't make too much about the moment when he touches the tubes and potentially their legs, because under the provocation law in Wisconsin and most other states, but particularly, of course, relevant Wisconsin, he recovers his innocence, even if he did lose it by the tube touching. All right, starts again in the morning. I'm going to plan to be streaming at 10 a.m. Eastern time. So 9 a.m. court time, 8 a.m. my time. Yeah, I'm believe it or not, my this respiratory bug is about 5% better every day, but that means it takes a lot of days to get better. Let's see. Looking at the Q&A. I'll also look at the super chat. So if you're on YouTube, in fact, let me refresh the take a look at the poll. Hasn't really changed. YouTube poll, almost 3,000 votes. Holy cow. By the way, if you're watching on YouTube, please click the thumbs up and subscribe. That's always appreciated. Guilty, 18%. Not guilty, 75%. Mistrial, 10% is the basic numbers. So overwhelmingly, people believe not guilty, at least in the Law of Self-Defense YouTube channel, believe not guilty is the appropriate verdict here. Let's see. Paul says, then again, the lawyer for the armor and rust didn't do her any good. Yeah, Hannah Gutierrez. First, she gets interrogated by police the day of the shooting death of Helena Hutchins on the set of Rust for, I forget, an hour and a half or 2 hours or something by two detectives. Then she comes back with a lawyer, gets interrogated again, and her lawyer just sits there like a lump. Doesn't do anything. Just lets her talk and talk and talk. He's looking at his phone. It's crazy. Bad lawyer. So that's why I say, even with your lawyer present, you may not want to be talking. You can tell your lawyer what you feel happened, and your lawyer can communicate that to the prosecution. Will the jury be sequestered? I haven't heard any argument for sequestration of the jury. Let's see. I won't lie, I'm a little tired. It's been a week and a half of long days. Cycle Boy says he bets on mistrial, that someone is going to be stubborn. You know, they're usually not, though. Usually they get worn down. But of course, we have all these compromise verdicts here in terms of these reckless killing charges, reckless homicide charges. So they have plenty of spots where they can compromise and still put this guy away for the rest of his life. Inappropriately, I think. All right, let me take a look at the super chats. Super chats. Needs to be $10 if you're on YouTube to get your questions answered. And it looks like I've answered all the super chats. All right, folks. So I'm going to wrap up the day. I look forward to seeing all of you at 10 a.m. Eastern tomorrow. If you're on our email list, you'll get an email about that. I'll put a little post up on Twitter and I'll prep the, try to remember, I forgot this morning, but try to remember to prep the member live stream with some new copy. So it's obvious we have a new show going. And I'll probably just continue to use that same live feed we used today where they're playing other witnesses. And we'll just, follow along with what they're doing, as long as it doesn't get too annoying, and see how long it takes this jury to return a verdict, hopefully on the law and evidence, a meritorious verdict of not guilty on the grounds of lawful self-defense. But who knows? As I always caution, juries are dangerous and unpredictable creatures, which is why I don't predict verdicts. With that out of the way, I just remind all of you, if you carry a gun, so you're hard to kill. If you carry a knife, like Nicolae Miu, so you're hard to kill. By the way, see how much damage that little folding knife did? Right? That's pretty impressive. If you carry pepper spray, so you're hard to kill. If you study jujitsu, so you're hard to kill. I do all those things, all of them. I carry a gun, a knife, pepper spray, and study jujitsu. So I'm hard to kill, so my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. Until tomorrow morning, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.